Good morning. Good morning, Telegang. Good morning, good morning, good morning. While we edit, I'm going ahead and do my I'm gonna do my TikTok. I'm gonna do my TikTok live too, just so we can have it. All right, y'all. So good morning, good morning, good morning, good morning, good morning, everybody. Happy Friday, y'all. We done made it to the week. It is December the 20th. We got 5 days into Christmas. We got 5 days into Christmas, and I need to know, what did y'all get yourself for Christmas this year? Do you celebrate Christmas? Do you celebrate Hanukkah? Do you Kwanzaa? What do you celebrate? Do you celebrate? Do you celebrate? Or are you one of those people that just, don't celebrate? Either way it goes, it's still the happiest time of year, in my opinion. Good morning, TikTok. Good morning. So I want to know if y'all celebrate, what y'all celebrate, and if you celebrate Christmas, did you buy yourself something this year? Hey, we just having a quick live session. Quick live session before we jump back into our trial watch. Our trial watch. Thank you, Brown Sugar. Thank you, Brown Sugar. All right, well, I see people are celebrating Christmas. Okay, so y'all, for Christmas this year, I decided that I was gonna apply to law schools, and I did. I did receive one rejection letter, but it was also from the school that I didn't really want to go to anyway. So, you know, just more to confirmation for me to say that, the things that I don't align with will not come to fruition. They will not come into my reality. So it's completely, now that I'm over like my first rejection letter, I'm looking forward to my next acceptance letter. So that's what I did for myself for Christmas. So I just share this story with you just to say that, it's Friday, December 20th. And I really hope that, you and your family have a good holiday season. Tomorrow we got our Christmas holiday party, our family party that we're gonna be doing. We have a pajama party that we do every year. And it's gonna be tomorrow. So I'm excited. Me and my mom, we're going together and we're gonna be dressed like Rudolph. We're gonna be dressed like Rudolph. So I will be sharing content with y'all over on my TikTok likely. Over on my TikTok likely. Um about our Christmas party. So make sure that y'all tap in with me on that. Good morning, everybody. So y'all know we are still watching the YNW Melly trial. We are on day 4, and Mariah, which is Melly's girlfriend, the mother is on the stand. The mother is on the stand. And I just remembered that my people wanted me to do a recap because there were some people who didn't watch the YNW Melly trial, like I didn't watch it, and they wanted to come in and join us today. So I promised that I would do a recap, and I am, now that I remember that I promised that. So I will give thank you. Thank you. I will give a recap. I'll do a recap. I'll get it up. But honestly, I don't think anybody has missed anything. What we know about this trial is that Javelle Dimmons, aka YNW Melly, is basically accused of unaliving 2 of his friends after leaving a studio session. All right. The state is alleging that after the session, while within the car, thank you, Tina Bina. After the session, while within the car, YNW Melly shot the 2 guys who were sitting in the front passenger seat and the back passenger seat, while he sat behind the driver in the back passenger seat. Afterwards, it is alleged that he staged a drive-by and got out of the car and was picked up by another individual. It is then said that he took the person who was driving the car, which is his co-defendant, Cortland Henry, who we call Bortland, that's his name. Bortland drove them to a hospital where he, then was met with police officers and, gave a story. And so the state is basically trying to prove that YNW Melly is responsible for these crimes. So again, if you want to jump in with us, come on. They are saying that Melly actually FaceTimed his girlfriend. And the mother of the girlfriend is allegedly a witness of this FaceTime call. And that is where we are at in the trial. All right. Because I know my people, like I said, they wanted a recap. I will make a video of it though. I'll give y'all my 1 minute recap my way and I'll post it as well. But we are going to get into our trial watch. So if you are on TikTok right now, come on over to my YouTube channel. All you need to do is go to my profile, click YouTube, and it'll bring you right over here. Or you can go over to YouTube and type in Taylor Unbridge, and it'll pull up my channel. But we're going to pick back up where we left off on yesterday. Yeah. Good morning, everybody. Good morning, everybody. Good morning, everybody. Okay, I'm in such a good mood today. It's not even funny. All right, so here we go.
We might take on here. Sorry for the delay. What time? Let's say 1:30. Thank you.
To 90.8035, the state would move at this time to read into the record the relevant portions.
Objection. Can I see, please?
Yes, sir.
It's 12 o'clock. Let's take our lunch and recess. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case. Certainly no recess, all right? Please take on your chair. Sorry for the delay. What's that? Let's say 1:30. Thank you.
For that, as well as the initial part. Old number was question, no, cause, answer. Her old number was 877-9609-321. Question, no. See, I have his phone records and he never called it. There was never answer. You have the 772-713-9807. Question, 9807. Answer, I don't know whose phone that he called and FaceTimed with. I talked to him on FaceTime.
So, assuming that I let this portion in, is this going to be a reoccurring theme? That what else are you going to ask her about?
In terms of that, as well as the initial part where she said she doesn't recall what he said verbatim. That would be the part where he's saying that someone just shot the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's a car coming behind him, like hiding. He was like, there's some, there's some, I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Zach and Juby? And he said, I don't know if they're in the car. I think they're dead.
And that's the portion that you're looking to have admitted?
So far, based on her current state of her testimony up to this point.
Is there anything else?
If there's anything else that she doesn't remember on that, for example, the Frito bang or Frederick Gibbons is his actual name, aspects of that, anything about the condo in Miami, about the blood on the clothes. There's another part later on where she then describes the conversation again that he said. He just basically said that his friend just got killed, and that he was like, there was lights coming, somebody's coming, someone's coming. I'm like, are they still out there? Question, answer. It's like I don't know. And I said, we're on our way. Just stay put. We'll come get you. So at this time, I'm thinking he's somewhere hiding in the bushes somewhere from whoever shot him.
And the statement goes on. There's other things that you're trying to get out through this witness that you're concerned that she may or may not remember.
Those are the relevant portions, Your Honor. There's a lot of other things that she indicates in the statement that I would agree would not be relevant, and that wouldn't prove an essential fact that is at issue in this case. So I would not be seeking to insert the entire statement.
Basically, the portions that you just elicited.
Yes, sure. And I have the ability to, in a Word document, to isolate those so that they can be succinctly read, provided to defense as well, so they would have copies. But the case law is clear and the statute is clear. The state cannot introduce that statement, but defense would be able to if they so chose.
Thank you. And your objection is?
Your Honor, we have a copy of her deposition, which makes clear.
Can I stop you for a second?
I'm sorry.
What is counsel reading from that? What are you reading from that?
I am reading from her statement of December 12th of 2018.
You're reading from a statement, not a deposition.
Correct.
Thank you. I'm sorry. Go ahead.
Thank you. And before I go any further, Your Honor, I meant no disrespect. And I appreciate your and understand your authority and you were making decisions. Whatever reaction I had was not intended to convey disrespect, but I agree with your decision, sir. Her deposition of December 14, 2022 will clarify the issue of whether this is a failure of recollection that the state is trying to refresh, or whether or not this witness has recanted her statement and is making an entirely different statement about the facts of that night. In this deposition, she is not claiming not to recall. She said she wasn't certain about the time of the call, but she quickly got herself together and came down here, and it took about 3 to 4 hours, like she said, and she got here around 12 or 1 o'clock, which would place that call at 8 or 9 o'clock. There are several other substantive statements that indicate that she is recanting that statement she gave on that day. She says the reason that she gave the statement was because her daughter was threatened with arrest, like she said here. She said that she feels threatened, and the first thing she said there, she's not talking about Jamel, she's talking about the state. She's on an ankle bracelet. They arrested her in the Virgin Islands and brought her over here. And the statements she's making in her deposition do not support and I wouldn't say they contradict, but they're not the statements that are made in the statement that the state seeks to elicit. If the rules allowed her to put a witness on just to get in a prior statement, then they'd be in okay territory. The rules don't permit that. She's creating this pretext. Oh, you forgot that? Well, let me read it into the record. I would offer the court a copy of this deposition over lunch to review. That makes it clear that she is recanting. She is not forgetting. She is recanting. And that's exactly what these cases speak to. And the process that the state is, what they're attempting to engage in is to violate and circumvent the rule and omit out-of-court statements for the truth of the matter asserted, which are hearsay, which are recognized to create constitutional problems, which have resulted in some of these cases in murder cases being reversed, murder convictions being reversed. And she's inviting error into this court, into this trial. And we'd ask the court to at least get a context of what is going on here, whether this is a failure of recollection, whether that's the way she's fashioning it, or whether or not what she said in her deposition does not comport with what she said in that statement that she's recanting, but the state is just using this rule as a pretext to get the state accepted.
Thank you. You have the statement of Ms. Holmes as well?
I do, Your
And
Honor.
I'm taken under oath.
It was, yes, it's a sworn statement from Ms. Oath, from Ms. Holmes in December of 2018. And Your Honor, I would also add that some of the timeframe and issues of that, those were actually clarified because the defense provided the state with reciprocal discovery of Ms. Janie King's phone records, which authenticate the statements. For example, that Felicia Holmes said she immediately called Janie King. That is shown in Ms. King's phone records.
Who's Jamie King?
The defendant's mother. So there's outside sources that corroborate the sum and substance of her December 2018 statement.
All right, so I'm going to take the statement. If there's no objection, I'll take the statement and the deposition. I'll read those over lunch, and then see everybody back here at 1:15. I told the jury to be back at 1:30. We'll resolve those issues, and we'll move forward. All right?
Thank you.
Thank you.
I think that was a fair.
The case law is clear that that is something the state can do under these circumstances. It's in the interest of justice rather than to have a witness who, for various reasons, is now professing a lack of memory to to then be prohibited from introducing substantive evidence in the case.
So you're calling a witness that has testified that the witness doesn't recall, and you're suggesting that, I take it that she's feigning a lack of memory?
On some of them, I think exactly that she doesn't have a verbatim recollection of what was said. I think if she said that she did, that would be suspect. I think so in terms of having a better memory back in 2018, 2 months after the incident or less than that, that is valid, and that she said she was truthful with law enforcement at that time. The state has met the admissibility threshold on that particular issue.
Thank you. And what says the defense?
Your Honor, I think the state undercuts its argument by admitting what she perceives to be the case, which is that concerning the gravamen of what she's trying to introduce, she believes that the witness is feigning a lack of recollection. In other words, she is recanting. So this is not, and what's important to realize is this is not about determining whether we have a witness who is being honest or not. I think this rule contemplates a witness who may be being dishonest by recanting. And the issue is not whether or not the witness is being dishonest, and in the interest of justice, we want to put in what we believe to be a more honest statement. The question is whether or not you're putting up a witness to impeach them, putting up a witness to introduce a statement previously made from which that witness has receded, or which that witness has recanted, which is what's going on here. And the rule is clear on that. Can't do it. It's hearsay, and it should not be permitted. Any issue with respect to whether or not the statement is sworn or not, I think sworn statements typically contemplate an adversary having the ability to test credibility at the time it's made. Furthermore, this witness, when asked by the state, did you give an honest statement to law enforcement back in 2018? She's like, I don't know that I did. She posited the possibility that she could have been lying then, which further undercuts the indicia of reliability. She also said she felt threatened then because she was speaking, given that she was advised that her, and I think advised in bad faith, that her daughter might be charged as an accessory after the fact, when there was no evidence to suggest that. And she said she was acting then under threat, and that she's not certain whether she was being honest then. So for the state now to say, hey, she's having a failure of recollection, so we just want to read her prior statement into the record, is a pretext. And it runs in violation of the law in the state of Florida as explicitly outlined in the cases we cited and numerous other cases. So that's why we object.
Thank you. So, counsel, I've looked at a couple of cases that came across. First is 880, 72nd 561, Pierce v. State, Supreme Court of Florida. And the second, 993, 72nd 1108, 4 PCA case, SL versus State. And in the first case, the Pierce case, that was an issue whereby during cross-examination of the state witness, defense counsel had asked whether or not the witness had previously told detectives and that he made a statement and expressed surprise at some piece of evidence. And the state, his response was he didn't recall, don't remember anything along those lines. And the end result was that the Supreme Court said in order to resolve this claim, I'm reading from the 8th page of the opinion, it said in order to resolve this claim, you must examine the law relating to the admissibility of prior inconsistent statements. Prior inconsistent statements are not hearsay and can be admitted as substantive evidence. And quotes, if the declarant testifies at trial or hearing and is subject to cross-examination concerning the statement, and the statement is inconsistent with the declarant's testimony and was given under oath subject to the penalty of perjury at a trial, hearing, or other proceeding or in a deposition. Then it goes on, says this court has held that a statement given under oath during police investigation is not a statement given at an other proceeding and consequently is not admissible as substantive evidence. Second case I have is SL v. State, as I said, 99372nd 1108, and that's a little more succinct. And at the second page of the opinion, it says, in order to resolve this appeal, we must determine whether the statement made by SL's mother to the deputy were admissible as substantive evidence. The Florida rules of evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at trial, hearing, or other proceeding or in a deposition. It goes on and says, interpreting this provision, the Florida Supreme Court recognized that a statement given during police investigation is not a statement given at an other proceeding, end quote. Doesn't appear to me that that statement is admissible as substantive evidence, counsel. So what the end result of all of this is, if you ask the witness denies remembering the statement and you want to read it to him, I don't see how a curative instruction telling the jury it's only for impeachment purposes and not as substantive evidence is going to resolve it. So my vote would be just keep it out. So I sustain the objection.
So just so it's clear, it is not a prior inconsistent statement. So the line of case law that you cited would not be applicable. It's a past recollection reported, which is a very specific subset. So first, Earhart, on that specific issue, maybe 803 sub 5.
Excuse me one second. Could you get rid of it? I left it on my desk.
So the state is arguing that it is a past recollection reported versus a prior inconsistent statement. Now, I don't know what the two differences are, but clearly there is a difference between the two. If they're admitting it as a prior inconsistent statement, the judge is basically stating the objection that it should stay out. So I'm curious to know or to hear his explanation or his input on a previous recorded statement. That's interesting. I'm sorry, a recollection recorded, a previous recollection recorded.
I'm sorry, counsel, what section are you talking about?
9803.
Error.
Yes, so section 5, 98035, which in the 2022 edition starts on page 1104.
So again, the judge is reading the case law that was provided for a past recollection recorded. That is the state's argument. And I'm really interested because I want to hear how this is really different from a prior and inconsistent statement. So I'm trying to like not let us miss it, so keep us in a good spot, a good spot. I'm trying to get it started. Yeah, I'm sorry.
Anything else you wish to share with me, Counsel?
Yeah.
How about from the defense? Anything else?
A commentary on the case that was provided.
Yep.
Okay. The polite case, the very first head note, says that the admission of past recollection recorded under exception to the hearsay rule requires the witness to indicate that the statement was made at the time when the events were fresh in her mind, his or her mind.
That's done.
And also attest to the accuracy of the memorandum or record. The opposite of that.
Excuse me, and that's in the bottom as well, that you're reading the head note.
Yes.
I just highlighted the portion at the end. It says, we reject the Fifth District's embrace of a totality of circumstances test and firm that in Florida, the admission of past recollection recorded under section 98.803 subsection 5 requires that the witness indicate that the statement was made at the time when the events were fresh in his or her mind, and also attest to the accuracy of the memorandum or record. Then goes on in conclusion. In this case, a proper foundation for admission of the witness' statement of past recollection recorded was not established. As we've explained above, the hearsay statement was inadmissible because the witness did not vouch for its accuracy or correctness.
Absolutely perfect.
Now, so my thought is this: if what I heard her say previously was that she couldn't vouch for its accuracy or something to that effect, if that's what she continues with, I'm not going to allow you to admit the evidence. All right.
Understood.
So, are you ready to proceed?
Yes.
All right. Let's bring the jury. You ready as well? Yes, you ready as well?
Yes.
All right. Bring the jury in. Bring the witness in. Bring the jury in.
Grab the witness.
Three exceptions, y'all. And one of them is the rule for past recollection recorded. That's what we just went through. So the fact that she's saying that she doesn't know if her past statements was accurate basically just goes against what that rule stands for. So if she continues to say that on the stand, then he's basically not going to allow them to continue on with the line of questioning. Okay, y'all, this is good.
I'll be like, can you go sidebar briefly?
Yep. Jerry, answer it. Ladies and gentlemen, thank you. Please be seated. For the record, reflecting the presence of defendants and counsel, the state attorneys, ladies and gentlemen, jury, our witnesses. Bishop Holmes remains on the stand. Ladies and gentlemen, I apologize for the delay. It's my fault. In any event, I think we're ready to proceed now. Ms. Holmes, I just remind you, you're under oath. Correct. Thank you. Proceed, counsel.
Okay, so I'm going to talk a little bit about your deposition.
Yes.
Do you recall when you've been provided a copy of that deposition?
Yes, I got, my lawyer got provided a copy.
When you, in that deposition, were you asked if your prior
Objection.
statement?
Improper impeachment.
I heard it over. You can ask your question, counsel.
Ms. Holmes, prior to that deposition starting, were you given your prior statement to review?
Which you mean?
Were
I
you,
understand, the deposition that I did on December 22nd? Yes, it was given to my lawyer yesterday, right, for briefly to look at, yes.
so the deposition you have, that was
It was given to my lawyer
provided.
yesterday, yes, it was.
So do you remember coming into that deposition?
Yes, I did, I was in jail, put me in jail.
Correct.
I remember.
And so it's clear, in terms of you don't want to be here.
You're making me be here, yes, I have
Yes.
a house, a band on my leg, I'm a nurse, I can't even work properly, yes.
You were under house arrest because you failed to comply with the subpoena?
No, you're not
Excuse me,
serving.
sustain. Listen, how we're gonna do this is you ask your questions, counsel, and listen to her question, answer her question.
Yes, I am.
All right?
Yes, sir.
So going back to that deposition,
Yes,
on December 14th of 2022,
yes,
do you remember coming to my office?
yes, I do.
Do you remember being asked questions at that time?
Yes, I do.
Do you recall being given a copy of your prior statement of December 12th, 2018?
No, I don't remember that, I don't remember, but I'm pretty sure. I do.
Okay, so what I'm going to do is permission to approach her
With what, counsel?
for deposition.
Objection, Your Honor.
I have to give her an opportunity to.
I saw that.
Excuse me, there's no question pending review. All right, you can proceed, counsel.
So counsel, I'm showing her page 10, line 10 through 17. Okay, so just read them silently to yourself. So back on December 14th, 2022, were you asked if you need to make any corrections or deletions to the statement of December of 2018?
That's what the deposition said, usually.
And did you indicate that there was no corrections or deletions in the statements?
I don't remember, but that's what's on the deposition.
So December of 2022, you said that this is a correct statement.
Objection.
Sustain.
So Ms. Holmes, is the December 2018 statement that you gave correct and honest?
Objection. Ask and answer.
Excuse me. You have to I don't understand you're trying to answer the question, but when they raise objection, let me answer the objection first. All
Yes,
right?
sir.
Objection notice overruled. Question is the statement, repeat your question.
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
In December of 2022,
Yes,
did you state that it was an honest and correct statement?
that's what you put in the deposition. I don't remember saying it, so I can't remember verbatim. I remember some parts of this deposition, but not all.
Okay, is there anything that you need to refresh your recollection to determine whether or not I'm being truthful and accurate as to what the question was in your answer?
I don't know to say that.
Okay.
Is that a question?
And actually, if there's anything that
Excuse
was,
me, one at a time. All right? Just one, let her finish her answer before you ask the next question.
so, Ms. Holmes, is there anything that would help refresh your recollection?
I don't think so. I don't know.
Would the audio of the statement of December 2018 help?
Objection.
What's the objection?
It's irrelevant. She testified 3 times.
Excuse me, thank you. Now as to this, go ahead, overrule.
I don't know. I don't.
So, Ms. Holmes, with regards to the events of October 26th of 2018,
Yes, ma'am.
did you travel down here to Birmingham?
Yes, I did.
Who did you come with?
My daughter and my wife.
Okay, where did you go?
We went to one of Janelle's friend's house.
And whose house is that?
Frida.
And now approaching has been previously shown to defense counsel and marked as stage N for identification purposes only. Ms. Holmes, do you recognize the two individuals in that photograph?
Yes, I do.
How do you recognize them?
I know Frida from being on Instagram from rapping about her.
Okay, any other individual in that photograph?
My daughter's boyfriend.
Okay.
I'm sorry, I apologize, I didn't hear that.
I'm sorry.
I didn't hear your answer. Could you
Which
repeat?
one? Do I recognize?
Thank you.
I do recognize, Frito from Instagram for being a rapper, and I recognize Janelle from dating my daughter.
Your Honor, this time state your request under stage triple N. N is the next number exhibit.
Any objection?
Relevance.
Over, it'll be admitted.
States triple N, Fremont State 62.
This is the photo that you can see on your screen that you just identified? Okay. So when you said Frito, is this the individual's house you went to?
Yeah.
Okay. Ms. Holmes, how much money has the defendant's manager given you since the October of 2018?
Objection. Relevance.
Motion side.
Okay, so I'll ask again. Okay, so I'll ask again. How much money have you gotten from the defendant, Melly, and his manager?
None.
And with regards to that specific statement? Ms. Holmes, you have from a credit union account?
I still launch credit union,
Okay. And at Launch Credit Union, you banked there for a number of years?
many years.
The credit union that you've been at has been your account, and I won't put your account number on the record for that reason.
Your Honor, object to this line of questioning based on the court's ruling.
Objection, it's over. Proceed.
So your testimony is that you have never been given money whatsoever.
I've never been given money for personal use.
Okay. So the question is, how much money have you been given by the defendants?
For vacation for all of us, for him, his wife, and me, to pay for it, as far as, he gave me $5,000 for Airbnb, which I gave him $1,000 to deposit that,
So he did give you money.
not for personal use.
Excuse me, can we clarify who he is,
Objection, Your Honor.
Jameson Francois?
Objection, no, just clarify, counsel.
So it's clear, who is Jameson Francois?
He's trapped, he's Melly's manager.
And you mentioned his wife as well. Who's his wife?
I used to go by AA,
So AA and his wife.
we're all good friends.
So I'm going to go now with the previously shown to defense counsel and mark this stage triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming into court today?
Yes, I did.
Okay, and in terms of the individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I do not.
Okay. Going forward to the contents of that particular item, do you recognize a conversation about a snake?
No, I do not. I know they had a sleep, I don't recognize this conversation.
Okay, with regards to the conversation about the snake that you do remember, what do you remember about the snake?
That they had a sleep.
What happened to it?
Objection. Relevance.
It's sustained.
Aaron, may we approach that?
Sure.
So Ms. Holmes, I want to ask you a question as to what was your daughter's phone number back in October 2018?
I have no idea. I don't know.
Is there anything that would refresh your recollection as to what her phone number was?
No, because I don't remember mine.
You don't even remember your own?
Yeah, no, I don't know.
In terms of, did you review your statement of December 18th of 20, I'm sorry, December 14th of, December 12th of 2018? Did you review that statement prior to testifying today?
I'm trying. Yes, I did.
And in that statement, were you asked, what is your daughter's phone number?
Objection.
Over.
I don't remember.
If I were to show you the statement, would that help refresh your recollection as to whether or not you were asked that question?
I don't think it would, no. But you can show it.
You have permission to approach?
Yes, ma'am.
Okay. 3 of 8. If you could just read silently to your son. Okay, looking at that, does that refresh your recollection as to what your daughter's phone number
I
was?
still don't recognize the number. It doesn't for me, but I don't know if that's her number. I don't recognize the number.
Okay, so you don't recognize the
Yeah,
number.
I have 3 daughters, so I don't know.
Understood on that one. So, Judge, permission to treat the witness as hostile?
Objection. I want you to sidebar, please. Any opinion about the case going on? We want to discuss the case from your presence and certainly your research. If there's no heads on your chair. Thank you. Let the record reflect the jury stepped out. Counsel may, along with the defendant, witnesses on stand. Ms. Holmes, my understanding from counsel's side is that you have an attorney here with you, is that right?
Yes, I did.
No, I was told to bring him in here.
Might be a good time for you to talk to him. So, you want to speak to your attorney? Any objection to that?
Yes,
What's
yes,
your
Your Honor.
objection?
The witness is on the stand, and for the state to suggest to a witness who has already been sworn and is in the middle of testimony that she goes and talks to her lawyer, it's type of intimidation, coercion. I think the rules have this. So we do object to that. It's intimidation.
Well, let me ask you this. Is it something you think you need to talk to your lawyer about?
I'll talk to her. I don't think I need to, but I don't know what the problem is of answering her question like she wants. I'm not sure what's going on.
Well, so my question to you is, do you want to talk to your lawyer?
Yes, I will talk to her.
All right, so we're going to be in recess. You talk to your lawyer, and you go ahead. You step outside, all right?
Okay.
And I'm going to continue with the argument here with the attorneys. So I guess this is the concern I had. You're asking me to declare her a hostile witness. It appears to me she is. I don't know if what's your position on it. She's at, that would allow her to ask these legal questions as she suggested sidebar. The problem with any of the questions, though, I don't want you to be asking specific questions, that things that she said previously she doesn't remember, and that you're just going to go ahead and put testimony before the jury. I mean, that's, you know, it's not the attorney's questions that are in evidence. I mean, she doesn't acknowledge it, or even after asking leading questions, she's basically saying, you know, she doesn't know, or that's the end of it. I mean, you can't go can't go much further than that. You can't put in evidence. Didn't you say X, Y, and Z? The police officer, she's not acknowledging she said it. I can't see how you do that. You can't.
So I think I can ask the questions because
What question?
in terms of, did you provide this phone number as the number for your daughter? Did you provide this number for the phone number regarding Mr. Dennis? Did you provide this information,
What information?
whatever the particular statement may be that we're at that point in the questioning? For example, did you provide the phone and say that previously that you talked on FaceTime with the defendant? That you talked to him on the FaceTime on the 772-713-9807 phone number? So judges, in terms of if I'm going to then impeach her with some other outside statement or some other prior consistent statement that she has made at some other proceeding, at that point, that's the concern as to her perjuring herself on that. So I think that's why it's important that she be allowed to speak to her attorney on that issue. And in terms of the prior statement on that, I still maintain that she has endorsed its authenticity and accuracy. Your Honor was provided with a copy of that deposition that the state referenced when we were talking about, and she indicated she was honest and truthful in that deposition, and she then endorsed the prior statement. So the prior statement should be allowed in on that, and if there's no concern as to any improper or anything on the jurors, because they will be instructed, as they always are, that no statements by the attorneys are evidence.
Can you speak her?
Yes, please. Your Honor, first of all, the state is now conflating issues. What we objected to and alerted the court to because we knew that this debacle was going to take place. I think it is evident that, yes, it appears as though the witness is not a major fan of the state. That's true. The state knew that going in. This is no surprise. These cases use the very language, surprise. In other words, what the state intended to do under a ruse at 803, 90.803 section 5 ruse is put on the witness to impeach that witness for that sole purpose of impeaching the witness, to introduce an out-of-court statement that is inadmissible because the state understood that she recanted. The state, under the pretext, oh, we don't know that she's hostile. We just think her recollection is failing. And we believe under 90.803 subsection 5, we can just read her statement. Unfortunately for the state, the Supreme Court has made it extremely clear that that witness has to vouch for the accuracy of the statement at the time it was made. And the Supreme Court also said in that context that in the context of an 803.5 exception, the contents of the record substitutes for the witness's testimony. This means that the reliability of the assertions rests upon the veracity of a witness who is present and testifying. The state is calling into question her veracity and calling her pretty much a liar, saying that she's feigning recollection and now attempting to essentially introduce a report of a police statement into evidence by the state testifying, asking the court to let the jury know that all this stuff that we're about to say, upon which we want to rest our case, is don't take it from me because I'm just a lawyer saying it. But then there's no point in saying it because there's no way to get it through this witness. She can't put her on to impeach, which is exactly what she's trying to do. The 8035 is a ruse, and that's not working out, and now she's doubling back to the original, which is, let me call her hostile so that I can lead, and instead of eliciting the testimony from her, I'm gonna read it out of this report and say, didn't you say that? So what happens is we're gonna now be in a situation where she's asking the state to tell the jury, hey, what the lawyers say is not evidence. So it doesn't matter that this witness is gonna say, I do not remember that number that you just read to me. That you just let me see. I told you I don't remember it. So I now the state wants to come back to the podium and blurt that number out. She just said she doesn't recall it. So what's the point of saying it other than to introduce it into the record through the state attorney's lips? So rules don't allow her to do what she's trying to do.
Thank you.
So you're in further support of treating a witness as a hostile witness. This has previously been provided to defense, but this is the Instagram production for Miss Felicia Holmes that I'm showing the court now, that she has previously been identified as her specific Instagram, and that it is saying the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company said. Now look, we can't go home. We're spending all my money I worked for and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitch Bitch. So Judge, it's very clear from this record that my intention and what the witness has represented to me in all shapes and forms that she was going to be honest and truthful. So to say that it's improper for calling her just for the purposes of impeachment is incorrect. So to continue on in that same Instagram production, and this is in June of 2022, Felicia Holmes is saying, they made me quit, told me that they would take care of us until trial was over. But guess what? Lies as usual. I was making $9,000 weekly. I didn't need shit from them, but everyone begging and pleading. Now they all ghost. I got something for Track though. He lied to me and my child for the last time. Again, saying you're going to air him out to the prosecutor. So Judge, in terms of, so that's in defense of the representation of counsel that is just being called for impeachment. It's also clear that this witness has received multiple benefits from the defendant based on her own statements there, that she has endorsed that that was her Instagram on that.
So, counsel, there's a couple things going on here. Number one is you indicated that the testimony was going to be admitted because it was in essence, I forget the statute number.
9803 sub 5, it's a past recollection reported.
Past recollection recorded, and you
Correct.
gave me the polite case,
Yes.
and that indicates that you have to have a proper foundation, but it has to be not only there's a proper foundation, but it has to, the hearsay statement was inadmissible in that case because the witness did not vouch for its accuracy or correctness, which is what we have here. The witness isn't vouching for the correctness or accuracy of the statement. So it doesn't meet that criteria. On the other issue about impeachment, this is not what she said. She's, she said, gave me a different answer. What I tried to read before was something from a couple of cases. And again, the synopsis at the end of it, this is, I'm just reading again from the SL, a child case, the state 993 Southern 2nd 1108. It just says the Florida rules of evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at the trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given on the oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. Goes on and says, interpreting this position, the Supreme Court of Florida recognize that a statement given during a police investigation is not a statement given at and other proceeding. So then if you agree, I don't know where we're going with this, counsel, respectfully. It seems to me under either scenario, that statement doesn't connect. Now, I do have a message from Mr. Bears, B-E-R-E-S. He says he's Ms. Holmes' attorney. He would like to speak with me. I don't know what he wants to talk with me about. He can't agree, I'm assuming it's this testimony. But anything he could say right here in open court, I don't have an issue with that.
That's fine, Your Honor. I really question the purpose in advising my client, Ms. Holmes, to consult me for a lawyer. I take it as an implicit threat to Ms. Holmes. We have an agreement that she comes in here today to testify. She's done that. She's honored her agreement. And, she's answered all the questions put to her. She may not be answering the questions to the satisfaction of the state, but she has fulfilled her agreement. And now Ms. Holmes is again placed in fear. And that's all I have to say.
Thank you. All right, let's, anybody need a restroom break or anything? You ready to go?
Yes, sir.
Pardon me?
Judge, I think someone on the fence.
I need to go to.
Sure. We'll take a short recess.
It came off as misleading to me too. Like we got to get back to this testimony, y'all, because I'm too intrigued.
Come on up, Ms. Holmes. Thank you.
I'm sorry.
Jury entering.
Please be seated. Let everyone see and reflect the votes for jury. All Ms. Holmes, please understand. Apologize for the delay. Councilman, ready to proceed? Please.
Okay, Ms. Holmes, when we left off, we were talking about a pet snake.
Yes,
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure probably, I'm not sure it's not here, but I'm pretty sure.
Do you remember the name of that pet snake?
No,
In terms of the owners of that snake, do you remember who owned it?
I just know it was, I know the owner was, it was in the house with Mariah.
Okay. Where did Mariah live at that time?
She lived in Myanmar.
And do you know the address?
No, I don't.
Who did she live with?
She got a boyfriend, but you know.
Are you telling the ladies and gentlemen of this jury that you don't remember your phone number in
I'm
October
telling you guys,
2016?
I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of this jury that you don't remember your daughter's phone number?
No, I do not remember my daughter's phone number.
And there's nothing that would refresh your memory or recollection whatsoever?
Objection,
That's
ask
what
and
you-
answer.
Overruled.
That was 4 years ago. I had so much trauma in my life since then.
Of course. So, is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drive-by?
No, because they said his friend had been in trial.
And you were worried about him because he was hiding in some bushes?
Objection.
I don't remember his
Sustained.
wishes.
What do you remember?
I sustain the objection.
What do you remember?
I should remember him saying for us to come get him.
When you made contact with him later that same day at Frida's house?
Yes.
Is it fair to say he had no blood on him?
No, he didn't have any money.
And is it fair to say that he left Frida's house and went up to a video shoot that afternoon evening?
Yes, he did.
Did you go to that video shoot?
No, I didn't.
Did Mariah live with Mr. Dennis after the homicide for a period of time?
Yes, she did.
Did she live in a condo in Miami with him?
Yes, she did.
Have you made other statements about the events of October 26th of 2018?
I don't remember making any other statements.
Do you recall a Instagram conversation with the co-defendant Cortland Henry?
I don't remember it.
Okay, if I may approach, I'll see if this refreshes your recollection as to that conversation. It's 3 pages.
Except for more counsel.
Not yet, Aaron.
I don't remember it. I don't remember it.
You don't have any recollection of that?
I don't remember it.
Is that your Instagram, LaneQueen258?
Yes, it is.
Okay, and the conversation that you don't recall on that whatsoever?
Yeah, I don't remember it.
Is your testimony here today that you lied in those statements?
The line of my statements.
The allegations that you made to Mr. Henry?
And I don't remember making those allegations, so I don't.
Do you remember sending screenshots of those allegations to a detective?
I remember sending a detective something stating that I didn't threaten Portland.
No.
Because I remember that.
You remember sending screenshots of conversations?
I remember telling him that I did, because he reached out to me and asked me that I threatened to kill Portland. And I said, no, I did not threaten Portland. I remember that.
Was there any threats made to you by the defendant?
No, no.
In terms of your daughter, Mariah, where is she?
I don't know.
After this incident, did she live with the family of the defendant?
She's always lived down there. Before this incident, she always lived there.
And your testimony to the ladies and gentlemen of the jury here today that you saw Mr. Melly on October 26th of 2018,
Yeah, I saw him.
that you spoke with him and heard him on the FaceTime conversation.
I did speak to him.
And it's your testimony that he indicated that it was some sort of shooting that occurred.
Yes, I did, yeah.
Okay, and it's your testimony that you saw him on your daughter's cell phone as a video call.
I saw him.
Is it your testimony today that after that you called Jamie King?
Yes, I did call Jamie.
And in terms of the conversation with Jamie King, that occurred
Yeah.
immediately after the FaceTime?
Not probably immediately, I'm not probably immediately, but sometime, I'm not quite sure the time. I don't remember what time it was.
And it's your testimony to the ladies and gentlemen of the jury today that you were dishonest in your first statement?
I don't remember my first statement.
Okay. Is it your testimony to the ladies and gentlemen of the jury that you would
I
lie?
don't remember my first statement. I have no reason why you.
Yes or no? Did you
No.
lie to police?
I did not lie to you. No.
Yes or no, did you lie to police?
I didn't lie to you. I don't remember my first statement. You're trying to make me say I remember my first statement. I did. For me to say no, I didn't lie with me. I remember my first statement. I don't remember it, so I don't remember.
Well, if you need more time to look it over, I have a copy of the.
I looked it over. I still don't remember it.
Well,
I did it over 100 times. I don't remember.
well, if you'd be so kind as to do it one more time.
Yeah, sure.
I mean, you can say that to this jury that this is not truthful?
Objection has been answered 5 times, Judge.
Thank you, objection noted. Move.
I honestly God do not remember any of this on here. Like I don't remember talking. I don't remember. I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your own practice or anyone for?
Objection.
Excuse me, that's
I'm
the
just
side
a lot.
quiet, please.
She's being forceful. Like she don't remember. She said she don't know.
That's the standing objection.
Okay, so going back to the relationship with your daughter and defendant.
Yes.
How long did that last?
3 years. I'm not quite sure how.
During the course of that relationship, did she have multiple photographs of him?
I'm pretty sure she did.
Videos?
I'm pretty sure she did.
After this incident, on October 26, 2018, at Frida's house, is it your testimony your daughter went upstairs with Mr. Jones?
She did. They did go upstairs.
And went upstairs. And do you know about what time you got to Broward County?
I probably got to Broward. Maybe I can't really remember the time. Maybe I don't know. But 1 o'clock was after lunch. It was right after. So it was after lunchtime. It was 1 o'clock.
Do you remember going to lunch?
Yes.
Do you remember where you went to lunch?
I don't remember which restaurant.
Do you remember who you went?
My daughter and AA.
And that's James Francois' wife?
Yes.
And do you remember, your testimony to the jury, that you remember the defendant, how he was dressed without letting his clothing?
I don't remember exactly what he had on, but I just remember there was no blood, I would have been, that would have freaked me out. So I know he had the blood on.
No blood on him. Is it your testimony to this jury in terms of that you went to Frito Bang or Frederick Gibbons' house?
Yes.
Is it your testimony to the jury that there were other individuals present at that house?
Yes.
Who was it?
I don't know.
Do you recognize any of the individuals?
No, I don't.
Okay. Your daughter, she was present?
Yes, sure.
And in terms of your appearance here today,
Yes.
you don't want to be here.
You made it on here.
I did.
Yes, you
So,
did.
and in terms of you were served with a subpoena from the
Never
prior,
served, never served.
and so you were ordered by the court to show up.
You never served me originally. That was a lie.
And in terms of your job,
Yes.
did you quit your job?
I got fired because you put me in jail.
And prior to that,
Yes.
before you were put in jail, did you quit your job?
No.
Okay, so you never quit your job.
I had to leave because you told my lawyer to put a warrant out for me. So I had to leave my job.
Okay, so you left your job.
Yes.
Did the defendant ever offer to pay for you and your daughter?
No, I did my homework.
Have you ever made statements contrary to that?
I don't remember.
May I approach you?
Got an objection.
Ms. Show counsel.
Sure.
Can we approach? Sure.
Are you done with that?
Okay. Ms. Holmes, were you ever told the defense, or the defendant rather, would take care of you and pay for your bills?
No.
Have you ever made a statement that is different than that?
Let's stay like that.
Can I approach you?
Just read this. I don't remember that.
Okay.
Staying away from my bills.
So, Ms. Holmes, is it your statement testimony that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies? They didn't want us talking with prosecutors, but now they've all disappeared. You never said that before.
I don't remember saying that.
Objection, Your Honor. Move, Mr.
Thank you. don't you come sidewalk? Totally improper, and therefore sustain the objection. I am instructing you that you will disregard the question. All right? I'm going to ask counsel to rephrase the question. Go ahead.
So it's clear. Ms. Holmes, did the defendant ever make you a promise to quit your job and that they had us?
Objection. Ask and answer.
Thank you. Overruled. Proceed.
I don't remember saying anything like that.
So you're testimony that you never said that.
I
Objection.
just, I don't remember.
Excuse me, counsel, she answered the question. All right? Let's move on.
So with regards to your statements with Portland Henry, do you remember speaking and talking about your daughter with Portland Henry?
No, I don't. When was that? Yes, I don't remember.
Sure. When was that? Here, I'll introduce you again. So it's February 5th of 2021. You said that?
Oh, no, I don't remember that.
You don't remember that?
Yeah.
Did you talk to Portland Henry about your daughter's involvement in this case?
I don't recall.
Ms. Holmes? Did your daughter tell you what happened in this case?
Objection.
No.
What's the objection?
Calls for hearsay. It's immaterial.
Not what the statement said. Did you say something about the case? Overruled.
No,
Not
she
what was
never
said.
told me.
Just,
She never
did you have a
told me.
excuse me. Not what was said. Was there a conversation?
Was there a conversation that your daughter told you what happened in this case?
What do you mean what happened?
Did your daughter
She
ever
never told me. She hasn't. I asked my daughter, did she know anything about this case? And she said no.
have you ever made a statement different than that?
Not that I can recall. No, I don't remember saying anything like that.
Can I approach her?
Yes, ma'am.
We object.
Why don't you show it to counsel first?
Can we approach?
Yes.
Sorry.
Ladies and gentlemen, take no recess. Don't discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case with friends. Learning no research. Just leave no heads on the chair. Ladies and gentlemen, thank you. Let the record reflect the attorney for the defendant, his counsel, the assistant state attorneys, ladies and gentlemen, the jury, our witness remains on the stand. Please be seated. And remind you, Ms. Holmes, to call her oath. Counsel, please continue.
Let me let me come back and ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about that.
Did she tell you what happened without?
No, she didn't just know shit. No.
Have you ever made a statement that is different than that?
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidewalk. Proceed. To your approach.
Showing me your messages from Instagram from February 5th, 2021.
Who was that Instagram? Is that the one Instagram we sent with Dortmund?
Ma'am,
I don't
sorry.
remember. I don't remember that Instagram.
Look at it.
I already looked at it. When she was it.
So is it?
I don't remember that. You showed it to me like 3 times already.
So you don't recall making
I don't
a
recall making my
statement?
statement.
Excuse me, one at a time. Please let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
So you don't recall saying,
Objection.
Sustained.
so, Ms. Holmes, in terms, you said that your daughter didn't tell you.
Objection, asked and answered.
Sustained.
So did you make a statement different than that?
Objection, asked and answered.
Sustained.
Into the statements that with regards to October 26th of 2018. Is it your testimony to the jury that you remember coming to Fort Lauderdale?
Objection, asked and answered.
Sustained. Listen, I just want one of you to make an objection. Whoever's gonna handle those
Yes,
things. All
I
right?
apologize.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection, asked and answered.
Sustained.
Ms. Holmes, have you ever let me rephrase. Ms. Holmes, did your daughter ever threaten to cooperate with law enforcement?
Objection.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection, asked and answered.
Different question.
Why don't you come sidewalk? I want you to do the question, please. Thank you. I still, come on sidewalk, please.
So, Ms. Holmes, I want to ask, were you present when your daughter spoke with law enforcement?
She was 17 and I had to be present.
Do you recall about when that happened?
If she was 17, that had to happen in 2018.
Okay. Without getting into what she said on that. Do you remember where that statement was taken?
No, I don't.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Cause for conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
Sustained.
When you arrived in Fort Lauderdale and saw Mr. Dennis, did you ask him what happened?
Objection. Asked and answered.
Overruled.
I'm sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
I have one question.
Yes, sir.
You came here and one of your first, you get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, Counsel, you direct your comments.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I did.
Thank you.
Anything else in this witness?
Yes, Your Honor. Ms. Holmes, you said you feel threatened by
Of
me.
course.
Okay. Did you fail to appear for numerous court appearances?
No, I never certainly lied.
Okay.
I lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay.
Material.
Overruled.
And so that was a location you were at?
That's why I was talking to her. Yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next weekend. I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of 2019.
You never served me. I know you served me to a location. I didn't do that anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Excuse me.
Anything about the courthouse.
Excuse me, come sidewalk, please.
So, Ms. Holmes, you even went so far as to hire an attorney
Yes,
to
I
try
did.
not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor after what my job with this. It's embarrassing. People think I'm a criminal. The state has ruined my life.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have you-
I'm telling you,
Have you- that's not-
I don't
Excuse
understand.
me, excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, sir. So my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you at the Fourth District Court of Appeals?
He had to hire an attorney to try to get in this far.
And that's a full statement.
Objection.
Excuse me, counsel, you're not testifying.
I
all right?
agree.
Excuse me, you asked a question, all right? That's it, you asked the question.
And so, Ms. Holmes, with regards to that, you hired an attorney
Yes,
and you then tried to get any sort of court order requiring you to be here in court thrown out.
no, what I did was I hired an attorney because you were saying you served me this subpoena that you never served.
And that was found to be valid.
You never served me a subpoena that was, you never served me.
Oh.
I've never seen a subpoena from you from those addresses that you said you served. Those
So-
are not my addresses.
Your testimony said you have never been served to appear in court.
Objection, asked and answered.
Sustain. Excuse me, sustain.
And so with regards to your feeling threatened on them, have I ever, any sort of physical violence against you? Do you have any written threats from me?
It's intimidating, you've intimidated me this whole time. As
And,
of now,
and in terms of your participation in this case,
yes.
you understand that you were served a subpoena to appear here today?
You served a subpoena after you arrested me. You
And
served
you,
a subpoena at the jail. When I was in Broward County.
and you understand you're here pursuant to that court order?
I'm here.
And that requires, under the law, to comply with court orders to, and that compels the attendance of witnesses.
I've been complying.
Nothing further.
Anything further?
No, sir.
Thank you. This witness excused.
Yes, Your Honor.
Thank you, ma'am. You may step down, you're excused. Want to sign order, please? Okay with
Yes, Your Honor, I have plenty of copies.
in any event, so, jury's been excused, counsel remain well with defense, so you have a couple motions from this time, you want to talk about those?
Yes, sir. As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do it, advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to plan one, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had into the record through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state is essentially trying to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, which you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant, And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial. This jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what's that.
This is your motion for Mr. Travis?
Yes, it's our motion from this round.
This is the second one. All right, go ahead.
Well, it's second. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper, and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since. So just to let the court know, there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regard to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it on based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's very, in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good, exceptions to all the rules of evidence, and there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or that Mr. Dem's interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm going to defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss with Mr. Demons whether or not his feelings about motion for mistrial. It's appropriate that he be consulted as well. But I haven't reached a conclusion about it, and so I'm going to see exactly what was said. I thought I heard what was said, and I'll check with the court reporter, get a little piece of that transcript, and we'll go from there. And I'll take it under advisement. But if you talk to your client about it, we'll see everybody back on Tuesday. All right.
Have a good weekend, sir.
Judge, since
We're breaking early today. Can we have a few minutes with our client?
Sure, I'd like you to take a few minutes with him. I'd like you to talk it over with him.
Yes, sir.
Can we have the cameras off? Will we talk about
I
it?
can't hear you.
The camera's off.
Oh, you want privacy, that's fine, that's right. Cameras can be excused, they can go out of the courtroom.
Thank you.
Let everybody go out of the courtroom, all right?
Thank you so
Thank
much.
Adjourn. This is like a private conference area.
Was messy. Okay, I was not expecting that. Like that, just my mouth is still on the floor. I'm still trying to process what the hell just happened. Like this lady, for one, y'all are here trying to solicit information from this lady. She's sitting here telling you she don't know. And you mean to tell me that y'all done basically just popped up like, yeah, somebody's supposed to be taking care of you? This video may be inappropriate for some users. Oh, what's going on? Now, I don't have an opinion. I'm waiting on the evidence to make my opinion about Melly because again, y'all, this is my first time watching. So I don't particularly know what all they presented. But I find it interesting that this prosecutor is acting real Miss Lovish. She acting real Miss Lovish.
This is put before them.
All right. I'm getting sick, y'all. I can hear it in my voice every day. But here we go. Day 5.
Prejudicial evidence that we believe was elicited improperly, either by introduction of evidence that could not be authenticated or through the leading questions of the government or the state. And the court denied the motion on the basis that there was not sufficient prejudice, essentially, to do so. What I wanted to do was to highlight, make a motion to strike the evidence that was elicited to be accompanied by a jury instruction, essentially letting the jury know that evidence that's excluded and the evidentiary rules are in place to ensure that only properly authenticated and reliable evidence is put before them. And that's the reason for the rules. And when evidence is put before them that do not comport with the rules, it's because it has been determined under the rules to be either unreliable or insufficiently authenticated. The specific items which I was able to identify by recollection that were introduced and ought not have been in the manner that it was done include, but are not limited to, the following. And we move to strike it from the record. Any and all phone numbers that were contained in any document Holmes was.
So you're not talking about physical evidence that's been marked, something that's marked for evidence. You're talking about her testimony.
Both.
What would mark in that? Why don't we do this? Why don't you put it in writing? All right, file your motion, put it in writing, give State a chance to digest it, look at it, and I'll take a look at it, and we can get back. We can have a hearing on it. You know, this just picking out sort of this, she said this or that. I don't know. You know, typically I rule on objections as they come. So, and I thought I ruled on every all the objections. There's something that's in evidence that you're seeking to me that's already been admitted that you want to strike and have excluded from evidence. You know, I'm more than happy to talk to you about it and more than happy to listen to your arguments. But I think I need to have something to digest it. So why don't you put it in writing, give everybody a chance to look at it, and do some research on it and find out what the law is. I don't know what the law is on that.
I'm striking inadmissible evidence.
No, the law on having something that's in evidence removed from evidence. Something the jury already saw.
One
You
thing,
put it in writing.
I understand. One thing, Your Honor, we have another court reporter now. And I think if we're going to put it in writing, it should be complete enough, and we would need a transcript of Ms. Holmes' testimony so that we can be sure to identify all offending references.
I'm sure you can order that, and I'm
I
sure
think
that,
she's out for the week.
my understanding is that she had a calling from higher authority. Fourth DCA is looking for transcripts.
I thought there was no higher.
Fourth DCA is looking for transcripts, and that's what she's, my understanding, she's working on, so you tell her what you need, and I'm sure she'll get it to you.
Okay.
All right, so we'll be in recess. I'm gonna make a phone call, and have my Jay make a phone call, find out what the status of the juror is, all right?
Thank you, Judge.
We'll be in recess. She's on an IV, and she believes that she's dehydrated, and that's giving her fluids. She thinks, can't confirm it, but she'll get out sometime today, and she thinks that she'll be here by 1:30, but nothing's definite now, doesn't know. So I wanted you guys to talk it over and let me know what you think.
Yes, sir.
And we'll make a decision.
Yes, sir. Thank you.
We're in recess.
Wait a minute, now who's sick? Who got sick? Who got sick? Hold on, y'all. Let's see who got sick now. I'm nosy. I need to know who got sick. Y'all ain't tell me somebody got sick. Starfish, when I say my investment then went up 20 times, because what? You know what?
Counsel, what I'm being told is Juror Campuzano indicated she's still in the hospital. She's on an IV, and she believes that she's dehydrated, and that's giving her fluids. She thinks, can't confirm it, but she'll get out sometime today.
Okay, it was a jury, y'all. Yeah. My level of investment shot all the way up. Okay, so did they have court on day 5 or did they just call it? Let's see. Alrighty, they did. They got back in that room.
You said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Well, I don't know who's more angry, the witness or the defense attorney on that one, but we're going to talk about it with our awesome guests on the other end. Take a break. Please stay with us.
I get an update from the juror who was in the hospital this morning, and my understanding is she will be joining us. Everything was just, I guess, issue of dehydration or something along those lines, but I'm told she will be here. Can you hear me all right? One thing though I need to bring to your attention is when we broke this morning, one of our jurors, as Gary was escorting the jurors out, he was approached, and one of the jurors had asked him a question. Gary, go ahead, you want to tell us exactly what was said?
Right. She more or less asked me if she could ask me a question. I said, well, it depends. So the question was, she said, well, what's the status of the mistrial?
So now, I don't know what you want me to do about that, but that's the question was posed.
Actually, never gave on the record and find out how she would have any knowledge of that, because that was never stated in front of them.
I think it was. I think there was it was done on the record by Mr. Howard the other day. Mr. Howard here, no?
No, it's not.
Oh, I apologize. I thought we were all here.
He's coming right now.
Mr. Howard, I'm sorry.
Oh, no problem. I heard it all inside the media room. So no apology necessary. Thank you. Apologize for not being present.
No, it's my fault. I thought Gary walked in, but what he was advising me and I to the attorneys was that there was a comment by one of the jurors. Did you hear that?
Yes.
So I don't know exactly what you wanted to do. Who the juror was?
Miss Manuel.
Miss Manuel. One of the things that is, in my recollection, and I could be wrong, is different than yours, Ms. Bradley. My recollection is that there was a motion for mistrial that was made out loud, and Mr. Howard came sidebar. But the jurors been instructed not to read anything about the case. So I don't know if there's something in the newspaper about that. That's a different story, but I don't know what you want me to do, if anything. I bring it to your attention, any real interaction that Gary has with them, something that may seem inappropriate, we always bring it up and let you know.
And should I assume that for future reference, you'd rather I make those motions outside the presence of you?
Just come sign.
Okay.
But that was my recollection. I thought you, at one point, I don't know which, there was 2 motions from this trial. I don't know at which point, but I believe at least one point you stood up and said, I have a motion for mistrial.
No, actually, there was a question asked. I said objection, move for mistrial. And
No,
you called the sidebar and asked me to hold it until the end. And then at the end, after the jury left, Mr. Allison and I articulated motions for mistrial on an independent basis. And that's how it went down.
But it was announced in open court, correct?
I said objection, move for mistrial.
That's my recollection.
I remember coming sidebar and there being, that being said at sidebar, I don't recall it being said in open court.
I thought it was said in open court.
It's a fact that I said it.
So again, that's, I don't know what you want me to do, if anything, and, the jurors, is that juror here, by the way?
She's in the reception area.
So anyway, I'll leave to your discretion. It was announced in open court, there was a motion for mistrial. Gary obviously didn't answer the question. And, what did you respond, Gary?
I told her I didn't know anything about that. And then she asked me, weren't you there? I said, I don't remember that.
Anyway, that's where we're at. So you think it over. Let me know if there's any inquiry you want me to make. Madam?
Yeah, I think you need to, the state's position would be that she needs to be brought in. Your Honor needs to inquire if she's seen anything in the media or any coverage of that, because that was discussed online, is my understanding.
What do you think, counsel?
Well, to the extent that the court's inquiry of this jury is because of the state's faulty recollection that I didn't say move for mistrial in front of the jury, I know that not to be the case. I did say objection, move for mistrial. You then called the sidebar, and the only thing you said was, please reserve that to me.
That's my recollection.
Okay, that's fine.
Again, is that what you're concerned about, or is it concerned about just because it was said that you think I would inquire?
Your Honor, I think that it's not defense is general. If we go forward, and if they're going to waive any inquiry of this witness, if she's been looking at any other items or anything online, the defense brought to Your Honor's attention earlier. Because if they thought was laboring under the impression that there was some sort of cessation of trial and then started looking at media and news reports because they thought their jury service was over, that would be a problem.
Better to have more information than less, so we have no objection to that being the procedure that we deploy.
So you want to bring her in, indicate to her that I was advised by our bailiff, Gary, that you asked him a motion for mistrial and what had happened, and just ask her, how is it that you're concerned about that, or where did you hear about it, and just find out what information she's got and about it and where she heard it from. Is that the end of the inquiry?
I would ask that you inquire from her if she conveyed any of that to any of the other jurors.
Anything else?
Unless the court wants to say, unfortunately, I denied it.
So we're going to ask,
When the judge said, that's not my recollection either, baby, drop the story. Drop the
what
story.
she heard,
Oh my God.
where she acquired it from.
If she did any outside research afterwards.
And if she inquired or asked any of the other jurors concerning that.
Anything else that you want me to ask, counsel?
Anything else?
Okay, sir.
All right. Do me a favor.
You want to go?
Okay. I don't like that.
Just for
Thank you. Mr. Manuel's coming in, counsel. Mr. Manuel's going to come in now. Okay.
Thank you.
yours, Jeffrey?
Manuel, thanks for coming back in. Let the record reflect the person who defended his counsel, the assistant state attorneys, as well as one of our juries, Ms. Manuel. Counsel, please be seated. Ms. Manuel, please be seated. Ms. Manuel, why I brought in is, my bailiff indicated to me that when you weren't able to start this morning, that he was escorting the jurors out, and you approached him and asked him about what happened with the mistrial or something to this effect. Is that right? So that's a yes. All right. So I guess my concern is what you may have heard about this alleged mistrial and where you heard it.
The last day I was here, and the defense attorney said, jumped up and said, mistrial.
Okay. So that's where you heard it from?
Yes.
Anything other than that?
No.
All right. Was there any other research that you may have done or looked at newspapers or any kind of article about the motion for mistrial, anything like that?
No.
Anything on the news, any news media
No.
about the mistrial? No. And last but not least, did you speak with any of the other jurors about the motion for mistrial?
No, when Gary came in and asked us this morning, do we have any issues, any questions? And I didn't want to ask him in front of everybody, so I waited until we got in the hall and I put it aside and asked him that, because he asked me, have any concerns?
Okay. All right. Okay, that's what we're trying to clear up and find out. Because there's an admonition that I say every time we break, don't discuss the case, don't form any opinion about
Oh,
the
it was
case.
said in here.
That's what we're trying to find out.
Okay.
Thank you, man. Appreciate it. Thank you. Let the record reflect the juror stepped out. Counsel Manuel, defendant. Any other issue regarding this issue of Ms. Manuel?
No, sir.
So we otherwise ready to proceed?
Yes.
Sure shows up.
Yes. I think, are they all here?
As far as I know.
Okay, so see if they're all here. If they're all here, we'll start. Yeah, he did say we're short 2, 3. 3. But they're here now? All right, they're all here now. They don't, sorry for the late start. Hopefully everybody's all right. We appreciate your patience. We also appreciate the fact that you're all here. Thank you. But we're ready to begin again. When we left off last week, the state was still on this case in chief. Madam Clerk, next witness.
Susan Johnson of T-Mobile.
Susan Johnson, please. Good afternoon. Are you Susan Johnson?
Yes, sir.
Welcome.
Thank you.
What I'd like to do is raise your right hand for us.
Do you solemnly swear or affirm that testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Susan Johnson,
Please spell your first and last name for the court reporter.
SUSAN,
Please have a seat.
Thank you.
Ms. Johnson, that microphone in front of you will adjust up or down, but not back and forth. Okay?
Thank
Are you
you.
ready to proceed, ma'am?
Yes, sir.
Counsel, you may.
Thank you. Good afternoon, Ms. Johnson. How are you today?
Good, thank you.
Could you please introduce yourself to the ladies and gentlemen of the jury and tell them where you work?
Sure. My name is Susan Johnson, and I work for T-Mobile.
How long have you worked for T-Mobile?
A total of 26 years.
And what do you do for T-Mobile?
I am a manager within the emergency response unit.
Prior to working for T-Mobile, did you work for any other telecommunications companies?
Yes, I did.
And what were those?
AT&T Wireless,
And how long did you work for AT&T?
5 years.
How long in total have you worked in the telecommunications industry?
31 years.
So you indicated you were part of the manager of the emergency response.
Legal emergency response.
And what does that mean?
That means that we respond to subpoenas and other legal demands from various agencies across the United States.
And when you say a legal demand, what would you mean by that?
Subpoena or a court order, search warrant.
In terms of the record when you work with them, how often do you work with them?
Every day.
What do you do with the records?
So we're able to retrieve the information from our secure computer database and then send the response back to the agency that's requesting.
And I know this might sound silly, but what type of company is T-Mobile?
We're a wireless telephone carrier.
And is T-Mobile the parent company of any other wireless carriers?
We did acquire Sprint.
How long has T-Mobile been the parent company for Sprint?
April 1st, 2020 is when we acquired them.
In terms of the information that is kept by T-Mobile, do you keep phone call records?
Yes.
What would you call those?
Call detail records.
Do you keep information regarding the networks?
Yes.
Do you keep information regarding subscribers?
Yes.
What type of information is kept in a call detail record?
So call detail reports will show incoming and outgoing phone calls or text messages made or received by the cellular telephone.
Does T-Mobile keep that information as to when data is used?
Yes.
Will a data phone call or video call show up in call detail records?
No.
Does the information show who is being called?
Yes, it will show the transaction of the outbound or inbound phone call on the call detail records.
Does T-Mobile keep the cell site information for the call that the outgoing non-T-Mobile subscriber?
No.
What's the purpose of collecting this information at T-Mobile?
Billing purposes.
Is there any consideration as to the health and optimization of the network?
So we keep what is known as timing advance records, which is solely for engineering purposes, so that they are able to check up on the network, yes.
When a phone call is made from a cellular device or handset, can you describe from the network perspective what happens?
Sure. So what happens is the phone reaches out to the tower with the strongest signal, which is not necessarily the closest tower. So for example, we can have a tower on top of the building, or we can have one down the street. However, the one down the street might be the stronger signal, and we pick up that call. At that point, it's transferred to our switch, and our switch is what records all the information that you will see on the call detail records. At that point, it's then transferred to a landline company, and it's the landline company that actually delivers the call.
So you mentioned true call data. What is that?
So true call data is for the network. It will show where the phone is connected to when it's not in use, as long as it's turned on.
Does Sprint also have a similar type of data?
Yes,
What is per call measurement data?
correct.
Is that the same for true call, for the Sprint analogy?
Correct, that's Sprint's term.
In terms of subscriber information, what types of subscriber information is kept?
So the subscriber information, we have two types. One would be a prepay, and then the other would be a monthly account.
So the prepay, what type of information could you have?
So prepay, a customer is not required to provide their information, but they could provide a name, address, and date of birth.
On the postpaid or the billed type, what type of information do you have?
So we would have the name, the address, date of birth, social security number, and we actually do a credit check on that individual.
In terms of the individual using the specific phones or handsets, can you testify to that?
No.
How many times have you testified in court before?
Over 1,000 times.
Were you, as the record custodian for T-Mobile, provided legal process, and I'll go through them one by one, under reference tracking number for T-Mobile, 214-6318, for two phone numbers at 305-922-9533 and 954-376-9158.
Yes,
As the T-Mobile records custodian under tracking number 219-2645, where you provided records and requests and legal process for three phone numbers, 561-720-3210, 772-713-9807, and 954-376-9158.
yes,
As the records custodian for T-Mobile under T-Mobile tracking ID 208-1851, where you submitted requests for phone number 954-248-9081.
yes,
For T-Mobile tracking number 217-2715, for phone number 954-376-9158, where you provided a legal process to obtain the records for that issue.
yes,
Were you also under tracking number 205-8127, asked to provide for legal process phone number records for 772-713-9807.
yes,
Was Sprint at the time, now part of T-Mobile, under the phone numbers for 772-713-2341 and 954-371-7895 under Sprint tracking number 2018-221418, provided legal process and requested to provide records.
yes,
Was Sprint under Sprint case number 2019-15821, asked to provide records with regards to phone number 225-529-5054.
yes,
Prior to coming into court today, did you have the opportunity to review the records that were provided?
yes, I did.
Are these records made at or about the time they are created by a person with knowledge?
Yes,
Are they kept in the regular course of business of Sprint and T-Mobile?
yes, they are.
Is it in the regular practice to keep such records?
Yes,
Now, at this time, approaching with what's been labeled as states 000 for identification purposes and previously shown to defense. Ms. Johnson, do you recognize this USB?
yes, I do.
How do you recognize it?
My initials and today's date are on the USB.
And does those USB fairly and accurately represent the records that were provided by T-Mobile in response to tracking numbers that we just discussed, as well as to Sprint and the tracking numbers and case numbers they just provided?
Yes.
Here at this time, the state would offer states 000, state 63.
Any objection?
Yes, Judge. Objection? Relevance?
Sure, watch come sidewalk.
I'm sorry, I didn't get you.
63.
So I'm going to start with the Sprint records. What are we looking at in this particular file, 2018-221418-6155597?
This would be the subscriber information.
And in terms of looking at this particular one, I'm going to zoom in. What is the billing name for this?
Chris Thomas.
I'm going to the second one. What is the billing name on this one?
The first name is Dontavius. Last name is Withers, Withers.
At the top of this screen capture, there's a BAN number. Do you know what that means?
Yes,
What is that?
that would be the account number.
Does that correlate with the other data that's been provided?
Yes.
Going to now the same Word document file name. What are we looking at in this Sprint document?
This is also subscriber information.
So you had mentioned that billing account number, that BAN number.
Correct.
If you can touch the screen in front of you, you can write on it and it will show up on the screen for the jurors. So if you could point out where the billing account number is here. Okay. And then what is the phone number that was being used by this account, or the subject number?
772-713-2341.
And is this again for that Chris Thomas billing account?
Yes.
Okay. Scrolling down to the next billing account number. Is this the other account that we just looked at the subscriber information on for Dontavius Withers?
Yes.
And what is the phone number that's associated with this particular account?
954-371-7895.
Going on to 2019-158-210-6566861. For the phone number in question on this particular record, is that labeled right here?
Yes.
And what phone number is that?
225-529-5054.
And looking at the Microsoft Excel viewer, can you explain to the ladies and gentlemen of the jury what we're looking at here?
These are the call detail records with cell site information for Sprint.
Going over to the T-Mobile records. Just for demonstrative and illustrative purposes, when you are looking, this particular one called Timing Advance LTE and UMTS _TN 772-713-9807. Then it has another underscore IMSI. What is an IMSI?
That stands for International Mobile Subscriber Identity Number, which is the number that's associated with the SIM card found in the back of the phone.
And the first, the 772-713-9807. What is that?
That would be the phone number.
Are all of these records provided by T-Mobile?
Yes.
In terms of completion codes, is that something that is reflected in these records?
Yes.
What is a completed successfully completion code?
So that means that the call went through the network successfully.
What is an abnormal completion?
An abnormal completion means the call did not go through. Perhaps the user hung up prior to the call connecting or a dropped call.
Okay. In terms of what time frame are all of these records kept in?
We keep them in UTC time, which is Coordinated Universal Time. So depending on what time of the year it is, you would have to subtract either 4 or 5 hours from the time that you see reflected in order to arrive at East Coast time.
On October 26th of 2018, how many hours did you have to subtract?
It would be -4.
The cell site locations indicate latitude and longitude of the cell site. Is that now there's also a physical address. Is the physical address always the same as the latitude and longitude?
No.
What could the physical address sometimes show?
So that's what we refer to as an administrative address. So we use that for 911 purposes. To get the exact location of the cell tower, you would take the two coordinates, the latitude and longitude, plot it into a mapping program such as Google Earth, and that will give you the exact location.
There's nothing further to say, Sharon?
Counsel, is there any cross-examination?
1 second, Your Honor. Good afternoon, ma'am.
Good afternoon.
How are you?
Good, thank you.
So the technology that you just described for identifying locations, how is that verified by T-Mobile itself?
That you would have to ask an engineer for.
So you don't know how that's done?
How it's verified?
Yeah.
As to what tower connected to, is that what you're asking?
Yes.
So it's done with a radio frequency, is how the towers work. It's a signal.
Okay, so but you were telling us earlier that the phone does not necessarily connect to the nearest tower.
Correct,
It connects to the tower with the strongest signal.
correct.
So how is it that you know to approximate, how do you know how far the phone is from the actual tower?
I don't,
Is there no way to tell that?
not through me.
Not through you?
Correct.
And how do you know if the tower that the phone connected to is the closest tower or the one with the stronger signal?
That would not be a question for me. You would have to ask an engineer.
How would you know whether or not a phone defaults to a stronger strength? If you have a tower with a strong signal and another tower with a not so strong signal, or a signal that's not as strong as the other. You with me so far?
Yes.
How would you know at what point the signal disparity is strong enough for it to default to the one that's further away as opposed to the one that's closer?
Again, that's a question for an engineer, not for me.
So you have no way of helping us understand any of this information that you just described.
Correct.
You just collect it when you're subpoenaed and you provide it.
Correct.
And you're not familiar with the technology at all.
Not the questions that you're asking, correct.
One second.
Sure.
Is it correct that the data location information, the purpose that you worked with Sprint and with T-Mobile at some point,
I'm a T-Mobile employee.
and you were a Sprint employee at some point?
No, sir.
You were somewhere else? No?
AT&T,
AT&T.
correct.
The purpose that AT&T, and in this case now T-Mobile, collects this data location information is for billing.
Correct.
That's its only purpose.
And network engineers collect to optimize the network.
Okay. It's not used for identifying the locations of customers' phones beyond the purpose of just billing.
Correct.
Okay. Thank you.
Sure.
Thank you. Any redirect?
Yes, Your Honor. Ms. Johnson, counsel asked you, how do you know how something didn't happen? Is that a fair question?
Objection.
Say, rephrase.
With regards to these records, are they accurate?
Objection.
What's the objection?
Lack of foundation, Chief.
Watch them, Sabo.
They have more sidebars than a resort in Cancun. I'm telling you.
So, Ms. Johnson, with regards to the records, does the T-Mobile keep any record of something that doesn't happen?
No.
What is contained in the records that have been provided?
Calls and text messages that have happened.
Is this from the network's perspective?
Yes.
Nothing further, Your Honor.
Is this witness excused?
Yes, Your Honor.
Thank you. You may step down. You're excused.
Thank you, Judge.
Who is your next witness?
Jonathan Zeller.
Jonathan Zeller, please. Good afternoon. Jonathan Zeller. Welcome. You want up here, sir? That's our witness stand. When you get there, you put things down, raise your right hand, be sworn.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth? Please state your full legal name for the record.
Jonathan Zeller. This is Z-E-L-L-E.
Spell your first name as well, sir.
Jonanthn.
Thank you.
And that microphone will just up and down and not back up. Counsel, if you're ready, you may proceed.
Good afternoon.
I'm sorry. Can we approach you?
CB, I was making a joke that the proceeding has more sidebars than a resort in Cancun. You know, when you at a resort, like there's a sidebar every 15 steps. There's a little bar sitting off to the side. So I was just being funny.
Thank you. Anything else, Counsel?
No, Judge.
Bradley, if you're ready, you may proceed.
Okay. Detective, how are you today?
I'm good.
Good. Where do you work?
I work at the Milwaukee Department
How long do you work for the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009.
Prior to going into the homicide unit, what other hats have you worn for the Miramar Police Department?
Several. One in particular is the forensic, digital forensic examiner.
Okay, what is a digital forensic examiner?
So what I do is we'll stick with cell phones or cellular phones or devices of that nature. I do the extraction and analysis for it.
And when you're doing an extraction, can you explain to the ladies and gentlemen of the jury what types of software or tools you use to do an extraction on a cellular telephone?
Okay, so what we use is a software and hardware company called Celebrate. And this is specific for conducting extractions of cellular devices.
And approximately how many different trainings have you taken in the use of Celebrate systems?
Taken a few, each of them consisted of 40 hours of class training and exercises, and obviously the exam as well.
What about, have you taken training with the task team of the FBI?
I have.
Have you taken, you said you also do analysis of the cellular forensics or digital forensics. What do you mean by that?
So depending on what type of case it is, I will actually do the extraction and I'll also do the examination of it, the analysis for it, and go through it and look for items that potentially could be considered evidence.
And in terms of to do the analysis part, what information do you need?
I need to know the case.
In this case that we're here on today, Miramar Police Department investigation 18-10-06269, were you the lead detective?
I was not
What was your role in this case?
doing the analysis or the extraction of the device.
Did you do any analysis of the device?
I did not.
In terms of the extraction of the device, were you provided an iPhone with a phone number attached to it that's 772-713-9807?
Yes, yes.
Prior to coming into court today, did you have the opportunity to review the digital copy of that extraction?
I did.
Okay. I'm showing defense counsel what's been marked as stage triple P for identification purposes, showing the witness. Detective Zeller, do you recognize this thumb drive?
I did.
How do you recognize this?
My initials and my number on the
What does that thumb drive contain?
This is the generated report of the generated report of the cellular device that was extracted.
And is that in the same or substantially the same condition as when you performed that extraction?
Yes.
You're at this time, the state of request to state triple P in at state 64.
Objection. Yes, sir. Name.
True.
But whoever's working the camera today, at least they know to shut off the white noise, because baby, the white noise has been terrible for the past 4 days that we watched. So at least that part is nice.
So Detective Zeller, can you explain to the ladies and gentlemen of the jury what an extraction does?
So the extraction consists or it's done in order to obtain whatever's on that phone and to put it in a legible or readable report that's easy for someone to look at. And some of the things that you would get also by doing that, you may get items that have been deleted, and so on and so forth. That's why we do those types of extractions.
Nothing further from this witness, Your Honor?
Any cross-examination?
Yes, just briefly. How are you, sir?
Good news.
You said you did a phone dump here of a particular unit that the state referred to,
That's correct.
and you have not analyzed it?
No.
You don't know if there's any relevant evidence on it at all?
That's correct.
Okay. And you don't know who it belongs to either?
I do know who it belongs to. Obviously, I'm in the office. I know who it belongs to, but as far as the contents of it, I don't know.
You don't know who uses it?
I do not.
You don't know who it's registered to?
I do not.
Okay. 1 second. And as to any contents of that phone, you don't know if they're texts, who authored them?
Once again, I don't know the contents of it.
Okay. Your Honor, we'd like to come sidebar if you truly. As I discussed, I don't think I have one before. The one that I referred to first is RLG versus State, 322 Southern 3rd, 721, a third DCA case. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church, and every time she goes to church and comes back, she's taking 20,000 steps because she's doing like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology, because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication hurdle to, as a foundation, establish that that technology is a reliable one, because she is going to now, and she's introducing the matter for the truth, told the jury in opening, Mr. Devins, who she believes had the phone, but has no proof of that to begin with, walks 70 steps. Says who? Says an app. What app? The one in his phone. Is it reliable? We don't know. Why? Because she has not established the reliability of the technology as a predicate to the admission of that. So that is our number one foundation argument.
The case that you want me to read?
Yes, sir.
I'll have to take a look at it.
Thank you.
Yes, ma'am.
Here, I first start with citing back to State versus Maximit, which is a 1967 case, which was the earliest time in which I could find a pedometer being mentioned. And at that point, it's important to note this is a well-established technology that's been in use for hundreds of years, initially done by train conductors to measure out distances. It's also allowed under the Florida statutes and used to be used to measure out distances for determination of 1,000 feet from a place of worship, a school, or anything else, for measuring distances for enhancement on drug penalties. So I'd start by handing that one to Your Honor. Then I also have State v. Birch, which is a Wisconsin case in which similar information was admissible and used in a homicide case. Then also in the issue of cell phone dumps, and that's at 398 Wisconsin 2nd 1. And then even more recently, this was a federal case, United States versus REGO, R-I-E-G-O. I just have a Westlaw site because it's 2022. It is not yet. This is 2022 Westlaw 175467114. And again, those discuss all of the location information and the activity and Apple Health data that was admitted in those cases. And I'll be happy to email copies of those to defense counsel now.
Thank you. All right, we're in recess. I'll read them.
Your Honor, may I also just direct your attention to a few articles, one of which indicates the highlight here. The reliability of the registered distances, however, depends on a number of factors, including walking speed and walking style of the subject, and can deviate up to 30 to 40% from the true value. That's one of the several articles here. And what I will do is I will compile the articles and send them all back for your review while you're considering the issue, if you don't mind.
Sure, and the state would also submit in terms of law review articles, including a 2016 wearable devices as admissible evidence. Technology is killing our opportunity to lie. The 2019, the iPhone health app from a forensic perspective can stats and distances registered during walking and running be used as digital evidence. And I would direct our attention to the Supreme Court of Alabama. That was Jeffrey West. The individual in that case was convicted as well based on some of the Fitbit data.
And may I just ask that the state is making the representation that all the cases she's citing to do not require that a witness establish the reliability of the technology? It's just put in?
It has been admitted. I have some of the, everything that I'm giving to his honor, copy to you as well.
Okay.
Thank you. We're in recess.
Thank you.
Of the YNW collective, along with co-defendant Cortland Henry, who will be tried separately. Court was off to a late start today, only calling their first witness of the day this afternoon, before court went on a brief recess, but there were some discussions outside the presence of the jury. Let's head into that courtroom for more now.
An app on a phone that purports to account for the number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church, and every time she goes to church and comes back, she's taking 20,000 steps because she's going like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology. Because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication, or at least the expert, not even the method. And so we raised the issue. we gave notice of an expert. The state took issue with it, raised a Daubert objection to it at that time. This is not a situation where the state presents us an expert. And we can't anticipate that the state is going to try to admit evidence before they admit it without the necessary predicate. And those cases actually speak to the objection being made at the time that it is sought to be introduced. As a matter of fact, some of those cases rejected the appeal because even though the predicate wasn't made, the objection wasn't made at the time the evidence was sought to be introduced. The state sought to introduce evidence without laying a foundation. Our objection is objection foundation. We're not making a Daubert objection to an expert who's testifying. He doesn't purport to be an expert. This is not a Daubert situation, Judge. This is a lack of foundation situation. And the fact that that foundation needs to be presented by somebody with expertise and knowledge doesn't make it a Daubert question. It's a foundation question. And before the state, I think those cases are clear. If the state is planning to put evidence in that relies upon a technology, they first have to establish the reliability of that technology. And that's the basis of our objection with respect to this step down. We've also made a relevancy objection to the fact that there is a wholesale dump of information coming in through a witness who said, I haven't even looked at it. How do we know that the information in there is relevant? How do we know that the information that has been introduced is not more prejudicial than probative, even if relevant on a 404B? How do we know that it's not doesn't contain 404B evidence that's inadmissible? The state has to establish the relevance of the information they seek to put in. They can't just put in everything from a phone and pick through what they think, and then the jury has in its possession a host of majority information that's not relevant to the proceeding, which is prejudicial. So that is the other basis for our objection. Also, a lot of the information contained in there is hearsay. They said, well, it's his phone, so there's no hearsay objection. There are texts between people. There's also evidence that we have that establishes that that phone was being used. The phone comes up as the name Sack Chaser Howard. Sack Chaser is a nickname of one of the decedents. That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedents' name as the identifier. It's in the name of Jamie King, not Jamel Demons. It was retrieved from Jameson Francois, not Jamel Demons. So it's neither in his name, it wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. We have information here that indicates that definitively. It shows the phone being used to call. It shows the same step data from that very unit after he is incarcerated. So it's obvious that it's being used by several other people. So we can't even say that it's his phone and the information there is therefore all relevance, all information on it is non-hearsay because it's statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's somebody else's name, retrieved from someone else, and this witness has not analyzed a single letter, all the information that he can put in. So there is a ton of irrelevant evidence that is being introduced, and a lot of it is going to be prejudicial, 404B and 403 evidence, and that's why we objected before. I didn't wait until after, because one of the points that the court made is you already let it in. We objected before, Judge, and you told us, overruled, let it in. It's still a problem right now, and we're trying to stem the damage before it goes too far. And we think that the issue has to be addressed before this information is used and it goes forward, both on the foundation issue, on the technology issue, authentication issue, relevancy issue, 403, 404B issue.
Thank you. The relevancy issue is relatively low, counsel. My understanding, where's the phone located at, counsel?
The phone itself?
Yeah.
That will be introduced through the.
No, where was the phone located?
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that goes back to this defendant.
And they have to establish it before they put it in, not after the fact, on this notion that they possess information that makes it relevant. If they do, present it, and then it's relevant at that time. We have, Your Honor, indications of this cell phone and this Instagram account that the state has introduced. The Instagram account is being used to post pictures days after his arrest, up to and including pictures of this very trial last week. This Instagram account is being used and accessible to a number of people. this notion that, oh, it's his account, he's an artist. It's a public account that several people have access to.
I'm sure you're gonna be able to ask those type of questions, counsel. My thought is this, counsel, it's not fair to basically give me an inch worth of things to read, cases to read, articles to read, saying it's how it's not, the methodology is, and it's basically an Albert issue on it. It's not clear, it's not been established, all those types of things. That should have been done pre-trial. I haven't seen what's on the account. I don't disagree with that. Council's telling me it's relevant because of X, Y, and Z there. You're saying it's not, but I don't know what is the 403 analysis, what's more prejudicial than probative. I haven't seen anything about that. I don't know what it is. I haven't seen it. You haven't made me aware of it. You're just saying it's something more prejudicial than probative. If it is, I'm more than happy to go through one at a time with you and find out. But as far as who used the phone, what was it being done, Council's saying it's relevant to establish his phone. So I've made my ruling. You've made your objection. So everybody knows where they stand on it. All right, so it's admitted.
Okay.
All right.
Thank you.
All right, bring the jury back in.
Just the process, Ms. Ballard, are you finished with your cross, or do you have additional questions? Yes.
I don't think he has any relevant information. He said,
Bring the jury.
let me ask a few.
Jury entering. Ladies and gentlemen, thank you. For the delay, please be seated. Let the record once again reflect the presence of the defendant, his counsel, the assistant state attorney. Ladies and gentlemen, jury, I'll witness for me to stand. Do you have questions, counsel?
Yes, I have a few more, Your Honor. Thank you. You did, sir, 2 data dumps from the device in question?
I did 2 or 1.
You did 2 of them, did you not?
I did on this device, I did 1 extraction.
You only did it once?
If I recall.
Did you have the data verified by any third party for completeness of the download?
No.
And you made that decision, was it your decision whether or not to do that kind of verification?
Yes.
Okay, and you elected not to?
Correct, I did not.
Did you have an engineer review any of the data that you retrieved?
No.
And have you validated that the cell write extracts in the data that you did were in fact complete?
The extraction is the extraction, and that's what I got. That's what the machine gave me. Yes.
Okay, and how did you verify that the machine gave you a complete download?
I understand when you say a complete download.
You said you don't understand what I mean?
No, you didn't elaborate on that.
How did you verify that the machine, the Celebrite software that you use, downloaded the contents of the phone in its entirety? How did you go about verifying that?
That is not something that I can verify. That is whatever the data that comes from that phone and appears on the software. That's what I have. That's what I can do.
Okay, so you can't verify.
I cannot.
Is there a process of maybe testing? Is there another, first of all, software that you can use to download the information?
Sure, there's other software.
And you only use the Celebrite?
Correct.
And if you use another software and compare the downloads, that would be one way for you to test it, whether or not the download was complete, right?
In theory, I guess so, yes.
In actuality.
All right, let's do it then.
Okay. So when you say there's no way to do it, it is what it is. What you're saying is there is a way to do it, and you didn't.
If that's what you want to call it, but it's not true. That's not correct.
Oh, so you did test it on another software?
No, I did not, but this is the only software that I have available to me.
Okay. So it's not that you had another software available to you that could help to verify the completeness and accuracy of your results. It's that you can do it, but you didn't have that software available to you.
Well, correct, I did not do it now.
Do you know anything about the testing of the technology of Celebrite as to its efficiency and operability?
No, I don't. I'm not an engineer for that.
So you, pardon me?
I'm not an engineer for them.
Okay, so it would take an engineer to do that?
Or somebody from that company, not me.
Okay, so it's like any kind of software. If you have the software and it doesn't work in totality or doesn't work completely, you're stuck with the answers.
I'm not understanding what you're trying to get at. If you rephrase it one more time, I appreciate that.
If that Celebrite did not give you a complete and accurate download, you would have no way of knowing it.
That is correct.
Okay, because you didn't have comparable software or similar software to test the results against.
Correct.
Okay, so you're just trusting in the faith. You're just having faith that the Celebrite.
Sustained.
You are relying upon the accuracy and completeness of Celebrite technology, right?
That's correct.
Even though you don't know anything about whether or not it works properly.
Correct.
Okay. Have you ever done a data dump from a phone more than once? Any phone?
Yes.
On Celebrite?
Yes.
And was it a phone that left your possession and then you regained possession of it?
When you're saying left my possession, I'm sorry.
In other words, it left the custody strikeout. In the instances when you have downloaded information from a phone on using Celebrite more than once, I presume you did it for a reason.
So one of the reasons why I probably would do it is maybe a software update from Celebrite.
Okay, that's one of the reasons. What else? What are the other reasons you might do it?
That's one of the reasons that I would use it.
Okay. Can I have one more, John?
Yes.
So it is your testimony, sir, that you didn't do an extraction from this phone in June?
What year is it?
And then another at a later date?
I don't recall.
At an earlier date in April?
I don't recall.
So you have any information there before you? Any of your reports that would indicate that?
I have one that was completed on February 28th.
February
2019, I think it is.
Okay. Nothing further. Thank you.
Councilman Zay, redirect.
Briefly, Your Honor. Detective Zeller, counsel asked you whether or not Celebrite is accurate.
Correct.
In your training and experience, can you speak on that particular subject?
Objection?
What's the objection?
This witness has already testified that he can't speak.
Sustained.
So Detective Zeller, in terms of you've used Celebrite numerous times,
That's correct.
approximately how many?
Hundreds.
Have you found any instances in which Celebrite added data to a forensic download or dump that wasn't on the phone itself?
I'm sorry.
Objection?
What's the objection?
You would have no way of knowing that.
Over it.
Can you answer one more time? Sorry.
Have you ever had an instance in which Celebrite has added data to the forensic extraction or data dump that was not on the phone itself?
That was not on the phone? Not that I'm aware of.
In terms of the way to physically review, how would you do that on a cell phone and compare it against the Celebrite extraction?
Well, there's a couple things I can do. I can look at the different artifacts that are extracted, meaning, so I would look maybe at a particular phone call was made at a certain time and date, or a certain picture that was there at a certain time and date, or a video, or so on and so forth, whatever that's there. That's one way of doing it, yes.
So I want to make sure I'm clear. You're saying you would look at outside evidence from the phone and see if it agrees?
Correct, yes.
In terms of the information and the data that's put out there, what is the purpose of taking it off the phone?
Well, you also don't want to, use the original, and you're pretty much making a copy of the phone so that you don't ruin anything, delete anything, or compromise the device, or anything of that nature. So you work off that copy.
In terms of when a phone is brought to you, are there steps that are taken to make sure that there's no outside or internet or network access with the phone?
Yeah, so usually the phones are put in what's called airplane mode, where you disable all cellular connections.
And in terms of the type of extraction that was done in this case, what type of extraction was done?
This is called an advanced logical extraction. So,
What does that mean?
so there's different forms of extraction. The advanced logical pretty much gets, for the most part, I'm gonna use the word everything on there. When I say everything, the context, the pictures, the videos, the communications, any sort of communications that are on there, deleted items, specifically deleted items.
Okay. And in terms of to get the advanced logical extraction, what information do you need as an examiner?
Meaning, I'm
Do
sorry.
you need the passcode to the phone?
Yes, you do the password, correct, yes.
Nothing further. Right?
Is this witness excused?
Yes, sir.
Thank you. You may step down. You're excused.
Thank you, sir.
Thank you. For your next witness, please.
Brendan Collins.
Thank you. You, Brendan Collins.
Yes, sir.
Welcome. This is our witness stand. Can you come here, please? When you get there, just remain standing for a bit. Raise your right hand and be sworn.
You solemnly swear or affirm that testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth.
Yes.
Please state your full legal name for the record.
Brendan Collins.
Please spell your first and last name for the court record.
My first name is spelled B-R-E-N-D-A-N. My last name is spelled C-O-L-L-I-N-S.
Thank you.
Thank you. Please be seated. Collins, that microphone in front of you, adjust it up or down, but doesn't move back.
Thanks, sir.
You ready?
Yes, sir.
Counsel, you may.
Thank you. Good afternoon, Mr. Collins. How are you?
Good afternoon, I'm doing well.
Good. Where are you employed?
I'm an FBI agent, so I'm employed by the Federal Bureau of Investigation, and my full job title is Supervisory Special Agent.
And how long have you held that position?
This current position, about 18 months. I've been employed by the FBI for since 2012.
And as far as education, what types of degrees do you hold?
I have a bachelor's.
And is it in a specific area?
I was a history major in college
Were you employed anywhere else prior to working for the FBI?
by the Army.
And how long were you employed by the Army?
About 6.5 years. I had a couple of different jobs.
Going back to where you're working now, the Federal Bureau of Investigation, what are your responsibilities as an FBI agent?
Well, agents do all sorts of different things. Generally, agents are all investigators, and in the FBI, we investigate a myriad of crimes, from violent crimes, economic crimes. We also have national security mandates. Me specifically right now, I'm the supervisor of a squad that focuses on transnational organized crime.
So do you also have an ancillary assignment?
Not right now, I used to.
Would you explain to the ladies and gentlemen of the jury what is the CAST team for the FBI?
So CAST, or the Cellular Analysis Survey Team, is a group of specially trained and equipped agents and task force officers who do cellular analysis or mobile device location analysis.
And so when you say that, what types of records are you working with?
Usually records from phone companies or other service providers.
Okay. Can you explain to the ladies and gentlemen of the jury what is historical cell site analysis?
Sure. So when someone uses a phone or a mobile device to do something, to make a call, to send or receive a text, to check a sports score, or check your email, post something on social media, that's to connect to the cellular network or to the internet. When you connect through the cellular network, there's a record that's generated by your phones, by the phone company. So you have T-Mobile gives you service to your cell phone. When you make a call, you'll see records on your T-Mobile sheets about that call. Historic cell site analysis is using those records to answer questions.
So what's the purpose of historical cell site analysis?
To help with investigations.
And what are the main components of a historical cell site analysis?
Well, if you're being asked to do like a location analysis, in other words, the case involves trying to determine where a particular device was at a certain point in time, you really have three things that you need. First, you need the records for that particular device. And that will say that the initial records that are called detail record, for instance, will sort of look like a billing statement that you might get from a phone company. Will say, this date, time, this phone number, place this call to this other number, etc. Except it will also have additional information. It will say a cell tower that the phone connected to when it made that call. So you need that record of the device. You also need a record of tower locations that says, okay, the tower the phone connected to is located at this particular point on the Earth. You put those two things together into some sort of mapping software and plots it, and that will give you a general area where the device was at the time that it connected to that tower.
So you said device. Can you testify a specific person was in a specific area?
No.
Why not?
So the records I have are just about devices.
Okay. So there are limitations to your testimony.
Yeah, absolutely. Yeah, I'm talking about devices, not people.
Have you received any specialized training to become an agent that does CAST as well? What is that?
To be CAST certified is pretty extensive. There's several stages that the certification process is broken into. So I started my initial training in 2017. The first phase of training is the CAST basic course. That's a 2 or 3 day course where agents and officers from our local, state, or other federal agencies are exposed to what cellular analysis is and how to do it at the basic level.
Do you use the CAST work in your day-to-day cases before you became a supervisor?
Yes.
And so is this a required assignment to go to the CAST team?
No, but there's a lot more training than just that 2 day thing. Is that okay?
Oh, well, let's start with, to do that first 2 day training.
Yeah, so the first
is that
2 day
mandatory?
Yes.
Yeah.
Yeah.
To go on past that, is that something you have to apply for?
Yes. Yeah.
Okay, and to explain after that first initial training, what happens? What's the next level of training you can take?
So the next course is called the advanced course, and it's a week-long course, and that's just a more in-depth dive into each of the networks. So specifically, what are the weaknesses of, say, Verizon or T-Mobile, AT&T, Sprint when it was a standalone provider? What their records look like? What are the weaknesses of their network design, etc. After the advanced course, then we have a sort of test. It's like a week-long. When I went through, it was a mix of part in the classroom and part in the field, but it's all scenario-based. So, for instance, you'd be like a kidnapping scenario, like, hey, this child was abducted. Your job is the asset going through to try and use the records to develop a search location and say, I think that we need to go here trying to harm the child. You need a portion in the classroom, you need a portion in the real world where they have test runs at the different locations and you validate the results right there. So you either find the person or would and then either pass or fail. So I passed, and I was allowed to continue to the certification course, which is a 4-week course. The first 2 weeks are very academic. We have a week that's basically a semester's worth of material condensed into a week. It's put out by professors from the Florida Institute of Technology. We bring in representatives from all the major cell phone providers in the U.S., both their law enforcement relations and records custodians personnel. We talk about these are the types of records that we keep in our specific record, which in our specific company. We also bring in personnel from the network engineers, so the people who build the network, who design it. We go to infrastructure, so like the Sprint Network Operations Center, where they oversee the whole network across the country, et cetera. And then at the end of that, there's a test, and you either pass and are certified, or you don't.
Okay, so especially in Collins, are you certified in CAST analysis?
Yes.
How long have you held that certification for?
I got certified in September of 2018.
Is there continuing education or recertification that's required?
Yes, so to keep your CAST certification, every year you have to attend a recertification course.
Okay. Is all of the training specifically from the FBI?
No.
What other agencies and I guess companies do the training for you?
Yes, we have partnerships, or not partnerships, but we'll bring in educators from a lot of different companies. So obviously, the different telecommunications companies are critical. So we have them come to the recertification conference every year. We've had a range of other people. We've had Apple, Qualcomm, Oracle, people in the field of GPS, cellular engineering, vehicles, for vehicle telematics, and anybody that's sort of involved in that ecosystem.
Okay, so you mentioned Apple, Qualcomm. What are those?
Those are different manufacturers.
Is there also specific as to cellular technology and how it works training on that?
For what?
In terms of being a CAST certification?
After recertification?
Yes.
Yes.
Okay. How long have you been specializing in call detail records analysis?
So
call detail record analysis is really like the bread and butter of what CAS does. So since I started the training process in 2017, that's it's when I first really got exposed to working call detail records or CDRs.
Okay, and approximately how many times have you done this type of analysis?
I've done more than 130 cases and that have included more than approximately 300 sets of records.
When you say a set of records,
Yeah.
what does that mean?
Like a call detail record or an engineering report, some sort of data report, some sort of report from a phone company about a particular device.
And in terms of the types of cases that you've worked, what have they been?
Again, violent crimes like homicides or shootings, white-collar crimes, and then public corruption, crimes against children, terrorism.
Okay. Have you worked cases where you've been called upon to determine the location of a cell phone?
Yes.
How many?
I mean, for the 130 so cases that I've helped with,
Yeah.
The vast majority of those have to do with location, historical location.
Have you had the opportunity to validate your historical call data reconstructions or that you do?
Yes.
And how do you do that?
Well, as we mentioned sort of during the, I was talking about the train up, if it's a situation, a case where we're trying to find someone who we believe is in possession of the device, and you do an analysis, and you say, I think we need to go to this house and go there, and the person and the phone are there, that's validation. If we have a case where we have some sort of other evidence that corroborates it, like in a crimes against children case, and there's metadata on media that was produced at a specific location, and the cell site that says, okay, we know this film or something was produced here, and here's the cell site looks like that corroborates it.
So when you say metadata, can you explain what that is?
Yeah, that's outside of what I do with CAS, but that would be something that would be in a media file perhaps. It's somebody else would you extract the file from using a physical extraction device or a computer or some other device. Sometimes there's metadata embedded within the image or the video or whatever that will tell you different things, such as when the picture or movie was produced, where it may have been produced, or the picture may have been taken, etc.
Yeah, I just want to offer Special Agent Collins as an expert in the area of historical cell site and cellular technology and offer for water.
Now, you want to come talk about that?
Me specifically right now, the supervisor of a squad that focuses on transnational organized crime.
So you also have an ancillary assignment.
Not right now, I used to.
Would you explain to the ladies and gentlemen of the jury what is the CAST team for the FBI?
So CAST, for the cellular analysis and survey team, is a group of specially trained and equipped agents and task force officers who do cellular analysis or mobile device location analysis.
And so when you say that, what types of records are you working with?
Usually records from phone companies or other service providers.
Okay. Can you explain to the ladies and gentlemen of the jury what is historical cell site analysis?
Sure. So when someone uses a phone or a mobile device to do something, to make a call, to send or receive a text, to check a sports score, check their email, post something on social media, that's to connect to the cellular network or to the internet. When you connect through the cellular network, there's a record that's generated by your phones, by the phone company. So you have T-Mobile gives you service to your cell phone. When you make a call, you'll see records on your T-Mobile sheets about that call. Historic cell site analysis is using those records to answer questions.
So what's the purpose of historical cell site analysis?
To help with investigations.
And what are the main components of a historical cell site analysis?
Well, if you're being asked to do like a location analysis, in other words, to the case involves trying to determine where a particular device was at a certain point in time, you really have three things that you need. First, you need the records for that particular device. That will say that the initial records, like a call detail record, for instance, will sort of look like a billing statement that you might get from a phone company. It'll say, this date, time, this phone number, place this call to this other number, etc. Except it will also have additional information. It will say a cell tower that the phone connected to, when it made that call. So you need that record on the device. You also need a record of tower locations that says, okay, the tower the phone connected to is located at this particular point on the earth. You put those two things together into some sort of mapping software and plots it, and then it will give you a general area where the device was at the time that it connected to that tower.
So you said device. Can you testify a specific person within a specific area?
No.
Why not?
So the records I have are just about devices.
So there are limitations to your testimony.
Yeah, absolutely. Yeah, I'm talking about devices, not people.
Have you received any specialized training to become an agent that does CAST as well? What is that?
To be CAST certified is pretty extensive. There's several stages that the certification process is broken into. The first, I started my initial training in 2017. The first phase of training is the CAST basic course. That's a 2 or 3 day course where agents and officers from our local, state, or other federal agencies are exposed to what cellular analysis is and how to do it at a basic level.
Do you use the CAST work in your day-to-day cases before you became a supervisor?
Yes.
And so is this a required assignment to go to the CAST team?
No, I don't want to interrupt, but there's a lot more training than just that 2 day thing. Is that okay?
Oh, well, let's start with, to do that first 2 day training.
Yeah, so the first.
Is that mandatory?
Yes,
Yeah.
yeah.
To go on past that, is that something you have to apply for?
Yes. Yeah.
Okay, and to explain after that first initial training, what happens? What's the next level of training?
So the next course is called the advanced course, and it's a week-long course, and that's just a more in-depth dive into each of the networks. So specifically, what are the weaknesses of, say, Verizon or T-Mobile, AT&T, Sprint, when it's a standalone provider, what their records look like, what are the weaknesses of their network's designed, et cetera. After the advanced course, then we have a sort of test is like a week long. When I went through, it was a mix of part in the classroom, part in the field, where it's all scenario-based. So, for instance, you'd be like a kidnapping scenario, like, hey, this child was abducted. Your job as the asset going through is to try and use the records to develop a search location and say, I think that we need to go here to try and recover the child. You need a portion in the classroom, you need a portion in the real world where they have test runs set up at different locations and you validate the results right there. So you either find the person would and it didn't either pass or fail. So I passed and I was allowed to continue to the certification course, which is a 4-week course. The first 2 weeks are very academic. We have a week that's basically a semester's worth of material condensed into a week. It's put up by professors from the Florida Institute of Technology. We bring in representatives from all the major cell phone providers in the U.S., both their law enforcement relations and records custodians personnel, to talk about these are the types of records that we keep in our specific record, within our specific company. We also bring in personnel from the network engineers, so the people who build the network, who design it. We go to infrastructure, something like the Sprint's network operations center, where they oversee the management of the whole across the country, et cetera. And then at the end of that, there's a test, and you either pass, are certified, or you don't.
Okay, so Special Agent Collins, are you certified in CAST analysis?
Yes.
How long have you held that certification for?
I got certified in September of 2018.
Is there continuing education or recertification that's required?
Yes, so to keep your CAST certification, every year you have to attend a recertification course.
Okay. Is all of the training specifically from the FBI?
No.
What other agencies and I guess companies do the training for you?
Yes, we have partnerships, or not partnerships, but we'll bring in educators from a lot of different companies. So obviously, the different telecommunications companies are critical. So we have them come to the recertification conference every year. We've had a range of other people. We've had Apple, Qualcomm, Oracle, people in the field of GPS, cellular engineering, vehicles for vehicle telematics, and anybody that's sort of involved in that ecosystem.
Okay, so you mentioned Apple, Qualcomm. What are those?
Those are different manufacturers.
Is there also specific as to cellular technology and how it works training on that?
For what?
In terms of being a CAST certification?
After recertification?
Yes. Okay. How long have you been specializing in call detailed records analysis?
Further, I'm going to give Nora a copy of the order that was discussed about the report that was done by Judge Siegel. This was signed on April 4th, 2023. Sure.
Are you intending to seek to admit the report?
Yes, and that's what that.
Admit the report.
Yes, and that's what that.
Should we just object now that the report's already missed?
I don't know what you're speaking of.
We don't think we admitted to admitting the report, we said we would.
Excuse me, I only want to hear from one. Whose witness is this going to be?
This is my own search.
All right, so you make the objection. So this is an order on the admissibility of expert witness testimony by Federal Bureau of Investigation, Special Agent Brandon Collins. Let me read it. Is there order to judge? Is your defendant stipulated to the admissibility at trial of the expert testimony of Special Agent Brendan Collins in the area of cellular phone forensics? This stipulation includes Special Agent Collins' testimony regarding the cellular analysis survey team cast report. And based upon the defense stipulation, it is ordered to judge the Special Agent Collins' expert testimony in the area of cellular phone forensics and on the cast report is admissible at trial. What's the issue?
So I believe counsel is trying to say that we are going to object to the admissibility of the cast report. We had stipulated to his testimony after deposing him. And then I will also bring to the record, she's trying to bring in 3 different cast reports. When we had deposed Agent Collins, we only had deposed him as to one cast report. We had extensive conversations about whether the state would be bringing in the additional cast reports. We had agreed at that time, if they were going to bring in those reports, she would let us know and we would depose him again. That never happened. They were always told it would be the one report of the 2 phone numbers. And which we are objecting to the admissibility of those reports based on hearsay. Also, they are misleading, and also the information in those reports have not been properly validated by an engineer.
Okay, so as of April 4th, 2022, what report was in existence as far as Special Agent Collins?
So the first one that was with regards to Anthony Williams' cell phone, as well as Mr. Demon's cell phone.
What other reports are out there?
The other ones were generated in May of 2022 and immediately turned over to defense counsel, and I have a very different recollection of that. This was listed at the same time as Mr. Zeller that we just had, so there was never any additional office request to depose this witness. But so Agent Collins has been available for the last however long if they so chose to do so.
And Judge, I would just for the record make an objection to for characterizing that particular phone that is actually registered to J.D. King as Mr. Demon's phone. I don't believe that has been established.
Thank you. So what is the report?
Judge, I'm sorry, I didn't hear what you said.
I asked for the report. I need to know what the report says. I'm not familiar with it.
Yes, sure. So they're all substantially similar. They do different cell phones at different times. That one is the one of Mr. Demon's and Mr. Williams, explaining how the cellular.
Objection.
Explaining how.
I don't understand. I'm asking for what the report is. I want to see it. And you say objection again. What's your objection?
My objection is to the characterization that it's Mr. Demon's phone and Mr. Williams' phone, actually. Yes.
You have another copy of that?
She emailed it to Ms. Liberty. Line.
Thank you.
So what is Agent Collins going to do?
Agent Collins would testify as to how he does the analysis, how he generates those timing advanced bands, and what it means as to the location of the cellular devices based on the records, which is all done as a product of the accuracy of the records and the fact that the cell phone communicates in a consistent way based on the laws of physics with a cell phone tower.
Because in here, it talks about the phone 772-713-9807, T-Mobile says Jamel Devins. This would goes below 954-248-9081, T-Mobile Anthony Williams. And it has the date of the report being May 12th, 2022.
Yes, Your Honor.
So this report date is after the order date.
It is. That is the second. It's the same one. It was all done at the same time. I believe, if I'm not mistaken, there was a typo that had to be finished on the spelling of the defendant's name, which is why it was generated at a second time on that point.
I just wanted
You respond, you say what you want.
I would just say just to go back that it has Mr. Evans' name on it, Mr. Williams' name, that needs to be submitted along with the other 3 reports, which were actually filed after the post-up. It is my recollection that we were told in court that they would not be used. There was a question if James and Francois' CAS report would be used. She didn't give us a definitive answer. We finally rested on the fact that she was not going to be using Mr. Francois' phone. So it is a little bit of surprise that is now being introduced at trial. And the other one, I believe, with Withers, we never ever discussed it.
Hold on.
Yes,
Hold on.
Yes, sir.
I don't fully understand this order dated April 22nd. It says, order to Judge Special Agent Collins' expert testimony in the area of cellular phone forensics and on the CAS report. So he's going to testify. I wouldn't normally admit a CAS report. I don't see why it comes in here. I don't see this specifically saying it's admissible. I see it saying Special Agent Collins' expert testimony in the area of the cellular phone forensics and on the CAS reports admissible. So he can testify. He's here. You can ask him questions that you want, but I don't believe I'd be letting this into evidence. It's just, he's here. His testimony is his testimony.
And so, with regards to that, the necessity of the maps is that Special Agent Collins is going to testify in terms of latitude, longitude, and distances on that. Without a map, and using that for the jury to be able to understand where this is being placed on the actual map, that's going in the vacuum.
You can show it as a demonstrative aid if that's going to help him illustrate his testimony. I don't have an issue with that. That's a different question for me. Typically, we don't just admit an expert's report. The expert's here is going to testify.
Yes, sir.
And it's not clear for me from this order that that's what Judge Siegel anticipated that the report was coming in. I don't have any issue regarding his testimony. They're not even, defense indicated they're not even going to board iron regarding his qualifications. So, he's able to testify. But as far as the report coming in, I don't read your order that way, respectfully.
Understood. So, Your Honor, then if I can show the admissibility of the maps with that on there, then you would evaluate them as their operating individual.
I don't have an issue with it. I mean, if he's able to identify them and talk to them, that's a different issue. You're wanting to admit the whole report in, is the way I understand, as substantive evidence. And typically, that's not the way it's done. I mean, the testimony is the testimony of the witness, not the report. I want it's cumulative, it's duplicative, or whatever he's going to testify to. I don't see the order talks about a date in April. This report was given after that date. I don't know if this is what the judge intended. You said there were some amendments. I don't know what the amendments are. I don't know if they're approved by the defense. They're saying they're objecting to it. Typically, that's just not done the way it's being done, putting in the document.
So, Your Honor, there are a tremendous number of cases on that specific issue, which I'm happy to provide the court.
What specific issue? About a report coming in?
About the maps and the mapping being admissible. So that would be.
I'm not concerned about the mapping. I'm concerned about the report per se.
Well, I just want to make sure we're clear on what specifically. So some of them, this specific items are demonstrative on that. So for example, when I can put it up so everybody can see, so it's clear. So Special Agent Collins, I anticipate to testify that, for example, there is cell power usage and how that would be displayed on that. So that wouldn't be confused with cell site usage. So that's because there could be the possibility that a juror would think, well, this is showing that the phone is somewhere in this purple area, which would not be correct, as opposed to, for example, a timing advanced illustration, which in this case, the witnesses can testify that the phone is somewhere in this band based on, and then as well as, so in terms of the way the mapping is then done, to make it clear and understand that these red dots are not the specific locations, but rather the towers that are used. I think it's important for the jurors to understand that and have the first part of that analysis there so that there can't be any sort of improper recall by the jurors on that. So then as to the locations on those, and this would be one of the timing advance. So if they don't have the other first part,
Judge, I think it's renewed again.
Excuse me, counsel. I don't think she's done.
Okay, sorry, Judge.
so it's more so the fact that the timing advance data and the way it is done, I don't want there to be any confusion to the jurors to saying that this is overstating the evidence. So if I just put in these particular items without the full explanation, because I don't think it is appropriate to do so without the jurors understanding the limitations of the testimony and what the different maps show. So on that would be the specific parts the state would be seeking to introduce, because the locations of the towers are important to how the map is done.
My understanding is that the defense is objecting to that exhibit. Is that correct?
Yes, Judge.
Does that include the maps?
That does include the maps, Judge.
So they're objecting to it. So I guess you have, in some way, it has to come out how it was done.
Mhm.
And you can talk to the witness and see if he can, authenticate it. The reason I was thinking that you were using was demonstrative, and I would ask him if that helps illustrate his testimony or not. But if you're saying it, you're not concerned with that, you want to get them into evidence. So the objection is, what's the objection?
That it's irrelevant. I would also object to the fact that
It's not relevant?
it's not relevant. It's also referring to Mr. Demon's phone. Nobody's established that number was his. It's referring to Mr. Williams' phone. We've got no testimony that establishes that it's Mr. Williams' phone. If we were to go to the other two reports, I don't know how the court's ruling on them. Again, she's referencing phone numbers, assigning them to people. We have had no testimony or evidence before the court that those actual phone numbers belong to those individuals.
Thank you. So I haven't heard any phone numbers being assigned to any individuals.
If I may, Your Honor,
Sure.
that is why the state introduced the phone slip that has been brought in to the defendant's fingerprints, that he endorsed that as his telephone number, and as such, the state cannot argue that. As to all of the other individuals, those are coming in from the phone records themselves. For example, Dungeedius Withers and Chris Thomas, as I went through with the Sprint records custodian.
So let me start. What is the phone number that's on that phone sheet that you're saying is Mr. Demers?
772-713-9807, and that's why we had the fingerprint analysis done, and they came in and identified that as the fingerprint of the defendant.
Thank you. And what's the next phone number?
The next two phone numbers that are the easiest ones to go through, Your Honor, are the phone numbers of Christopher Thomas, 772-713-2341. And if Your Honor recalls,
713-341. Should be another number.
772-713-2341. And I can bring up here for Your Honor the specific information on Mr. Thomas's phone that was brought in earlier through the Sprint records custodian. And there's the phone number at the top of the screen, 772-713-2341, billing address for Chris Thomas.
All right.
Going down in the same records, because they were produced at the same time. In addition, the email address with it is Chris Thomas 86. Again, consistent with Christopher Thomas. The next phone number that is on this particular is 954-371-7895. And that is belonging to an individual by the name of Dungeedius Withers.
Are there any other phone numbers this witness is going to be testifying on?
Yes, Your Honor. He would also be testifying on the T-Mobile records to the individual by the name of Jameson Francois, and to go to the subscriber information for Mr. Francois' phone. This is related to Miss Adria Scott. There's been testimony that Adria, or AA, is the wife of Jameson Francois. In addition, that phone number for Mr. Francois, 954-376-9158, is consistently in the phone download of Mr. Demons and is listed as track. And there are plenty of photographs and things of that nature that would show and illustrate that Mr. Jameson Francois, also known as Track, is the owner of that phone number.
But it's actually in his wife's name.
Correct. And if you, the rest of the subscriber information also says it is a family plan with multiple lines.
All right,
Rate
so
plan, family, unlimited, 2 lines included.
on the subscriber information for the first phone that you're suggesting is Mr. Dennis, what does that subscriber information look like?
That comes back to his mother, Jamie King.
So let's go back now. What's on I don't know what the exhibit number was. Did you print out anything on these phones? I think there was a printout. They objected to it.
There's multiple printouts on the phone, not all of which have been entered into evidence at this point.
But what's in evidence so far?
I can pull that up and just take a moment. This is in state 64.
This is the extraction.
That's correct. For example, 954-346. Three 7-6-9158. There are 1,129 messages between the phone owner, Mr. Devons, and other individuals in which Mr. Francois is a participant in those conversations.
So again, you indicated this is Mr. Demon's phone. You just told me the subscriber information reflects that it's his mother's phone.
This is, the plan is paid for by his mother. His mother's phone is in here. She is listed under Brazy, B-R-A-Z-Y, lady, and that's the 772-501-6942, which is listed as an additional number subscriber on the phone for Mr. T-Mobile from Mr. Devons.
Judge, I just want to point out, she's saying that these are messages between Mr. Demons and various people. This cell rate actually tells you, like she stated, like it's going to track, but it's coming from Young Sat Chaser Howard, and he's registering as the owner of the 9807 phone, which in these reports keep going back to Mr. Demons, but in the cell rate is showing Young Sat Chaser Howard.
And so in further showing as to who owns the phone, we can look at all of the videos and images of Mr. Demons, of which there are over 1,000 videos on the phone showing he is the user and owner of this particular device.
Judge, again, nothing that shows that he's a user and owner, it shows that whoever had possession of his phone took videos of Mr. Demons. They're not selfies, these are actually pictures that appears to be taken by another party.
Well, these are not videos, actually. If you want to go to the selfies, I can go to the 10,963 images to show some of those.
I don't know how she's determining their selfies, Judge, that's testimony possession.
So for example, in this particular image, it's a screenshot of a FaceTime conversation in which the large image is going to be the person who's on the other line. The local device is going to be the tiny picture up at the top, which is of Mr. Demons. This is just one of many, many examples.
Can you go back to the main subscriber information page?
In terms of this one?
So where does it show the subscribers?
This is from the device itself, Your Honor. This is an extraction from Celebrate of that phone in terms of information as to user accounts that are on this particular phone. You have YNW Melly booking at gmail.com. You have YNW Melly a Twitter account. You have YNW Melly an Instagram account. You have Melly.Montana, the Snapchat account, which the Snapchat is already in evidence, showing that one. You have Jamel.Demons, a Facebook account as well on that. In terms of the content of the messages themselves as well, show that this was Mr. Demons' phone and that he is sending out information and things personal to himself on this. So there are multiple different types of information to show them.
So just if we were to actually go through all of these, as I informed the court before, you're going to see messages from both of the deceased to their girlfriends to other people. There's no question that our client had used his phone, but so did all these friends. So this is a phone that they passed amongst each other. I don't think bringing up the Celebrate or a couple of selfies proves that it was actually his phone. For that argument, there's pictures of Michael Jackson on there. So can I say that Michael Jackson is well owned his phone? Based on her argument, that's what she's stating. I don't think she has given any definitive proof that this was 100% possessed only by Mr. Demons. Just picturing it out, yes, I guess he shared the phone with future also.
Anything else? State? No, anything else from the defense?
I would just point out that not only is that phone in Jaden King's name, so is the phone that she's trying to assign to Anthony Williams as the victim's name.
The counsel suggested and gave me four phone numbers. One, counsel indicated was Mr. Demon's phone. That's the 713-9807-772 area code. And there's one that was listed as Christopher Thomas phone. Another one as a Mr. Withers phone. And another one as Francois, also known as Track's phone. I haven't seen one as being on Mr. Williams, my mistake.
Yes, Your Honor, there was one on Mr. Williams that was on the initial report. That is the 954-248-9081.
954-248.
9081.
And that's Mr. Williams, one of the students, you said
Yes.
it's his phone?
Correct, that phone, and defense counsel is well aware of the fact that the phone that Mr. Williams had at the time of his death was recovered, and a full file system extraction was done from that phone. It shows it was his phone on that, and as well as the fact that the Celebrate extraction that we just went through also has Mr. Williams saved under the name of Twin in the phone of Mr. Demons, in which there's discussions back and forth that identify the 954-248-9081 phone number as that of Mr. Williams. And there's discussions, for example, that they have gone on trips recently. They have gone to Detroit. And there's then again photos of Mr. Williams on the phone of Mr. Demons in Detroit that are sent back and forth on it.
Regarding this witness, is he going to testify regarding Mr. Williams' phone?
He's going to testify to the locations of that particular cell phone, yes.
And they're going to be identified by phone number?
At both.
Anything else?
No.
Anything else?
Just if you're gonna let it in for demonstrative purposes, I would say at the very least that the names are stricken from the reports and referred, or redacted, sorry. And we refer to only the phone numbers, not to the individuals.
Thank you. So we're bringing jury in now. As far as that demonstrative, I'm getting conflicting information. I don't want something going before the jury about this is Mr. Demon's phone or this one's phone. There's circumstantial evidence to that effect, but I'm not putting that in evidence that way. You show the portion that shows the maps, and you can talk about the maps and the other things, but leave out the portion that has at the bottom, or I forget if it's the bottom or top, that identifies Janelle Demon's phone. Because she's by the phone.
Use it by the phone number. Okay, that's not a problem. So I think I need just a couple of moments to adjust that.
Go ahead.
Okay.
We're in recess.
Thank you, Judge.
All right, y'all, we are at a natural stopping point. So I am actually gonna run up to the school to grab my kid because my kids got half days. So we're just gonna take our little lunch. We're gonna take a little break. And then I will be back and we'll continue to stream once I got my kid in the house. So I'll put up a little thing. Give me about 25 minutes, 25, 30 minutes, and we'll be back. All right, y'all. We back. So let me get us after this break. And shout out to everybody that stayed tuned. And I'll get us queued up for day 6.
Sure, but I haven't, let's bring it back in. It is yo-yo, but I did say tell them not to read. I'm worried about that.
Sure. Makes sense.
Bring it back in. Mary's coming in.
Jury entry.
Ms. Young, thank you. Please be seated. Let the record once again reflect the presence of our jury, as well as the defendant, Mr. Dennis, this counsel to assist the attorney. All which remains on the stand. Ms. Young, I apologize, but I need to resolve certain issues before we go further. It's approaching 5 o'clock now, so my thought is I'm going to resolve it. We'll see you all back tomorrow morning. So remember the admonition: do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in your presence. Certainly no research about the case. All right? You hear that every time we break. I tell you that. It's very important.
Oh, okay. Like this day was over anyway. So I guess we had like a perfect stopping point because what? Okay, so let's get into now. We on day 6, y'all. It's crazy how fast we going through this trial. These are the commentators recapping from the day before. They're already at the bench. They at the bench before the
May we approach very briefly?
And we need one to be put in.
That is on the new download that was not on the prior download. So there's some more information on that. None of that is exculpatory. We're just going to say that the defendant was not at the scene of the homicide and not there.
There's nothing on that. I asked the officer.
More questions on Charlie?
Yes, Your Honor. It needed to be diagnosed, but the state just advised. If the court recalls yesterday, I was inquiring with the witness whether or not he, Miramar Police Department had any other software to test the results of their Celebrite download on. He said no, wasn't done. The state advised me at Miramar that there was another one done on another software in June of this year, which the state did not disclose, purportedly because we asked the discovery to be closed, even though the state opposed the closing of the discovery and the court denied closing discovery. Nonetheless, the state indicates that it failed to meet that discovery obligation because we were asking to close discovery, but wants now to introduce through another witness the fact that another analysis was done in June of this year. We would object to that admission based upon the discovery violation and the ambush evidence.
So you're alleging there's a discovery violation, so you're alleged that I need to do research in here and just find out whether what you're saying is true and not true, whether it's inadvertent or intentional, and make some decisions. You heard what the council suggested, so what are you telling me?
So Your Honor, in terms of there was an additional evaluation that's done, this was done, and the only reason why it's been coming up is because of council's questioning. So based on council's questioning and asking if there was additional or other ways to prove it, different witness, Dr. Melly, did a second analysis of the cell phone. Because at the time when Zeller got it and did this, they did not have an additional software program called Reiki. Miramar Police then subsequently obtained the license for Reiki. So the state's position is that based on questioning by defense, the state has instructed the witness to go into an additional download of the phone on that. So that was done in June of 2023. On that, the phone, everything is the same. The only difference is there's additional location data that is on the new download that was not on the prior download. So there's any more information on that. None of that is exculpatory, which is going to say that the defendant was not at the scene of the homicide and not there on that. The state doesn't have it in their possession yet. My understanding is it will be dropped off later this afternoon.
So, is it fair to say then that defense requested whatever downloads there were, and a download, the Celebrite download was turned over to them?
Yes.
The first one?
Yes.
But there had been a second download done, and that download was not sent to them?
It's not yet even turned over to the state. I'm waiting for it from the detective. He's going to be bringing it later this afternoon.
Okay, and when did this second happen?
That would have been about a week or 2 weeks ago. I have to start checking the date. I haven't seen it with the exact time.
Subsequent to the trial starting, you still were having downloads done?
In terms of if there was any other information, anything that was exculpatory, and I'd have to make sure that that was fully explored and turn that over to defense.
And so that has been turned over to them, so the defense doesn't know anything about it. And then defense counsel asks questions about other possible programs that they might have had, because he doesn't know if there are any or not. And the witness, Zellner,
Yes.
answers that they don't have it. And so something that he doesn't know, that prior to testifying, you've already run a second program through a different detective already on a different system.
Yes, so the defense didn't pose Detective Zeller because then it could ask questions such as, does Miramar now have additional software that this could be done on? So they chose not to do so on that.
Question comes back to this: when this second download was done on different software, that was just 2 weeks ago.
Yes.
When is it that you found out about it?
I still don't have a copy of it. I was talking with the detective last night on it. In terms of the download being done, I have to look and see exactly on the date and what he communicated to me about the results.
And who asked for the download to be done?
It was discussed with the detective in pre-trials as to if there was any other information, if there's any updates to the Celebrate program, as Detective Zeller testified to, that sometimes downloads are redone once there is updates to the software.
So this is new information that Detective Zeller doesn't know about.
Correct.
And Detective already hasn't been told about.
Correct.
And it's something that's new to you that you just came up and your pre-trial. How long ago was that?
I have to look on the exact date on when that was.
Yeah, tell me when the
Sometime
date
the week, I believe, of May 21st or 23rd, sometime of that, during the course of that week, as to when your actual analysis is done. I couldn't put it, I don't have it yet. But, this is analogous to, for example, if defense were to cross-examine a witness about evidence that was tested or not tested. If they open that door, then the state would be able to go forth and send additional items for testing on that.
And to your knowledge, there's no cutoff on this one.
Correct.
Thank you. Anything else?
Yes, Your Honor. There were two questions that the court just asked the state, which I noticed were not answered. The first was, who asked for it to be done? The second was, when did you, Ms. Bradley, find out that it was done? Neither question was directly answered. Both answers were evasive. If I asked a question that precipitated the state going and doing further investigation, one, we again keep arguing that that is an ambush that affects the fairness of the trial, and that's why it needs to be discovered itself. But also, that's not what occurred. The state's discovery obligation is triggered by the rules, not by questions I put to a witness during trial. So if the state was aware of the existence of the fact that another download was done, whether the report was not, and that we are in trial, and it puts a witness on the stand, to say, well, we're going to turn it over to you now because you asked a question, I don't think is a good faith response. One, we need a discovery cutoff, and we need one to be put in place now so that this propensity for ambush is not innate. Also, that's not the case in this instance. There was an analysis done. Ms. Bradley knew about it. She knew of her obligation to turn it over. She didn't turn over the fact that it was done, nor did she turn over the report. Apparently the report she is now claiming has not yet been finalized. If the analysis was done, it's a download. If the download was done, then the material from that download exists. This isn't a test that's done. It's a download. So if this download was done a few weeks ago, that is the material that should be turned over. And it was not. And we would object to any reference to it. And the defense team is going to discuss what other, one, we also for the court to inquire to say if there's any other discovery out there about which they know to exist and have not turned over. And we're going to discuss whether or not we're going to seek any further relief, but we would ask that the state be prohibited from engaging in this ambush. I've had it for over a month now.
No. So I'm gonna have to look at the notes on that and answer on, so if your honor wants me to respond on those, I can go and check exact dates on emails.
That's fine. You can check the dates and that type of thing. Right now, I'm referring to my Detective Moretti's not anticipated to testify today, is he?
No.
So we'll talk about that later in the day.
Sure.
Okay.
We also move for the discovery.
Understood. I defer ruling on it. All right. Let's bring the jury in, please.
If we can have the witness resume his seat.
Sure. Bring the jury in.
There's no family.
They'll take care of it. Jury entering. Ladies and gentlemen, thank you. Please be seated. The record will be reflecting the presence of the defendants, Devins, and counsel, and assistant attorney, ladies and gentlemen, jury. Our witness, Megan Collins, remains on stand. Good morning, sir. Please have a seat. I just want to remind you to remain under oath. Ladies and gentlemen, I did get a question. I was just discussing with the attorney regarding the scheduling, and my understanding from speaking with the attorney is that they anticipate the trial would conclude before the end of July. Trial is a fluid process. You don't always know exactly what the next witness is or who the witness is. Can you hear me? I apologize. So let me start over. I received a question about when the schedule of the trial, what it's anticipated to conclude. I spoke to the attorneys. They advised me they believe the trial would be over before the end of July. I want to remind you also that one, because the attorneys reminded me, I forgot that there's the week of July 3rd, 4th, 5th, 6th, and 7th. That week we're not going to be in session. It's we'll finish out the end of June and then pick it up again on July 10th. The week commencing Monday, July 3rd, we're not going to be in session. But the attorneys think the trial will conclude by the end of June. All right. So, ladies and gentlemen, when we were last here, Special Agents Collins on the stand as a witness. He remains under oath, and counsel, you want to finish with your record examination?
Yes, Your Honor, if I may.
You may.
Okay, Detective Collins, we had just discussed about your training and experience, so remind the ladies and gentlemen of the jury, in what field do you work?
I'm testifying here today in my role as a cast asset, so cellular analysis survey team, a group that specializes in historical cell site analysis and device location analysis.
And have you used historical records to locate fugitives and missing persons before?
Yes.
Did you conduct historical cell site analysis in this case?
Yes.
Okay. Did you prepare demonstratives to help show and explain to the ladies and gentlemen of the jury what your analysis is and how it is completed?
Yes.
Okay. I want to start with and go over the cell site records. Are those records provided to you?
Yes.
Okay. And so it's been previously admitted into evidence as states 63 and 64. Thank you. Starting with state 63. I'm going to open up some of the records, and if you would be so kind to follow along. So starting with what is in state 63, going to the tracking number 2058127. And so it's clear. I'm going to also publish state 28. This phone number 772-713-9807. Is that one of the phone records that you analyzed in this case?
Yes.
And states 28 is a pawn slip. Have you ever seen that one before?
No, I haven't.
So going back to the same phone number, 772-713-9807. Can you explain to the ladies and gentlemen of the jury what we're looking at in these phone records?
Sure. So this is a report from T-Mobile. It's an engineering report, and you may also hear it referred to as true caller quantum data or time advanced data. But essentially what this is, it's records of, from the network's perspective, location where the phone likely was during particular times. So you'll see a series of columns on here. At the top, it explains what is contained in each column, and then you'll have a series of entries. All that is associated with a particular time. So column A in this case is in latitude, and column B is in longitude. It says what the confidence level is, the IMSI, column E, and the IMEI. Those are numbers that are assigned to the device. So the IMSI is sort of like your SIM card, the subscriber number that authenticates on the network, so that when you have a cell phone communicating with the network, knows that your customer is paid and they can give the network resources. The IMEI is about the device that you have in your area.
It's been a little while since geography. So could you please explain what latitude and longitude are?
Yeah, those are coordinates on the Earth. So if you wanted to know where a particular person was at a certain point in time or whatever, those latitude and longitude coordinates correspond to a specific spot on the Earth. So we could plot those in any mapping software, like we could copy and paste this in Google Maps right now, and so in Google Maps, for instance, and say, okay, that's where latitude 25.984685, longitude minus 80.375979 is here.
And is that what you use to do your analysis, just those latitude and longitude?
No, I use other information on this sheet.
So you talked about the IMSI, IMEI, and so I'm going to go scroll over and just if you could explain. So the next column is, so we said roaming group, I think model and make would be the next columns that for you to explain.
Yeah, so the roaming group, it's T-Mobile records, the phone that is applied to, you can see the model and make. It's an Apple phone, it's an iPhone, and we'll skip to column. You can see in column K, it will say what type of record this is for, so data, which would be whether some sort of internet connection, whether you're using email or social media, or we'll say voice and data. Voice is obviously you're making like a voice call.
Okay, so going down to row 91, is that an example of the voice and data?
Yes.
Make it a little bit bigger. Zoom in so it's easier to see for the ladies and gentlemen on the jury. Okay, continuing up at the top again so that you can explain the columns. Which specific column are you looking at when you are analyzing these records, and the data in that?
So usually one of the most important ones is the time and the date. That's called that because often when you're doing a case, in this specific case, I was asked, are the records consistent with certain things the detectives had wanted to know based on the investigation that they had done separately. So you need this time and date.
And it's, when you're looking at this time and date, what does that tell you?
The time of the record. So when like column, or excuse me, row 2, when you see October 26, 2018 at midnight 000, you will know that the latitude, longitude points attributed to that in columns A and B, or a little further down the spreadsheet, we'll see the distance measurement from the tower that is associated with that particular date and time.
So with regards to the date and time, do you have to take into account if the records are kept in Eastern time or UTC?
These are in local time, so just
So the time that's on here is the time that the event happens here in whatever location it's plotted in?
yes.
Okay. So going forward, continuing across, and then which column, you talked about distance from the tower, which column are we looking at for there?
So you'll see in, if you scroll over for S&T, you'll see cell site and so start cell, start eNode B. eNode B is another name for cell site, like 4G technology for cellular providers. So depending on what technology it is, 3G, 4G, et cetera, they call the hardware different things. It performs the same function. So that's a tower. And we will know that that tower is at a certain spot in the real world. So if I know that at a certain time, column 2, where that time was at midnight, the phone connected to a tower named 76963, the antenna 23, I can go find where tower 76963 is, plot that on the map and say, okay, this tower is here, and the antenna is pointed in a particular direction, and at midnight, the phone was in that direction, and then we'll see if you scroll further to the right. You'll see the distance there. So column AO, it'll say 2.96 miles. So at that time, midnight on October 26th, that phone was 2.96 miles from that tower.
Okay, so we've gone through a lot, and I'm going to break it down a little bit in some of the things you talked about. You talked about 3G, 4G, 5G.
Yeah.
What is 3G, 4G?
Different technologies for, like, I guess, evolutions for the phone. Each time there's a lot, generally there's improvements in how well the phones work, the cellular networks work.
Okay, with regards to 3G, what type of information does that limit you to? In terms of distance from the tower, if it's a 3G tower, what type of range are you working with?
Okay, well, so that does play a factor in like the certainty of work. We'll see in the reports later, but this timing advance is an estimated distance from the tower, right? But there's a margin of error, a margin of uncertainty associated with it. And so 3G, for instance, the network can only say within, depending on the type of 3G, 234 or 244 meters, what that distance is. If it's 4G, they can tell within 78 meters. They'll say, okay, this is the time advance inquiry.
And in the case that we have before us today with the 772-713-9807 phone number, what types of towers and service was being used?
During the period that I reviewed, analyzed and plotted, it was exclusively 4G.
4G. So in terms of how wide is going to be your margin of error on the 4G towers?
78 meters.
78 meters. So can you explain to the ladies and gentlemen of the jury as to how that data, that distance, how that is computed?
Sure. So essentially, this is it's sort of like if you think about throwing, if I had a ball and I'm playing catch with myself, throwing it off the garage and it comes back to me. So the cell tower will send out a burst of signal to the phone, and then the phone sends it back to the tower because the network knows when it sent the signal, when it received it back, it has an amount of time. And we know the speed the cell signal travels at, it's the speed of light. So by multiplying distance by time, or excuse me, speed by time, we get a distance.
Is the speed of light constant?
Yes.
It's been a while since physics. So you just kind of explain that a little bit so that ladies and gentlemen of the jury as to how that works.
Yeah, so it's, the speed of light doesn't change, cell signal, the speed of light, anywhere in time, it's going to be the same.
Is the speed of light affected by foliage or trees or leaves or anything like that?
No, speed of light's the same.
Okay. Are cell signals or service affected by changes in environmental conditions?
can be slight changes, but generally not. And if there's a change, we're talking about like minuscule amounts of meters, not miles.
So meters, not miles. And what types of environmental conditions would be required to have a change of those meters, not miles?
Well, if your phone is in a, like, you know, a lot of buildings down here are built for hurricanes, so if there's lots of concrete walls, that can affect it. If the path that the signal takes to the phone is not a direct line, let's say it bounces off something, like it, we call that multipath, so if it less building and came to the phone and went back, obviously those things would increase the time that it took for the signal to go there and come back, so that would then increase the distance.
Okay. With regards to hurricanes, is that something that affects?
I mean, the way that would affect this would be if that had a catastrophic effect on the network and then the network wasn't functioning properly.
Okay. If there are records that you are analyzing, what does that tell you about that specific tower?
That it was working.
Going on again, so you've explained a little bit about cell tower and or cell phone and how it works, and you mentioned cell towers. What are cell towers or antennas?
Yeah, so obviously our cell phones don't have wires going out of them to make calls and text or do whatever we want on our phones. We can connect to the cellular network. We do that through cell signal, which connects to an antenna, which is usually on a tower, and then through the network infrastructure, the call or the data transaction directly through a score and then handle however you need to handle it. So the tower can be anything that has an antenna on it.
Have you created a demonstrative exhibit to show the ladies and gentlemen during the jury what a cell tower is?
Yes.
Would it help in explaining and the understanding of the testimony?
Yes.
Okay.
Judge, we're gonna object before she publishes it to the jury and maybe go sidebar.
Yes. All the items that are actually received in evidence would go back and move to the jury room for your consideration during your deliberations. This is to assist the witness in explaining or illustrating his testimony, these demonstratives. All right, Counsel, you may proceed.
Thank you. Okay, especially the accountants, could you explain to the ladies and gentlemen of the jury what we're looking at in this photo right here?
So this is just a generic example of what a cellular tower can be. Here you see it antenna arrays mounted on a monopole, so there's a big hole that you see everyone's driven by these. And so you'll see that there's, on the image on the right, there's two triangular shapes. Each of those on each side, if triangle shape, there's multiple pieces of equipment mounted on them. So that would be a cell tower example that has three sectors or antennas pointed in three directions. So each of those sides that has multiple pieces of equipment, those are transmitters and receivers. Can I
I just about to tell you that it's a touch screen, so if you touch it, you can draw on it as well.
Fantastic. So all of these would be part of one sector, one side, all of these are part of one sector, and all of these. So this would have three sides. And you should think about like what these are doing. If you wanted to imagine that it's like a flashlight, because of the light cell signal, all part of the electromagnetic spectrum, and the same characteristics and properties, right? So this would be like somebody standing on top of the pole with a flashlight pointed in one direction, sending light that way. And this side is a flashlight pointed in another direction. This side is light going in another direction. That way, there's light or cell signal going in all directions to service, in this case, phones that are within the coverage area of the tower.
So you mentioned a little bit about the coverage area and the three-sided. Going on to what's on page 4 of the demonstrative exhibit at this point. You explained the flashlights and things like that. Can you demonstrate again on this particular image, the sector 1, sector 2, sector 3, and why that's important?
So this would be, as we were discussing further, like further drilling down into what this example of tower could be. So here again, with the three-sided tower, and you'll see that each side has a particular direction that that flashlight is pointing. The antenna sends signal. That will be recorded in the tower list by something called an azimuth. So in the records that we'll have for the phone we just talked about from T-Mobile, it will say the azimuth is 0. And what that means is that the flashlight is pointing 0 degrees, like out of compass. And that will be when the coverage is the strongest, like that's the center of the beam, but it creeps out. And so it will be will cover approximately 300 to 60 for 120 degrees on that side. Each side, if we have three, would be divided up like an eye to cover 120 degrees. That way we'll have 360 degrees of coverage for the timer. Towers don't have to be three-sided, they can be six-sided. They can be one side that covers 360. It's up to the network engineers who build out and optimize the network, what they want to create based on what they need to. But the most common type is three-sided tower.
Is the information as to how many sides on any given tower something the FBI captures and takes note of?
The providers provide that to towers.
And is that provided to the FBI?
Yes.
Is that done and updated so it is at the time of whatever the records are created?
Yes.
Could you take those same records that you were given and look at the towers that are working today and make an analysis?
No, so whenever you do the analysis, you have to make sure you're using the tower that corresponds to the time of the records because networks change over time.
And are the azimuths, is that always part of the records that are given to you on each tower?
Yes.
When you pick up your phone and you make a call, what determines what cell tower the phone uses?
So the phone picks the tower that's going to connect you for its initial connection. The way that does that is even as friends with them right now, so we're sitting here not using them. The phone is still scanning the environment. It's constantly looking for signal strength, signal quality. The phone's going to identify the tower, the sector. When I say sector, I mean the tower and an antenna that offers the clearest, strongest signal. When the phone wants to make a call or send text, that is the antenna, the tower that the phone is going to reach out to. So that's very important for what I do because that means that when the call is initiated, it's not based on the network or something. It's based on what the phone sees. It's based on what the phone sees as the tower that is the clearest and strongest signal.
Does the phone always use the closest tower?
No. The phone always uses the tower with the clearest, strongest signal. Usually, or often, that is the closest tower. However, there's other things that can determine what the clearest, strongest signal is. For instance, line of sight. If the closest tower is doesn't have a clear line of sight to the device, then you may use the phone, maybe use a tower that's slightly further away, but there's the signal strength and signal quality are better from the antenna with a direct line of sight, for instance.
Are all the antennas and cell towers, do they look like the ones that we showed in the previous slide?
No.
What does a cell tower look like?
Yeah, whatever the companies want them to look like, right? They, that's a good one because it's that I use in this because I identify that as a cell tower, but I'm sure everyone's seen antennas that look like various flagpoles, antennas that are mounted on the sides of buildings, up here on the roofs of buildings. It can be small antennas that are just on the tops of street lights or they look like anything.
In terms of the general direction that the cell tower antennas are pointed, are they at 90 degrees out or are they angled downwards towards the majority of the phone?
Usually they are tilted down.
If you saw an example of it picking a cell tower that's further away, would you look at the records and try to determine why that happened?
So yeah, I see a red flag or something to me that stands out and it's being atypical when I'm doing my analysis. Usually I'll look further into it and say, okay, why is this not connecting to one of the towers that I expected it to?
So we've described the CDRs and the information that's used on those. Is that the same you did for each and every phone in this case?
So we were looking at the time advance reports, the engineering data, the CDRs, the quality detail records are different data sets.
And just explain to the ladies and gentlemen of the jury what's the difference between the timing advance, the engineering reports, and the CDRs.
So the CDRs, or the call detail records, are records of the phone's communications, like calls and outgoing, certain types of text messages, etc. That will say date and time, the numbers involved in the call, the tower, the azimuth, etc. But it doesn't have the extra information that the engineering report does. So call detail records, which looks like billing records that you usually see with your phone if people actually look at their phone records. But it'll say tower and sector in addition to it, but it won't say distance from tower, it won't have longitude coordinates, or all the extra information in the time advance report. The other really important thing to delineate between those two is, I just said that the phone picks the tower that it uses based on its measurements. And so call detail records, the tower that is used is picked by the phone. It's that first connection. In the time advance report, the engineering data, that's the network's perspective. So that's what the network is seeing behind it. And the tower that's listed in the engineering report may not be the certain cell. It may not be the tower with the clearest, strongest signal. It could be, but it could also just be another tower within the network that's on that phone and say, hey, I see you with the rest of your device, something this far away. So it's important to keep in mind what type of report you're looking at because obviously it affects the conclusions that you're doing.
So in terms of the way you illustrate the difference between a tower being used or a sector and a time in advance or the distance on that, I want to make sure it's very clear. What we're looking at right now, what does this illustrate when we see just a round circle in your report?
So this will illustrate the tower that I'll use, or if it's from a data report, the engineering report, the tower that is registered as this scene. All the green dots in the middle of this graphic, those are all cell towers, and you'll see that there's one tower in the center of the map that has a blue circle around it. So that would be the tower that the phone connected to. That's not, it's not like if you're using Google Maps and you're just seeing a blue dot. When you pull that out, this is not the location device, this is the tower.
Okay, and can you just, so it's clear, point out a couple of the towers that are on this map and just highlight them so it's clear what you're talking about. Because sometimes the color doesn't come across right on the screen.
So these green dots would be other towers that weren't used or weren't, that didn't see the phone. This one here in the center of the blue circle would be the tower that was listed in the report. And then this big blue circle, it's not a coverage area, that's not saying that, hey, the phone has to be somewhere, then you're just flagging that as saying that is a tower that was listed in the report, that's the tower that was used over a cell phone.
Is it your testimony that the phone is definitely within that circle somewhere?
No, definitely not.
Why not?
That's not what this is intended to do. This is just intended to show this is the tower.
So now we're going to go into the cell site. How would you indicate that in your report?
So cell site, tower and center, or tower and antenna. This is showing the direction that the flashlight is pointed. So these, this wedge or slice of pie, or however people like to think about it, that will show the direction the flashlight's being. So the azimuth, the center line would be in this case like 180 degrees due south. And then the illustration shows the estimated like ends of the coverage area. But what's really important about this is that this is just showing the direction that the antenna is pointing the direction of the. So this is again not showing where the phone is. In other words, I'm not saying that the phone has to be within this blue shaded area. I'm not saying that the phone has to be within the arms of this black wedge. I'm saying this is the direction that the antenna is pointing.
Are you able to tell anything about the strength of the signal from a tower at any given time?
No.
Why not?
It's not reflecting the records that I have.
In terms of the average signal strength, is that something you have training and experience on from the various cellular telephone providers?
That's right. No.
So is there any determination or anything that can be made about distance from a tower just based on what cell site the phone or device is using?
No, from your call detail records, you cannot tell distance.
So I want to go on to this type of illustration. If this type of illustration is used in your report, what are we looking at?
So this would be an example of the engineering data from the time of advance report. So now we see, again, the blue wedge saying, hey, this is the sector that recorded the phone, here's the direction that it's pointed, and then we have that distance from the sector. So the distance, whatever we can say this is, for instance, 1 mile. So a particular example, it be 1 mile here. And we see that it's a certain thickness of the band because the time of advance, margin of error or size, depending on the technology, can only get down to a certain distance. So for 4G, again, it's 78 meters. For 3G, it's about 234 meters. So the size of the band will depend on the technology that you're using.
So in the records in this case, what is the width of the band in your report?
78 meters.
Okay.
So in this case, what I'm expecting, based on the information from the phone, from the engineering report, is that the phone would be somewhere within this band, this like curve and shape, whatever. That's based on the data from the engineering reports saying, hey, the phone was 1 mile from this sector, this antenna points this direction. Here's 1 mile. The phone should be somewhere within that band.
With just one data point, can you narrow down where in that band it could be?
No.
With multiple data points, can you draw conclusions as to the location of the phone because of multiple records?
Yeah, potentially. So one way we could do that is meet intersecting bands. If we had another tower, could you zoom out a little bit, please?
Sure.
Like let's suppose that this tower down here also recorded a measurement. Maybe that it was a certain direction and distance, and so we had bands that intersected, and we could say, okay, I might make the conclusion the phone is in that smaller coverage area where it's where the intersections of bands are, we kind of triangulate. We could also use other information that's not related to cellular technology if there's other facts from the investigation.
Is that type of information provided to you when you're doing your analysis?
Yes.
And do you identify areas potentially of interest?
Yes.
Okay. Going on to this next slide here, what are you illustrating in this particular map?
So this shows the green dots are T-Mobile towers in the South Florida area at the time of 2018 and time relevant to this analysis or case. And the takeaways there are just there. You see in densely populated areas, there's a much higher concentration of towers, right? Because there's more people who have more devices, there's more demand of resources. The providers need to have more towers with smaller coverage areas to provide service to those devices. When you get to more rural areas, where there's fewer people, fewer devices, the networks will usually have fewer towers that would have bigger coverage areas. So.
Is this map fairly and accurately depict the towers that were in South Florida in October of 2018?
Yes.
So going on to the areas of interest. If we can identify the ones that are listed here, I'm going to start with 805 Northeast 4th Avenue in Fort Lauderdale.
So that's shown in the upper right portion of the map with an orange flag and white letters and E on it. That was a location, all these locations are provided by the detective who requested that analysis. That was one of the locations identified.
And how do you plot or map these locations?
With mapping software, being part of mapping software school maps.
And does that fairly and accurately depict the locations of the items of interest that are provided to you?
Yes.
So moving on, so you have a crime scene with coordinates on it.
Yes. So
Is that again provided to you by the detective?
Yes.
Next, reported shooting. How would you identify that on the map and point it out, please?
So the reported shooting location is a blue flag with a little eye in it, shown here on the map, sort of, I guess, in general in the lower left.
Okay. After that, there's Memorial Hospital is your next. How is that identified on the map?
Yeah, Memorial Hospital, 1901 Southwest 172nd Avenue here in North Florida. It's shown on the map with a red square and a white H.
Okay. Next location is labeled as McDonald's. Where is that on the map?
McDonald's is 17001 Miramar Parkway, Miramar, Florida. That's shown with a red circle and a yellow hat on it.
Okay. And Sunset Lakes is the next one. If you could point that out.
Sunset Lakes is located at 18513 Southwest 40th Street, Miramar, Florida. That's shown on the map with an orange flag that has the white letters SNL.
And so last but not least, the Montessori Academy.
Yes, the Montessori Academy, 19200 Pines Boulevard, Pembroke Pines, Florida. It's shown on the map with an orange flag that has the letters M&A in white.
Are those locations that we just discussed consistently plotted throughout the rest of the mapping that you do in the case?
Yes.
So I want to go to the phone number 772-713-9807. And then the phone number 954-248-9081. Do you know who either of those phone numbers belong to?
Objection, outside of scope of knowledge.
Excuse me.
And hearsay.
Yes, sorry.
So the camera didn't move, so it's gonna be a little difficult to figure out where the audio picks back up. Okay.
Okay, so Tom, you may answer the question. Do you know who any of these phone numbers belong to?
I don't know. I know the detective treated on this.
Yes, I'm sorry.
We'll stop it right there. All you know is that somebody told you.
Right.
Okay, so I don't want to get into any of that. I just want to know what your personal knowledge is. You don't have any personal investigation or knowledge as to who these phone numbers belong to. Okay. And you just know that the phone numbers that were provided to you.
Yes.
Okay, and the 772-713-9807, that's the same one that we discussed in State 28 that I published
Objection,
earlier.
Your Honor. He also testified that he never saw the document before, so it's outside of scope of knowledge.
Sustained.
Thank you.
So with regards to the 772-713.
Objection, Your Honor. She cannot leave it up there
Speaking
published.
objections,
She's
Your Honor.
tainting the jury.
Just take it down, please.
So 772-713-9807, that specific phone number on that, and I taught in the 954-248-9081. Between 3:20 a.m. and 3:57 a.m., did you analyze the data for both of those phones?
Yes.
And if you can tell the ladies and gentlemen of the jury what this data is showing and explain it to them.
Sure. So the several slides like this in the report. So we'll talk a little bit more about this first one so everyone understands. which the slide says. At the top, it says the analysis of the two phone numbers that conducting analysis for. It says the time period that I'm analyzing, so October 26, 2018, 3:20 a.m. to 3:57 a.m. And then the bulk of the slide is the graphic, is the map. You see all the green dots all over the place. Those are T-Mobile towers, like we talked about before. And then you'll see that certain towers are highlighted with a circle showing that those are the towers that saw the phone. Some circles are red, some circles are blue, some circles are red with a blue perimeter around them.
And so I'm going to kind of zoom in up here on this top section, the 3:20 a.m. If you could just show some of the red with blue circles and then the blue and red on that.
Yeah, so there's an example of a red circle. And what that means is that you can call it, since it's hard sometimes to remember, numbers which call it the red phone and the blue phone. So the red phone was seen by that tower, and that's why there's a red circle there. Here, the network saw the blue phone on that tower. Here's an example of a tower that saw both.
Judge, may we approach that part, please?
Thank you. Let the record reflect the jury stepped out. Counsel ran along with the defendant. Witness is also present, the state's present. All right, so I don't understand. You're saying you didn't have this report?
So we got this report this morning while I was sitting in the courtroom. We don't have a printer here. So I asked the state to do the professional courtesy and give me a copy of the documents that she's using for this testimony. I'm trying to refer to what she said. She gave me 7 pages, by the way, which we started, and I was objecting to it being published because it still had the names in. She said, I'm not using that first page that I handed you, I'm using every other page. So I'm looking at the pages to try to go along with what she's showing. And I'm noticing she gave me a report from a whole other phone. All I'm asking is to give us the actual documents that she's showing the witness. And to say I emailed it to you while we were sitting in the courtroom is a little disingenuous because I don't have the printer to be able to print it out. So I just asked.
So you have the report, all 3 reports, but the reports that you have that were generated to you have the phone number as well as a name. It's identified that the phone is associated with.
No,
correct?
She redacted that.
No, but you have the 3 reports.
Yes.
Discussing the phone, and you was given those reports some time ago, and yesterday your objection was made that it's it's conclusory as to whose phone it was, and I sustained that objection, told to redact the name.
Yes.
Correct?
Yes.
And you're telling me you don't have the form of the reports with that redaction of these maps or whatever they are, with the names being redacted. Is that correct?
So I have it in email, but I'm asking for paper form so I can follow along.
Understood.
Yes, that's exactly.
Thank you. So can you make copies of those?
I have printed, I found all of them. If there's one that she's missing, I'm happy to do so and pull them up again. I printed them all this morning.
Counsel suggesting she doesn't have them, so I just want to make sure she has
Of course, and that's not a problem. So they've all been turned over via email. This is all in there, the original copies as well that were provided.
Counsel does not have the ability to print something out in the courtroom now. She's asking counsel for Liberty's asking for a copy of it. Let's provide her a copy of it.
I'm happy to do so. I just need to know exactly which one she says she's missing and which one she says she has. I don't want to have to duplicate them if possible.
None of the documents she's published
So just do me a courtesy, just print all of them out.
Sure.
All right?
Should we take a break while the jury's out?
We can, but can we finish this first?
Oh, yes, I thought you were finished.
You're gonna make copies of all the documents.
So she has in her hand some of them already. So I just want to make sure I don't double print them.
Double print.
On that. So
Counsel's suggesting she doesn't have them, so let's just print them all.
Okay, well, she does have some, just want to make sure.
For the record,
I don't know, you're saying you're saying counsel suggesting she hasn't received those things. I just want her to get copies of it. I don't want your constant back and forth. She has it, just give her the copies. That's it. It's easy. Just get her the copies. All right, Mr. Devich, any rush break?
Yes, sir.
All right, we're in recess. Thank you.
You gave me a so you're going off with 907 and nothing on it.
All right, welcome back, everybody, and thanks for coming back to Law and Crime. The Broward County jurors are in a morning break in the trial of Florida versus Jamel Demons. This is the rapper better known as YNW Melly. He's accused of double murder for the 2018 shooting deaths of his two friends. And as we wait, and want to go back to a little bit of what happened yesterday, where a detective with the Miramar Police Department took the stand. This is Jonathan Zeller. If you haven't seen this testimony, let's take a look.
Detective, how are you today?
I'm good, thank you.
Good. Where do you work?
I work in the Miramar Police Department
How long have you worked in the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009.
Prior to going into the homicide unit, what other hats have you worn for the Miramar Police Department?
Several. One in particular is the digital forensic examiner.
Okay, what is a digital forensic examiner?
So what I do is we'll stick with the cell phone, the cellular phones or devices that I do the extraction and analysis for.
And when you're doing an extraction, can you explain to the ladies and gentlemen of the jury what types of software or tools you use to do an extraction on a cellular telephone?
So what we use is a software and hardware from a company called Celebrate. And this is specific for conducting extractions of cellular devices.
And approximately how many different trainings have you taken in the use of Celebrate systems?
Taking a few, usually consistent of 40 hours of class training and exercise, and obviously the exam as well.
What about you taking training with the task team of the FBI?
I have.
Have you taken, you said you also.
I don't think we have color printed in the back of my office, so it's not something I can do regardless. All right, let's get back on the record. I understand, well, first of all, the record reflect the presence of the defendant, his counsel, assistant state attorneys. We're still waiting for the state to provide certain documents to defense counsel ID. Some maps that were being used as demonstratives. Counsel sidebar suggested that she didn't have them. They were emailed to her, but she doesn't have hard copies, and everybody wants the hard copies. I have instructed the state attorney to go ahead and do that, provide those hard copies, and that's in the works because the printer can be quoted. It doesn't seem to be working. So while we're waiting on that, let's go back and talk about the discovery cutoff that counsel suggested he wants. What's the state's position on the discovery cutoff?
That if there is anything that counsel brings up with regards to the witness that suggests additional analysis or anything that can be done, that the state would do it on that.
So you're opposing it.
Yes, Your Honor.
Anything else that you want to be heard on regarding this discovery code?
Yeah.
Anything the defense wants to be heard?
Yes, sir. I just started to do some research, and quite frankly, I've only candidly found a case. It's in the 4th DCA, but it concerns a civil matter. And it speaks of the need for a discovery cutoff to avoid the very term I use, ambush and surprise. And that when a party conducts itself in a way as to ambush there not to get the benefit of that. These trials, we understand, life goes on beyond trials. So the evidence that can be introduced into a trial should have some finite and determinable parameters. The notion that the state comes here and asks jurors to put somebody to death suggests that they have completed an investigation that warrants that co-signing, co-signature. To suggest that, okay, there are a lot of things that we could have done and we didn't do, and if you ask about it, we're going to go do it and introduce it while the proceedings ensue, is not only an ambush, but it's an insult to the process. They're saying that they have the evidence. Now, the state can get up there and say, hey, the defense is making some ridiculous cross-examination and we don't have everything because what we have is enough, which is when they bring an indictment of this nature, or any indictment, they're saying we have enough now, beyond a reasonable doubt. But what they cannot do is, as these proceedings go forward, continue to investigate and plug holes that we reveal to exist as the process goes on until this case goes to verdict. I'm not quite sure when this would end or how there is even a gatekeeping function of the court if there is no gate and there is no fence and there are no lines and no parameters of propriety. The state is making a representation by bringing this indictment that they are ready and they have proof beyond a reasonable doubt. And if that proof beyond a reasonable doubt also includes areas of investigation that were not pursued, then they should explain to a jury why it was not pursued and why the failure to pursue it does not undermine their case. They don't get to keep plugging holes as the proceedings go forward. And so, as the Fourth Circuit said, that is ambush. And the purpose of, the Fourth DCA said that is ambush. And the purpose of a discovery deadline is to avoid surprise, avoid ambush, and a party that engages in that ought not to get the benefit of it.
Thank you.
Thank you.
Hold on.
I just briefly mentioned that defense isn't yet to provide any reciprocal discovery, but alluded to some yesterday, that they were looking at Instagram posts and everything that happened as recently as this week, but yet they have provided nothing to the state. So if there's any deadline of any sort that needs to be imposed on both parties.
Thank you. Oh, Counsel, my understanding is that's the way it works, is that it's not, we're just in violation by both sides, doesn't come just from the side, it's deadlines by both sides. And there's the obligation to that's not what we're talking about.
We apologize if there's a second I'm sorry.
I apologize. What I'm saying is that the whatever obligations that are imposed will be applicable to both sides when the discovery cutoff or not. My thought is that the discovery cutoff, you can keep investigating the case, however you feel fit, and you're more than welcome to do that. However, that doesn't mean that anything you find can be used at trial as evidence. This thing with Mr. Moretti, where when I'm out of town on vacation, you're asking the detective what he's offering. I'm not really sure how it happened, to continue and run this through another process. And the defense doesn't know about it. The defense cross-examines Mr. Zellner, or Officer Zellner, and is not aware that he's asking questions about other programs. His understanding is there isn't any other program, but you know there's another program that have access to it and they've done it. You just don't have the results. That seems to me to be what the council's talking about. And it seems to me to be a Richardson violation. The discovery that's ongoing, you know about it, and you're not telling them about it until we're here. So as far as Mr. Moretti is concerned, I think that's a discovery violation. And I'm finding it to be a discovery violation. I think the only way it can be cured is he's not going to testify about the second procedure that's not coming up. Same thing, if you want to keep investigating the case, you can do it. You can find exculpatory information. You may change your mind as to how you proceed with the case, and I don't have a problem. You investigate whatever you want to investigate. But as far as using new discovery that you're coming in, I think a cutoff needs to be happened, because this is what's going on. We're gonna have this. If you find something new, there's a whole, as counsel describes it, that then you try to find evidence to plug up the hole. That's new discovery. Defense doesn't have an opportunity to depose the witness. Defense doesn't have an opportunity to do X, Y, and Z. And that's just not the way it should be. It shouldn't be done by surprise. So
it's clear, this was not a new item. This was just this, all of the information was supposed to be identical.
you found it. You had a meeting with the detective in May when we're in hiatus because I'm on vacation. All right. Had a meeting with him in May after we picked a jury. And when we're ready to, we're in the middle of jury selection. You picked it. You did it, and you said, well, he tells you, or you ask him, do you have more programs to go ahead and provide the information, and you find out there's another program, and he runs the program, does a different download with something other than Cellbrite, and therefore, you have more information. Don't make the defense aware of it. You hold that to yourself. You go ahead and put on a couple weeks of trial testimony, and then when it comes up after he, in cross-examination, points something out, you bring it up and say, well, by the way, I told him, the detective in our pretrial meeting, it came up and he has the program and we can use it and we're doing it. All right. And, but you don't tell him about it. You just go ahead and hold it, keep it close to the vest yourself. Don't explain it to him. And then you say, when it comes up at trial, say, what was it? I don't have the report yet. That's why I didn't turn it over to him. It didn't disclose it's coming. It seems to me that's not what's supposed to happen. Not supposed to happen, period. That's a discovery violation. Okay. So as far as the detective ready, and whatever other form he used, that's not coming in.
Okay.
All right, that's the sanction. If you have other information, other discovery that's in the works, you better share it with me, because right now, if you don't have it, they're not aware of it now. It's not coming in unless there's something extraordinary that pops up. And just because, you find out they have additional capabilities and you want to go retest something, that's not extraordinary on my way of thinking. I'm not familiar with what the case law says. It just seems to me that this is a fundamental fairness thing. You have evidence, you need to turn it over to him. If you didn't turn it over to him, you can't use it. That's really the basic.
Understood. And so everything has been turned over. That was the only item of which there was additional investigation done on to see if there was any other information or anything else that came out. It was reported to me that it was identical in terms of the information that was done through Gray Key versus Cellbrite on that. So defense counsel is attacking the veracity of the Cellbrite program on that. So with regards to that, that's the only reason why that would even be brought up. But I understand there, so we can move forward on that. I do want to address one other issue while I said to the jury. Counsel keeps objecting to publishing of items that are already in evidence and making speaking objections. So just ask if Your Honor could address that specific issue, because the state can publish the items that are in evidence in the presentation of their case, and the defense can object if there's something that has not been admitted or something to that effect. But in terms of the speaking objections and things like that, those are proper in front of the jury.
Okay. All right, no speaking objections. When do you expect this documentation to come over?
I think the printer just started working,
And I provided it to Ms. Liberty.
Do you have those, Ms. Liberty?
Yes, confirmed, Judge.
All right, ready to proceed?
Yes, Your Honor.
Defense?
Yes, sir.
Bring the jury.
Jurors entering.
Judge Jones, thank you. Please be seated. Let the record once again reflect the presence of the jury, both defendants, this counsel, the state attorney. Our witness remains on the stand. Counsel, you can continue with your direct examination.
Okay, so we had left off, we were talking about the red phone and the blue phone. And just to remind the ladies and gentlemen of the jury, what is the red phone number?
So that is, listed at the top of the slide, is 772-713-9807.
And then the blue phone number?
The blue phone number is 954-248-9081.
Okay, so going back, you have a little green box with the numbers 154-129-11. What is that?
That is the name of the tower and the sector.
Okay. And the times that are listed below, what are those indicative of?
So there's a time that says 3:28 a.m. in blue, it says 3:28 a.m. in red, and that is the time from the records that the blue phone and the red phone each respectively connected to that tower.
So based on what you're showing here, what can you tell us about where the blue phone and the red phone were at 3:20?
So generally in the area around New Era Studios.
Okay. As you're moving across the slide, what are we looking at?
So we see a series of towers that the red phone and the blue phone were observed by as they move from east to west. So you see there's a line of towers generally in this area, kind of along 595, I-75, and then the last ones at the end of the slide are the west, kind of by the intersection of the tower that's near the intersection of Pines and the US 27, the tower is 63035, sector 15 at 3:57 a.m. That tower saw each of these phones.
So I want to make sure it's clear when you're the 3:20 a.m. that's on the right side of the screen. Can you kind of show in order the way the towers are plotted?
Yeah, so I didn't know the time for each tower because then it would be just a mess of boxes on the slide. But generally, these towers in the northeast, and then sequentially or chronologically, as time went on, these towers were used. This tower was used later, that tower, and this tower, and that tower. And so as time went on, from 320 closer to 357, these towers were used.
And based on your training and experience, what does that tell you about how the phones were moving in relation to one another between 3:20 and 3:57 a.m.?
Yeah, so in my opinion, that's consistent with the devices moving generally together.
So you mentioned that there are some in which there is red and blue together. So I want to focus in. There's one here. It looks like at the intersection of Flamingo Road and I-75, and 595 rather. The red with the blue. What does that mean when you have them overlaid like that?
So that tower saw both the red phone and blue phone.
Okay. Is that at the same time, or are they at separate times?
Could be either.
So going on to the phone of the 772-713-9807, what are we looking at this slide titled 3:47 a.m.?
So this is a plot of timing advance data, and it shows that two data points basically from the engineering report. The tower 64337, sector 2, the point south, recorded the red phone at two data points, one at 3:47:13 a.m., one at 3:47:14 a.m. And the measurement that was of that phone at those times was 0.24 miles from that one.
So you said it's two different times, but it's the same measurement. How do you explain that to the ladies and gentlemen of the jury?
That's just what the records recorded.
Okay. And in terms of by having two data points, are they going to be in the same exact spot?
Well, it could be or it cannot be. So the 0.24 miles from the tower is this red arc here. And I guess your question is the phone in the same spot or not? I don't know. Those are two data points close in time. They're separated by 11 seconds. So the phone certainly could be stationary. The phone could also be moving. For instance, at one point it could be here, and the other point it could be there. There's both possibilities, and you can't get our influence there.
And in terms of you don't have any cameras if it's stuck at a red light or anything like that?
I don't.
So that was the 772-713-9807 at 3:47 a.m. Okay. Moving on to the 772-713-9807 from 3:52 to 3:53 a.m. Can you explain what you're illustrating and the data shows on this slide?
Okay, so this shows two data points, both using the same tower and sector, tower 151, 685, sector 13. And the first data point is at 3:52:58.
Okay.
That's this arc here. That's 0.58 miles from the tower. And then 50 seconds later, at 3:53:48 a.m., the arc is 1.16 miles from the tower. This other arc.
And in terms of the distance between the two arcs, what is that amount?
It's a little bit over half a mile,
And the time frame in between those two arcs is how long?
about 50 seconds.
Based on the records and that you have, can you give a information as to where that phone was along those arcs?
Based on the records that I have.
Yes. Based on other additional information that was provided to you, can you make a determination as to where it's more likely than not the phone was?
Yes.
And where is that?
So the phone moved half a mile in 50 seconds. That's consistent with vehicle terminals. It's too fast for a phone to move. That's 30 miles an hour. So there's a couple places that the phone could be logically. For instance, it could be going east to west on Pines, it could be going north to south on 184th. There's both options. There's a data point that's provided to me. That reason for this analysis was I was asked, hey, the detective recovered some video footage from Montessori Academy that he believed these devices might be in a vehicle that was seen driving by around this time. The detective asked, is this cell data consistent with these devices being in a vehicle? In my opinion, yes.
The data points that we're looking at, are those the only data points that exist in this case?
No, but these are the data points that from 352 and 353.
No. So going on to now the 772, 713, 9807, and 954, 248, 9081. That 4 a.m. to 4:03 a.m. Can you describe what information is contained here?
So both phones were seen in the same tower and sector, tower 63035, sector 15. At 4 o'clock and 36 seconds, the blue phone was 1.45 miles from the tower. We have two data points on the red phone, one at 4 a.m. 54 seconds, one at 4:03 seconds. The red phone was reported being 1.5 miles from the tower, 1.45 miles from the tower.
So when we're looking at here, this purple area, why is that?
Because the red and blue phones are both, they are red and blue mixed purple, so.
Just in case anyone's colorblind. With regards to the locations along this arc, can you narrow down in any way where the phones are along that arc?
Now, from the cell records, I can tell us that there's something there. Yeah.
And in terms of if you're looking at it in the totality of the circumstances based on the other records and information that you have, can that help and assist you in rendering an opinion as to where the phones are located?
Yes.
And where would that be?
So the red flag depicts a crime scene that the detective told me about and asked, is it possible for these devices to have been in the crime scene? In my opinion, yes. The data is consistent with these devices being near the crime scene at this time.
Okay. So going on to the 772, 713, 9807 phone at 4:06 a.m. What information or data are you showing here?
So this shows the red phone at 406.22. There's a data point where it's back on tower 63047, sector 3. It's 1.02 miles from the tower. So in this band here.
Okay, and in terms of where it is along that band, can you give a more definitive answer?
From the cell phone records alone, no. The reason for this slide, this analysis, was because the detective had video footage from Montessori Academy again at a certain time.
Objection, Your Honor, hearsay.
Sorry, repeat your question.
So based on these records, can you say where the phone was along that band?
And your objections are called for hearsay?
That wasn't the same question, Judge.
Thank you. Proceed. You can answer the question.
So based on these records, can you say where along the band it was?
No.
Was other physical evidence provided for you to review?
I don't think I saw physical evidence, no.
Okay. So going on to the next slide, the 772, 713, 9807, and 954, 248, 9081. If you can explain what we're looking at on this particular slide.
So this is a series of data points on 3 different hours to both the red and blue phone between 4:17 and 4:23. We're starting back on the left side of the slide. Where at 4:17:43, the blue phone is 1.21 miles from this tower. Shortly after that, at 4:18:02 a.m., the red phone is 0.87 miles from the tower. Shortly after that, at 4:20:50 a.m., the blue phone is 1.02 miles from this tower. Then after that, at 4:23:22 and 4:23:55 a.m., the red phone is 0.29 miles and then 0.68 miles from this tower.
Okay, and in terms of what can you tell about how the phones are related in direct in distance from one another based on this slide?
Distance from one another. Well, both phones move north and then east. We know that the blue phone and the red phone both over here, and now they're over here at the end of the period.
Can you have an opinion as to whether or not they separated during this time frame?
During this time frame?
Yes, 417 to 423.
I don't know. To me, I don't think there's enough data here to form.
Okay. So going on to the blue phone, 954-248-9081, 4:40 a.m. to 5:52 a.m. What data points and what information do you have on that phone?
So there's a lot of data points, many data points for the blue phone during this time period. All the timing advanced bands were 0.82 or 0.87 miles from the tower, tower 62492, sector 3. Each of those bands, the 0.82 miles and 0.87 miles are shown here.
Okay. Does that phone then, that's all the data that you have for that particular blue phone?
Right.
Okay. Now to go to the 4:40 a.m. for the 772-713-9807, where does your data show that phone to be in the area of?
So at 4:40 a.m., at this point, the phones are clearly separate. At 4:40 a.m., we have two different types of data points that apply here. At 4:40-31, we have time advanced data, which shows that the phone is 0.5 to 8 miles from this tower. And then at 4:34 a.m., the red phone makes an outgoing call using that cell site for that tower in sector 62407, sector 12.
Okay, and the outgoing phone call that is made, is that identified from the records?
Yes.
And what is that? Sorry.
That is a outgoing call to phone number 954-376-9158.
Okay. Does the red phone ever coincide again with the blue phone on the same arc that covers the hospital?
No.
So that was the first analysis that you did. Did you do additional ones?
Yes.
Okay. So I'm going to move on to the sprint and records and analysis that you did. Counselor, your favorite one? So with the sprint records that you were given, did you have the same measurement or distance data for those phones?
No, we have a similar report, which is the time in advance. Brent calls it protocol measurement data report. It's formatted differently. It's a different network, it's a different company, but it has generally the same types of information contained in the report.
Okay. If there was going to be a distance in this report, where would it be shown?
It would be shown in column I.
Column I?
Yeah, just title distance in miles.
Distance miles there. Okay. And to be clear, we're looking at the records here for 954-371-7895. Did Sprint provide the distance for column I at any point between 3 a.m. and 3:57 a.m.? Sorry, that's column 163. Was there any distance provided?
No.
Okay. The 164 column, or row 164, row 60, 166, 167, and 169 was distance provided by Sprint at that point.
Yes.
Are they from a different manufacturer or vendor of cell tower?
Yes.
Okay. So based on, and so on this, the state would also publish what's been previously admitted as state 63. And for the record, that is the 2018-22-1418-6155597 customer service management screen of Chris Thomas. And the second one this published is the customer service management screen of Dontavius.
May we approach?
Sure.
I think the feed will come back up pretty quickly. It's a little hard trying to guesstimate where it is. I don't want us to miss out on any of the details, because if you are in the chat, CB is going to hold you accountable. Okay. So I just want to make sure we don't miss anything, and that we're able to absorb as much as we can. Here they go.
And so now also publishing the 2018-221418-6155640 records that have been previously admitted into Sprint and previously admitted as part of State 63. Special Agent Collins, the number that you're looking at here on the screen, 772-713-2341. Did you do analysis for those records?
Yes.
Okay. And again, for the record, publishing the subscriber information previously admitted to State 63 for Chris Thomas. Going down to the next phone number, did you do a cellular analysis for the phone number 954-371-7895?
Yes.
And for the record, publishing what's been previously admitted as State 63 with an identified subscriber of Dontavius Withers. Okay. On the Sprint records, do you do substantially the same type of analysis that we talked about on the true call data analysis?
Yes.
Okay. And do you use the same information to illustrate cell sites and cell sectors and towers?
Yes.
Okay. So again, the same demonstrative that's on what's labeled as page 3, we're still using the same symbols, the circle to represent a tower.
Yes.
Okay. Are you still using the same wedge or pie shape to identify a specific cell site?
Yes.
As to the next image that we're looking at, what does this show?
This shows the Sprint network in South Florida in the time of October 2000.
Does this fairly and accurately depict how the cell towers for Sprint were situated in October of 2018?
Yes.
And we previously discussed the locations of interest. Were those the same as in the previous analysis that you did?
Yes.
Why don't you put these all on one giant map together?
All the phones?
Yes.
Well, one, there would be a lot of phones. It could be like confusing to look at to see all the different data points. And then, so that was one of the reasons why.
Okay. So going on to the phone number, the 772-713-2341, the green phone on this, and 954-371-7895. Can you explain what we're looking at of this October 26th, 322 to 343 a.m.?
So much like the red and blue phone, this shows that the green and the purple phone both use towers or seen by towers in the Fort Lauderdale area near the flag with the NE unit. Represents the various studios. At 3:22 a.m., the purple tower seen by Sprint Tower 168845, and then at 3:23 a.m., the green phone by a different tower 32591.
Okay. And in terms of, to go back to the 772-713-9807 and 248-9081, you're showing the same or similar time frames?
Yes.
Okay. Do the phones, the green and the purple phone, move consistently together during this time frame?
During this time frame, yes.
Okay. And how can you say that?
The towers, again, advancing chronology, consistent with the phones moving together, generally south, moving west, and then south again. They were hitting the same towers, similar times through this point.
Moving on to now 3:43 to 3:57 a.m. What are you showing and illustrating on this slide?
So this is only the purple phone. And you'll see that there are several towers installed purple phone during this time period. Unfortunately, because we didn't get distance information in the report, we can't tell where in relation to those towers this device is. So you'll see that there's overlap between the towers, right? Like for instance, between 343 and 352, there were multiple times that this tower saw the phone. But during that time period, this tower also saw the phone at 348. During that time period, this tower also saw the phone at 349. 350, this tower saw it. So we have multiple towers from all different locations where the antennas are generally pointing that direction that saw the phone, but we don't have distance information.
Are there any phone calls or anything that would indicate that the phone used one of those towers as the clearest, strongest signal to make a phone call?
No.
Then going on to the 772-713-2341. Is this using some of the same towers?
Some of them.
Okay, and if we can just kind of go back and forth a little bit to explain to ladies and gentlemen of the jury, which ones are the same and which ones are different?
Sure. So I believe all three of these are the same, but the purple ones, or the purple phone had multiple other towers that were used.
Okay. So look at tower 336234-3. I'm trying to overlay them. Are they using the same antenna on that tower?
No.
Okay. Is this consistent with the phones being together?
In my opinion, this shows that the phones were separated.
So in terms of the final analysis at 3:49 a.m., you could, for the 772-713-2341 tower, if you could identify that on this exhibit, which is page 9.
The tower that recorded the phone at 3:49?
Yes.
It's this one in the center, tower 3360972.
Okay. And then in terms of the final tower, the 3:57 a.m., if you could identify that one.
That's the western edge of the map area, tower 336-234, sector 3.
So going on to the third analysis you did in this case. Did you do an analysis again for the phone number 772-713-9807, the red phone, and 954-376-9158?
Yes.
And in terms of the 954-376-9158, is that the same phone number you testified to was the phone call at 4:40 a.m. and on the 772 phone?
Yes.
Okay. So going on to those, you again use the same information to depict timing advance and cell sites and everything of that nature?
Yes.
The two phones, is it important to know what network the phone is on before you do the mapping?
Yes.
Were both of these phones on the same network?
Yes.
On this particular one, what network were both phones on?
T-Mobile.
Okay, so back to the red phone. I know these, again, fairly accurately depict the location of the T-Mobile towers of October of 2018.
Yes.
Same locations of interest, or is there an additional one on this particular item?
There's an additional one.
And what item or additional location is on this map that is different from the others?
The Toscana Apartments, 5700 Toscana Lane, Margate, Florida. It's shown on the map with an orange flag with a white letter T on it.
And if you could just circle it so it's clear to the jury where that's at.
Here's on the map. Here's the actual location.
Everything else remains the same?
Yes.
Okay. So on the 954-376-9158, the kind of turquoise phone, what information are you showing from 1:08 a.m. to 8:23 a.m.?
So this is information from the call detail records. Here data, this is calls and texts. And it shows that between 1:08 a.m. and 8:23 a.m., there are several calls and texts at the phone, to the front of the phone, using two different sectors of the same tower, shown here with two different wedges.
And so based on your training experience, do you have an opinion as to where that phone was from 1:08 to 8:23 a.m.?
Yeah, so generally in the area, it's kind of apartments.
Moving on to October 26, 2018, from 12:01 p.m. to 12:12 p.m. on this turquoise phone, the 954-376-9158. What information are you mapping here?
So here we're showing both the engineering data, the time in advance information, as well as information from the call detail records. So first, 12:01 and 12:02, the phone, turquoise phone, is in these two bands here. First, this one is a little closer to the tower, it's 0.63 miles away, and then the second band is 0.73 miles from the tower. During that time period, also at 12:01:39, the turquoise phone places an outgoing call to the red phone, 9807.
So then the next time frame that you're mapping on this location is what?
It's 12:05, when the time in advance measurement is recorded is 1.02 miles from this tower, south of it.
Okay. Going on to 12:06:07 to 12:12:37.
So during that time frame, there's measurements from two different sectors in the same tower. So we see on the one hand that there's arcs here. They're either 1.45, 1.5 miles from the tower. But also during that time period, we have measurements from a different side of that tower. They're 1.55 miles from the tower.
Okay, and in terms of the location, is there anything you can say with specificity as to where that phone was at 12:07?
No, I mean, I think that I would generally look for the phone to be someplace where the arcs are overlaid, or an area where we see both sectors, but you can't isolation everything.
Do the cell phone towers overlap in their sectors?
Yes, they do.
Going on to October 26, 12:14 to 12:20 a.m., the 954-376-9158 phone number, the turquoise phone. What are we looking at in this image?
So starting down here, south on US 27, or tower near the area of Pines and US 27, point south. At 12:14, 14 p.m., the band is 1.45 miles from the tower. Then a few seconds later, it's 1.21 miles from the tower. It's getting closer. A few seconds later, it's 0.97 miles from the tower. And then 0.48 miles from the tower. Then it's in this band on a different sector, but perhaps still close to the tower, traveling in the same direction, 0.60 miles. And then to the north, 1.1 and 1.6 miles from the tower.
And so in terms of the north to south distance of each of these bands, how wide are they? If we're looking at the north to south, aspect between here and here, what type of, remind Melly, what, is this still on a 4G phone?
Yes, yeah. So each of those arcs is still 78 meters.
Okay. Based on the multiple locations that you have, do you have an opinion as to how that phone or handset was traveling?
Yeah, I think the data is consistent with phone traveling south and north during that time.
Okay. Now going on to the 772-713-9807 between 12:01 and 12:12 p.m. on October 26, 2018. What are you illustrating with this particular image?
So at 12:01, first there's an incoming call from the turquoise phone 9158. And then at 12:01, the red phone is this band, 0.92 miles from the tower. At 12:03, it's 0.68 miles from the tower. At 12:05, it's 0.92 miles from the tower. And then 12:07 to 12:12, it's 1.55 miles from the tower.
Okay, and just to flip back again to the 12:01 to 12:12 for the 954-376-9158. In terms of, can you make any opinions as to where these two phones were located in relation to one another during these time frames?
So they're in the same general geographic area for sure. Right? They're both on the same hour, at the same time, near Pines and US 27. There's areas where there's times when their bands are approximately the same, and there's times when they're different as well.
Can you make any sort of opinion that they were in the same vehicle?
No.
Going on to the 772-713-9807 phone from October 26, 2018, from 12:14 p.m. to 12:21 p.m. What data are you illustrating in this particular slide?
So the first data point, 12:14:47, is this band here. It's 1.02 miles from this tower. The next one, 12:16:28, is this band here, 0.92 miles from the tower. Then continuing on at time, at 12:18:08 p.m., the red phone's in this band, 0.92 miles from the tower. And then at 12:18:28, 0.68 miles from the tower. And then finally at 12:21:17, it's 0.29 miles from this tower.
And in terms of that was the end of the mapping and cellular analysis that you were asked to do in this case.
Yes.
Do all of the maps fairly and accurately represent your testimony that you just gave?
Yes.
In terms of, we talked a little bit about cell phone signal and things like that. Does being in a parking garage or being at elevation change your analysis of where the phones would be?
Being a part of the television change. I mean, I don't think so. No.
If there was something that was a red flag in the data, what do you do to catch that?
If I see a red flag for whatever reason, something that doesn't make sense, I'm gonna look at it much more closely. I'm trying to figure out, okay, what is the issue? Is there an issue? And, yeah.
Was there any such information or issues that in the records that you looked at in this case?
No.
Can you ever say why a phone picks a particular tower or doesn't pick a different one?
Yes. So if we're talking about picking a call or sending a text, something called detail records, the phone picks the tower based on its readings, signal strength and signal quality. The phone always picks the tower with clear, strong signal. If we're talking about the engineering data, what the network sees, why the network reports the distance measurement from one tower instead of another, no, I don't know why.
In terms of, can you tell whether or not each specific tower was working on the evening in question?
If there's a record associated with that tower, it was working on the evening.
There's other mapping software that's available. Does the FBI use a specific mapping software when doing this?
Yeah, we have a couple different programs. I used one program.
Okay, and what is that?
ESPA.
What is that specifically?
ESPA is a program for cell site mapping.
Why do you use that specific program?
Well, it's the tool, one of the tools that we have, and they meet our needs or requirements as an agency.
In terms of just plugging the latitude and longitude into Google Maps, is that something you can testify to based on those records?
Yes.
And do you use that and those latitude and longitude that are in that timing advance data to determine where the phone was?
So I didn't use the latitude longitude to produce that report. Could I use it? Could I plot them in ESPA or Google Maps and look at them? Sure. Yeah, that's the way.
Why don't you rely on them?
I don't rely on when I'm doing expert testimony because I don't understand all the factors that go into the network driving that estimated location for the device. For investigative leads or something, I'm looking for a kit or something. I'm making a report for expert testimony. I use the time in advance to understand that.
And in terms of, is the math constant?
Yes.
Do you take into account, you mentioned the UTC time versus local time. Do you take that into account in all the records when you're looking at those?
Yes.
Does the power of the antenna or cell site affect your analysis on the speed of light and the distance from the tower for each cell phone?
No.
Okay. Can you explain what is tower loading?
Tower loaded. Like when the tower gets overloaded?
Correct.
Okay. So towers have finite capacity. There's not unlimited network resources for a phone company. So generally you're able to make calls or text whatever you want, right? Like towers generally don't get overloaded, but it is possible for towers to get overloaded. So the way you see that, I guess, would be one, if you're trying to make a call, if you've ever experienced the phenomenon where you're looking for something, like say it doesn't have to be an event where there's a ton of phones, like an unexpected, unanticipated influx of devices and people, like say the Super Bowl or something like that, and there's just an incredible demand for network resources that it's trying to Facebook Live or make calls, take video, everything. So if you've ever been in a situation where you're looking at your phone and you see, man, I have like great service, I have 4 bars, but I try and place a call, and the call just won't go through. It's because the towers might could be because the towers are loaded, you just can't handle your call.
Okay, and in terms of, would that be something that the phone would be able to see in the phone records?
So if the tower's overloaded, the phone won't know that it's overloaded, right? The phone can't see or doesn't have a view into what the network is handling, which is why your phone has identified a particular antenna as the one that offers a clear, strong signal. Says you've got 4 bars from this antenna, this is the one that connect you. It doesn't know that antenna is overloaded, so that's why when you have 4 bars, hit send and try to make a call, the call just doesn't connect, it won't go through. The phone doesn't know, oh, I should be looking for an extra antenna someplace. All it knows is that's an antenna.
And if there's no records or no entry in the records, can you analyze any of that data?
No, obviously, I'm only able to analyze the data that I have data points for.
In terms of the mapping and everything that you created, is it a fair and accurate depiction of the cell phone data and records that you just specified?
Yes.
Does it, in terms of as you're creating it, are you creating it as an expert in cell phone data and mapping?
Yes.
Do you do validation and verification of the data and the information that you're relying on?
So, through my training experience, I know that the time in advance data is very accurate. And we talked about that earlier or yesterday, where it's like that real life foundation for it. Like, yes, I've done historic cell site analysis, I've validated by finding the phone in a place where I snapped it to or see video of the person with the device at that point in time.
Here, we may approach Shankar. Okay, so back to the red phone. And these again fairly accurately depict the location of the T-Mobile towers of October of 2018.
Yes.
Same locations of interest, or is there an additional one on this particular item?
There's an additional one.
And what item or additional location is on this map is different from the others?
The Toscana Apartments, 5700 Toscana Lane, Margate, Florida. It's shown with a map with an orange flag with a white letter T on it.
And if you could just circle it so it's clear to the general jury where that's at.
Here's on the map. Here's the actual location.
Everything else remains the same?
Yes.
Okay. So on the 954-376-9158, the kind of turquoise phone, what information are you showing from 1:08 a.m. to 8:23 a.m.?
So this is information from the call detail records. Hearing data, this is calls and texts. And it shows that between 1:08 a.m. and 8:23 a.m., there are several calls and texts to the phone, to and from the phone, using two different sectors of the same tower, shown here with two different wedges.
And so based on your training experience, do you have an opinion as to where that phone was from 1:08 to 8:23 a.m.?
Yeah, so generally in the area, it's kind of apartments.
Moving on to October 26, 2018, from 12:01 p.m. to 12:12 p.m. on this turquoise phone, the 954-376-9158. What information are you mapping here?
So here we're showing both the engineering data, the time in advance information, as well as information from the call detail records. So first, 12:01 and 12:02, the phone, the turquoise phone, is in these two bands here. First, this one's a little closer to the tower, it's 0.63 miles away, and then the second band is 0.73 miles from the tower. During that time period also, at 12:01:39, the turquoise phone places an outgoing call to the red phone, 9807.
So then the next time frame that you're mapping on this location is what?
It's 12:05, when the time in advance measurement is recorded is 1.02 miles from this tower, south of it.
Okay. Going on to 12:06:07 to 12:12:37.
So during that time frame, there's measurements from two different sectors in the same tower. So we see on the one hand that there's arcs here that are either 1.45 and 1.5 miles from the tower.
Okay.
But also during that time period, we have measurements from a different side of that tower. They're 1.5 and 1.55 miles from the tower.
Okay, and in terms of the location, is there anything you can say with specificity as to where that phone was at 12:07?
No, I mean, I think that I would generally look for the phone to be someplace where the arcs are overlaid, or an area where it would be seen by both sectors, but no, you can't isolation it.
Do the cell phone towers overlap in their sectors?
Okay, let's talk about this a little bit more. So, Paul, you had brought up an interesting question to me in the
Okay, wait a minute. I might be having a slow moment here because I think I just caught up to what my mind just caught up to what we're watching. So the objection earlier about the papers not being printed off was because those had Melly's name on it and somebody else's name on it. And she was supposed to redact the names and only show basically the papers and print them off. So when the objection came, they ended up printing them off and giving them over. Okay. I think I understood that part right. But now that he's back on this stand talking about it, I'm realizing that the jury probably don't know whose phone is who. Because they no longer have a name or anything. Am I tripping? Let me know in the comments. I'm sorry to stop the view, the thread, the stream. But am I tripping?
Jury entered.
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the list of the defendant, Dennis counsel, the state attorney, ladies and gentlemen, jury, all witness, attorney, Collins remains on the stand. Ladies and gentlemen, outside the present, the state offered items QQQ, RRR, and SSS. Is that correct?
Yes, Your Honor.
All right, and they were admitted that is what's the,
States QQQ will be 65, states RRR will be 66, and states SSS will be 67.
thank you. Counsel, jury, you may proceed.
Thank you. Okay. Special Agent Collins, I want to go through on some of the timing advance records. And just so for the purposes of what we're talking about, it's row 139, 140, 141, 142, and 143 of the 772-713-9807 phone records. The latitude and longitude you mentioned, and this would be covering the times from 3:48 a.m. through 3:52 a.m. You indicated that the latitude and longitude are the first columns that are put there. And then the next column, column C, is called confidence.
Yes.
What does the confidence column modify?
It refers to columns A and B.
So is there a numerical value that's assigned to the low, high, and medium data entries in column C, the confidence?
And so confidence, it refers to, like, that's T-Mobile's determination of, based on the number of data points that they have used to derive or estimate the device's location with that latitude and longitude, refers to, or gives a confidence of what, low, medium, or high based on the number of data points.
And in terms of, do you use that in any way, shape, or form to testify to where you are placing the phone in your analysis?
No.
Okay. The question as to the difference between accuracy and precision. Can you explain that?
Sure. So precise, I guess, would be much more narrow. In other words, the latitude and longitude we were just talking about, like that is incredibly precise. That refers to like a particular point on Earth. But it may not be completely accurate. Right? There could be a margin of error in it. So, for instance, if there's a margin of error that says, okay, like I'm giving you a precise point, a particular latitude and longitude coordinates, but my margin of error is 800 meters, well, that might not be very accurate. What you're saying is it's somewhere within an 800 meter radius of this latitude and longitude point. So, I guess precise would be very small. Accurate, whether it's reliable or not. In other words, like a cell site, you use by the phone to make a call, for instance. That's not a very precise area. We're talking about a general coverage area of an antenna, but it's completely accurate. There's no denying that is the cell site that the phone saw as the cell sector that gave it clear, strong signal. So it's very, very accurate, but it's not very precise. It's the size of the coverage area.
Okay. And so last but not least, from the state would just be publishing part of state 64. The top number, the 954-376-9158, is that the cell phone that you did the analysis on? One of them?
Just one.
One of the phone numbers?
Yes.
For the record, publishing part of state 64, contact list for the phone number 954-376-9158 from the phone extraction 772-713-9807. No further questions of this witness, Your Honor.
Thank you, counsel. You have any cross-examination?
I do have a cross-examination, Judge. If you remember before court, I had asked that we take a break before.
Oh, yes. Absolutely. Motion to silence.
It's on motion.
Okay, D-Wood, I'm pretty confident that that is what happened. Like, he basically just said that those two phones were in the area of where the murder may have been.
My thought is, we just take a lunch and recess now, so do not discuss the case, don't form any opinion about the case, don't allow anyone to discuss the case in your presence, do any research. It's now, looks like 5:12, so how about we see everybody back here, 1:15. All right, does that give you enough time? Yep. All right, 1:15 for lunch. Remember, don't discuss the case, no research, just leave no notepads on your chair.
I'll say the names are on that. They don't have to remember who they authenticated the number to, like who's the owner of that phone.
And you have reflect the brief excuse, Dr. Manuel defendant. Any discuss, ladies, no?
Just returning all the evidence request.
All right, so, see you back at 1:15. All right, have a nice lunch. What's that? How do you bring them? Jury entry. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, defendants, and counsel. This is the attorney, ladies and gentlemen, of the jury, and witness, Brendan Collins, and names on the stand. Ladies and gentlemen, Judge had a nice lunch. They only broke. Counsel had not yet had an opportunity to commence her cross-examination of this witness, so we're going to turn it over to the defense now. Counsel, if you're ready, you may proceed.
Thank you. Good afternoon, Agent Collins.
Good afternoon, Ms. Liberty.
Nice to see you in person. The last time we met, I think it was over Zoom.
Yes.
And last time we met, you actually told us you were working for the terrorism squad section of the FBI.
The transnational organized crime.
Okay, and that's where you learned the tax reports as a collateral duty, correct?
No, I started doing CAS collateral duty when I was special agent working gangs, partner state youth gang unit. And then I started doing terrorism investigations as my primary job, and continued doing CAS collateral duty. Then I did CAS full time in DC as a supervisor. Then I got promoted to field supervisor, which is my current job. I exclusively.
So you're still supervising organized crime?
Yes.
Do you do any of the task work with organized crime?
No.
So do you know, if you know, when's the last time you actually did a CAS report? An actual one for an actual case, when's the last time?
This would be, so I kept all the cases that I had done previously that had been adjudicated.
Okay.
I have not taken new cases since becoming a supervisor.
And just curious, from the last time we spoke, which was about a year ago now, has anything changed with the technology that we should be aware of? Right. So you had testified earlier talking about timing events, and you said with T-Mobile they call that true data, correct?
Time in advance is the principle where the network is able to calculate the distance from a tower. T-Mobile has the brand called TrueCall that they use to do that.
And who within T-Mobile would do the true call? Is it engineers? Who would know that information?
I don't know.
So I'm gonna put up your report. And looking at this band. Oh, I do. Sorry.
Thank you, Gary.
All right, so this is your report. And we have this band here that kind of looks like, I know that's something called a hot dog. I like to call it like macaroni. But what does this band represent?
That is the timing advance band. So the engineering report, the true call report from T-Mobile would say the distance from the tower is 0.24 miles. And so then, based on the timing advance measurement, which in 4G is 78 meters, that band is 78 meters deep, so it would be plus or minus 39 from 2.4 miles on either side.
So plus or minus, so it's an estimated distance, correct?
Yes.
All right. How did T-Mobile determine? I think you testified earlier that T-Mobile determines the distance by speed times time equals distance, correct?
Yes.
All right. And how fast does that signal travel?
At the speed of light.
All right. And you testified earlier that the speed of light is a static number, correct?
Yes.
However, I tried to do the math myself because I think I'm really smart. And one of the things that I came across when I was looking at the speed of light was that it could actually be a 3 times 10 to the 8th power meters per second, or the actual number is 2.99792458 times 10 to the 8th power. So if you know, is T-Mobile using the higher number of the 3 or using the actual number with the speed of light?
I don't know.
Okay. But you would agree when we're dealing with the meters per second, that could actually be a big distance, correct?
Yeah, so obviously the bigger the distance or the bigger the time, then the more significant the distance or the difference between those two numbers would be, yes.
And just curious, would that estimate, because we talk a lot about sectors and I'll get further into it, is it possible that that estimate would change what sector you're paying off of?
It's possible.
Well, let me ask you this, because if you're dealing with a meter, if you're dealing with a meter, it's 3 feet, 3 inches, correct?
Yeah.
And if I'm off by 4 or 5 meters, we're talking about like 15 feet basically, correct? A little bit more than 15 feet.
Yeah, so I guess at some point there always has to be a transition from one sector to the other, because they have multiple sectors. So on the sector boundary, could that change? I guess, yeah, there's a possibility for that for sure.
Okay. Can you do this calculation yourself?
Which I did.
The calculation of the speed times time equals distance. Can you do that math yourself
Yes, I can.
by hand? And would you include timestamps when you did that calculation?
So I didn't do that calculation for this report. I used the distance that was in the engineering records that T-Mobile gave it produced. If they gave me the time, and we could use either 3.0 or 2.99, whatever the other number that you said was for the speed of light, I can do math if that was your question. Like for this report, I did not do that math to produce these distances.
Okay. So can you tell me about any publication that would tell us about these expected accuracy of the timing advance records?
Nope.
All right. So in your map, throughout your map, you talk about these bands and the distance from the tower. Is there any publications or any other data that you have that would explain how accurate that is?
No.
Do you know of any scientific testing outside of the legal community as to this whole cell tower stuff?
I mean, the cellular community, because this is an important part of how cell phones work on a cellular network.
Okay.
But apart from that, no.
Okay. Can you show that band as a plus or minus 10 miles, correct? Is that the width of it?
No, it's 78 meters.
All right. And could you break that down? How big would that be? If you were to compare, like, would that be a football field, 2 football fields?
No, it's less than a football field, slightly less than a football field.
So slightly less, like 3/4 of a football field?
Something like that.
And do you have any factual basis that would back that up?
Factual basis for what 78 meters is?
Yeah. No, well, the distance, the approximation of the span. You have anything that would back that up?
As to why it's 78 meters?
Yeah.
Because that's what based on how technology works, based on 4G, that's what the time advance is. And that's just what it is.
So did T-Mobile tell you this in your training, or how did you figure it out?
Yeah, from a training experience, not T-Mobile specifically, but I mean, that's for regardless of whether it's T-Mobile or Verizon, Sprint, 4G technology, the time advance is 78 meters.
All right. So is this an estimate that's being made by T-Mobile?
The distance?
Yeah.
The tower?
Yeah.
Yes. Yeah.
All right. So would you say that this is T-Mobile's best estimate and it's actually no more accurate than the call detail records themselves?
Well, so I think that in my opinion experience, generally the time advance is accurate. Call detail records are accurate. So sorry, can you repeat the question?
So I was just asking, it's T-Mobile's best estimate on this map, correct? Is it any different or any more or less accurate than the call data records, the CDR?
Well, the call detail records will have to be more accurate because they are less precise. So without a doubt, that is the sector that the phone shows. The timing advance measurement, in my experience, is accurate, but there are factors that could make it less accurate than the call detail records. For instance, we just talked about how the difference of whatever 3 100ths in math could make a difference in the calculation of distance. Earlier, we talked about how like multi-path signal bounces off multiple surfaces on the way to the phone or on the way from the phone back to the tower. Increase the amount of time that it traveled, which would then also increase the distance. So although I think the timing advance is accurate, because it's more precise, there's a potential for it to be less accurate than call detail records.
So do you know of any publications or studies that would back up your opinion?
No.
Okay, so based on that information, you can't really tell the court precisely which locations these phones are following, can you?
One of the limitations of cellular analysis is that you can only say a general area where the device would be at the time.
All right, so even with the general analysis, all of the stuff that we've gone through for about 4 or 5 hours, at the end of the day, you can never give an exact location.
True.
All right. Can you tell us if the phone is on a highway?
So that depends. For one data point, no, you can't. You just general area of the phone would be. If you have multiple data points, you may be able to infer an opinion as to where you think it is. For instance, like in this case, if you see the device traveling from east to west, the towers along 595, and you have the time between those towers, you can infer what the speed would be and say, okay, I think it's likely that they're on the highway to Central area, or they're on state 34 traveling a certain speed. But from the cellular data alone, no, you can't tell that the phone was a car on the side of the road.
So can you tell if it's in the woods?
No.
How about another residence located in the area?
No.
And could you tell if somebody was walking around a car with the phone? Would you be able to tell that?
No.
Okay. Go back to your report. So it'd be your testimony that this phone, 9807, could be from here to here, correct?
Yes.
And what was the distance from here to here?
Oh, I don't know what the distance is from one end of that illustrator to the other.
Okay. Well, can you actually guarantee that the phone is in the arc?
No.
And why can't you guarantee that it's in this arc?
So that arc estimate, or that arc depicts the time advance measurement with the time before, including the 78 years time advance, which is all the resolution you can get. Why I can't guarantee that it's there as well. One, the sectors themselves, the sector itself. So that's an illustration, it's an approximation of the sector, right? Like talked earlier about it being a flashlight to illustrate the direction that the cell signal is going. When you drew a flashlight, you draw a cone or something that looks like this. But everyone who's used a flashlight knows that it's not actually like a tube on a paper towel. It's not actually just a tube, right? It's raised here and it gets weaker and weaker and weaker. So although in this illustration, there's hard black arms that say this is the limit of the sector, that's not really the case. There's some bleed opens. So that's the first point, is that it could be, in this instance, potentially over here and over here. Second instance is, as we talked about, if there was something that delayed the signal traveling from the tower to the phone or back, that would make the distance longer than where the phone actually is. So it's a depiction of the records. But with 100% accuracy to say that the phone has to be in this band, no, I can't say that 100%.
Okay. And I did switch the page, so we're looking at your page 12 of your report. And looking at this, can you tell the court if the phone is between these two bands at any given time?
I infer, in my opinion, yes, because it had to have been at some point in time between those two bands, because it's here at 350 or somewhere within this area at 352.58 and somewhere here at 353.48. So to get from here to here, we had to be somewhere between them at some point.
But didn't you tell us earlier that you don't always necessarily connect to the tower closest to you? It's the one with the best signal. So could it be possible that this is actually the tower with the best signal and the phone is nowhere in that sector?
So this is from the engineering report. And so the engineering report had two measurements for this tower and sector, the 0.58 miles and the 1.16 miles. The engineering report does not, that's a network's perspective. So when I was talking about what they call detail records, where the phone measures the clearest, strongest signal, and then picks the tower or the antenna on the tower that offers the clearest, strongest signal, that's from the call detail records. The engineering reports is the network's perspective.
So where did you get the engineering reports from?
From T-Mobile.
So didn't you previously testify that Detective Moretti gave you these records?
Yes,
So did they come from Moretti or from T-Mobile?
from Detective Moretti.
All right.
From T-Mobile.
And so the engineering report, is it what Ms. Bradley, the state attorney, had put up previously, all these numbers and environments?
Yes.
Okay. Do you double check that report?
What do you mean?
Do you validate it? So you get this report with all these numbers. Do you have a system in place at the FBI that you could cross-reference this to make sure that the latitude and longitude and the distance is actually what it's saying it is?
No.
So, do you even know if it's credible?
Yeah, my state.
Overruled. You can ask a question.
So yeah, the accuracy of this report is like pinned on those records being accurate. In my experience, the records that we get from telecommunications providers are accurate, which is why this works.
Well, let me ask you. So, have you ever had an engineer come through on any of your cases, the 130 cases that you had, and have them validate the information that you got from T-Mobile, Sprint, or whatever carrier it is?
So I've had cases where there was actually, no, not for me. I know of other cast assets who had cases where there was a red flag or a problem, and then we contacted the engineers and said, hey, there's something that it's not making sense. We need to look more into this. But for me, no.
All right. You know of any instances in these records where a mistake or any oddity occurred?
No.
All right. So, and you already testified you did not request an engineer to assist you to review these records, correct?
Correct.
And you said that one of these bands would be a little less than 100 yards wide?
Yes.
All right. I'm going to show you this engineering report that you're talking about. Okay. So there's a section on this engineering report that's labeled environment, all right? And it goes on to tell you, and I'm looking for, good thing I didn't do the cell tower analysis, it'd be a mess, so obviously I can't handle this modern technology, but you have a section in here called environment. I just want to find where it's at.
It's a little left.
No, it's so small I can't even see it. But you know what I'm talking about when I talk about environment, correct?
Yes.
Do you rely on this?
No.
Why?
I don't know how it's calculated.
So, and it goes back to my other questioning. This document that's produced from T-Mobile, from their engineer, your engineering report says that T-Mobile can tell you if a phone is outside, inside. So why do you rely on everything else in this document, but you won't rely on that column?
So I rely on the time in advance, I guess, just because I have, well, I think it really comes down to two things. One, because I understand it, right? I understand speed of light times time equals the distance. And two, because I've done that and I've been able to validate that through my real world experience. That's why I have confidence in time in advance. When it comes to the environment and the latitude and longitude coordinates and their associated confidence level, why don't I use that? Well, I didn't use them in this report because I don't know all the factors that go into calculating those. And I don't have real world experience validating those or disproving them to myself personally, whether they would be.
So you had previously testified that in your training, you actually get invited out to different cellular companies, correct?
Yeah.
And did you get invited to T-Mobile?
Never been to T-Mobile.
Okay. Do you know if any of your cast people went to T-Mobile?
I don't know.
Okay. Can you tell us how T-Mobile can tell if the phone is indoors?
Don't know.
Have you ever performed any testing to determine if a phone is indoors or outdoors based on the timing advance records from T-Mobile?
No.
And is there any way for you to verify that environment column? The environment estimate for T-Mobile?
Yeah, if we wanted to test it, we could coordinate something with T-Mobile, or I'm sure T-Mobile could test it, where they would use test phones and do things that people do with phones, calls, texts, data. They look at the phones of the record and say, like, okay, here's our control group, and here's what the data said, and here's where the phones actually were. So is there a way to do it? I'm sure that.
We were kind of just like talking about hypothetical, because as far as you know, it's never happened. Okay. So with the true call distance estimates, has T-Mobile ever shared the calculation with you or possibly other members of the task team?
The calculations, the speed 3.0 or 2.9, 7, whatever times the time, that's the calculation.
So have they shared that with you guys? Have you gone through to find out what exact number is, how they're coming up with these formulas, anything like that?
Yeah, and that's that calculation for time in advance. Again, it's not unique to T-Mobile. That's how all phones have to function on cellular networks. They have to have time in advance measurements of all the providers.
So it's just T-Mobile gives it to you. You have 100% trust in T-Mobile and its records. So you just get them and you go off of that, correct?
I plot the data from T-Mobile and do an analysis. I don't take anything for given as I do my analysis.
But you don't know if the numbers are correct because you don't have an engineer validating or rechecking anything, do you? So
I'm taking, I'm relying on the accuracy of the records, yes.
all right. So basically, you're telling us that we're to trust an undisclosed calculation as being accurate. Right. Do you not have any of the measurements for the underlying true call data?
I don't think so. I don't know. There's a lot of columns on this engineering report. It's possible that something is there, but I don't think so.
Okay. Go back to your report. So in this report, you say that the measurements of phone number.
Just like on the phone.
Well, I'll move it up here. So your report says, you can come on the stage if you want to help me. Of course. That these two phones, 9807 and 9081, are in the area of the crime scene, correct?
Does it say consistently, but what's the?
Your language is cellular measurements are consistent with, yes, the two phones being in the area of the crime scene.
Yes.
All right. But is it not true that they could also be over here?
Yes.
And could 9807 be over here and 9081 be over here?
Yes.
Could it be over here?
I don't think so. Yes. Yes.
Or right here?
Yes.
And again, this is an estimate because it could just be pinging to the tower with the best signal, correct?
No. Because this is from the engineering report.
Okay. So page 14 of your report, you say that phone number 9807 is within this area, correct?
Yes.
But would you agree it's not actually touching any of the points of interest?
At that time?
Yes.
Yes. If you find points of interest, if you mean the locations that were highlighted earlier in the presentation, I guess it's not overlapping the one-story cabin area replaced that on.
Okay, let's turn to page 16 of your report. So does this show phone number ending in 9081 near the hospital?
Yes, that's consistent with the phone being at the hospital.
But this science is not actually precise enough to pinpoint the location of the phone, correct?
Correct.
So while you say it's consistent with it being at the hospital, you actually don't know that, do you?
From the cellular data alone, no.
Go to 17. Here you've mapped again the data for 9807. And again, would you agree that this macaroni does not touch any of the points of interest?
Yes.
explain what this means? Can you see that?
340, the text box that you're pointing
Yeah,
to?
yes.
Yes, so that means that there were multiple data points on that tower and sector between 3:43 a.m. and 3:52 a.m.
Okay, so 3:43 to 3:52 a.m., that phone number was pinging off of this tower.
So it's from the engineering reports, and that tower saw the phone multiple times between 3:43 and 3:52.
Okay, so let's go over here, and what's this mean?
The same thing, all these cell sites that are shown are from the protocol measurement data from Sprint's engineering reports, and those towers, that sector on that tower saw the phone at whatever times indicated.
Do you know the difference from this point to this point?
I imagine it's a couple miles.
So from this report, we're showing that there's a couple miles difference, but the phone is pinging over here at 3:49, but according to your report, between 3:43 and 3:52, it's pinging here. And what does this one mean right here?
3:48.
So it's pinging from this tower at 3:48,
That tower saw the phone, yes.
right? And then down here,
3:50.
so again, back here, between 3:43 to 3:52, it was pinging out of this tower, but at 3:50, it was down here.
No, the phone wasn't down there. It wasn't up here. The phone wasn't in any of those places. That's not what the data says. The data is saying that these towers at those times saw the phone. This is all from the engineering reports, which means that the towers, these towers that see them, are not necessarily the tower with the clearest, strongest signal. It's not necessarily the serving cell that saw it. If we had distance information at these times, we'd see like a band, just like we did on the T-Mobile record. So for instance, at this one, 3:49, you'd see a distance with there's a number like this or like this, whatever. The distance column on that engineering report for all these data points was blank. We don't have distance. So we know that these towers saw the phone. And we know that they were not necessarily the serving cell. It could have been, anyone who could have been, but we don't know that. And we don't have any calls on the call detail records to cross-check and say, okay, well, which tower did the phone reach out to if they need to make a call? So we're left with the question then is, well, what's this mean? Because as you we're just asking, as we were just talking about, 3:49 falls between 3:43 and 3:52. How could two towers in two completely different areas both see the phone? Well, they both did see the phone at different times because they registered that connection with the phone. So if you ask me what's my opinion, what's that mean? It's like, well, the phone was someplace where all these towers could see it. And I note that this one's pointed generally west, this one's pointed southwest, this one's pointed southeast, this is northeast, this is this way. So my conclusion would be that this data, which it's hard to form a conclusion from because you don't have I don't have the distance information I want. It's not to say, okay, the phone is generally it's in Miramar. We know that, right? It's not in Fort Lauderdale or Miami. It's probably somewhere in the middle of all these towers. So if I'm asked a specific question, like, hey, is this consistent with the phone being in Silver Lakes? I would say yes. Is it consistent with the phone being in McDonald's? Yes. I mean, this is a.
So it could be anywhere in Miramar, basically.
I don't think it could be anywhere in Miramar. I think it could be anywhere kind of in this map area. I think it's a fair statement.
Okay. At any given time as well, correct? Because I just for the sake of my knowledge, when we look at this item that says 3:43 to 3:52, so I know it's hitting that tower throughout that time, right? But it's then also hitting this other tower at the exact same time, and 30 seconds it's hitting this other tower. Is that a fair statement?
Well, the network's hitting the phone. The phone isn't in the network, but yes.
Okay, and then how far can a phone go? Is it 1 mile? Could it be between 1 mile and 20 miles? Or could a phone ping off a tower that's 50 miles away? Do you have any background on that?
Yeah, so it depends kind of what you're asking. If you're asking how far away can a phone be from tower when it makes a call, well, that depends. If you're asking how far away can a tower see a phone, which is a different thing, because the phone choosing the tower is going to rely on the phone's clear, strong signal, and that also depends. Generally, I see something in the range of like a couple miles, but I've seen in extreme cases many miles that a tower can see a phone.
Okay. So even with this is again based on that.
Yep.
Any area could be in this ping.
To try and make a conclusion about precise location for a phone on this data is not really possible based on this data.
So would it be more accurate just to show a range of where it could be at rather than trying to do these curves and pinpoint the precision?
What do you mean?
I mean, you would agree with me that there are some unknowns. Even though we're talking about the speed of light static, we don't know what T-Mobile's using. Are they rounding up to the 3 or are they actually keeping the right number, correct?
Well, regardless of what they are doing, they're giving us a distance, and that's the distance that's flying. So we plot the distance, applying the records that T-Mobile gave us, not saying, okay, the phone's, here in this bottle or something like that. Hey, this is what the records show.
Well, it seems like you're giving testimony that is precise, but when we get through the data, how it's used, that it's actually really just an estimate. So is it precise or is this an estimate that you're giving us?
I guess it's not an estimate like hey, just some number that's made up, just a ballpark pay out of 10,000 or something like that. But if you're asking, I think you're asking about really the accuracy, not the precision, because that number, like if it's the number is 0.54 miles, that's a precise number, right? That's down to hundreds of a mile. You're asking how accurate is that number? We'll say, okay, generally that's accurate. That's why with my testimony, even when I have a precise number like 0.54 miles from a tower, I still say it's consistent with it being in this location, or it's generally in the area of this apartment complex or something, because the possibility that it may not be precisely there.
So based on that map, could it be possible that you had two phones registered to the same person on the same carrier being operated by two different people who were sitting next to each other? Can those two phones ping off different towers?
When you say hang off towers, you mean are you talking about the engineering report?
Yeah, the engineering report.
Could different towers see those phones?
Yeah, so
Yes.
we're both sitting in the car here. Is it possible that it's pinging off to here and then the other person's phone is pinging here?
Yes.
While they're next to each other?
Yes.
All right. Can you tell if this phone's in somebody's pocket?
No.
Can you tell if it's left on the car seat?
No.
Can you tell if you had the phone?
No.
Okay. No further questions?
Council, thank you.
Okay.
Mayor Redirect,
Yes, Your Honor.
you ready to proceed?
So in terms of, I want to make sure we're clear and it's very clear for the jury. What's the difference between the engineering report and the call detail report?
So the call detail records show what the phone was doing, like the phone's calls and texts. So they will list a tower and a sector in them. And that's the tower and the sector that the phone identified as the one that offers the first strongest signals. That's the tower the phone chose to connect to when you make a call or send a text. That's the phone's perspective. The engineering report is a network's perspective. So different towers that may or may not be the service tower could have seen the phone.
Why is it important to differentiate between those two?
Because, so if I'm plotting doing a report, and I plot the phone that was the server, and the tower that was the server itself, then I'm showing, okay, wherever the phone was in this coverage area, it's on this is the one, the best tower, the best, the strongest signal point. With the engineering report, like the slide we were just looking at, none of those may have been the best one. So if I'm looking at something I plotted because of the call detail records, I would infer that that's probably the tower that's the closest towards the best line of sight. With the engineering data, that may not be the case.
Okay, and so in the one we were just talking about, that was under the 3717895. That phone, correct?
Yes.
Okay. So if you can explain to the ladies and gentlemen of the jury, there's discussion about the accuracy versus the precision of the records. Is this a precise estimate of which tower saw that phone?
Yes.
And how can you say that?
Because it listed, the records listed specific towers that saw the phone at a specific time.
Are you ever going to say, based on the data that you have here, precisely where that phone was?
No.
What conclusions can you draw from this map based on your training and experience?
That the phone is generally somewhere in the area shown on the map. In my opinion, it's likely to be in the center of the map here, because that's where the direction of the antennas and towers that saw the phone are located.
So council asked you about the latitude and longitude columns that are on the call records from the engineering report.
Yes.
And so you mentioned that you do not validate these particular records.
Yes.
Would they be accurate?
They certainly could be accurate, yes.
Can you explain as to, ladies and gentlemen of the jury, if you call 911, what does a cell phone provider send out to law enforcement?
At minimum, I asked us to provide the tower and sector.
Oh. And at maximum, what can they provide?
I don't know.
In terms of those coordinates and things of that, is that also collected for the purposes of location for 911 emergency?
Maybe.
You had said that And council asked you a lot about validating your findings, your records, your analysis. When you are doing the training and experience, do you validate the records that are given to you by going out and finding a specific phone in the field?
Yes.
Okay. Would you be able to validate your records with other corroborating information?
Yes.
For example, a video, would that help validate your records if the phone is seen in the video?
Yes.
If there is video or surveillance footage of locations and the phone is seen in that area, would that validate your information?
Yes.
Is, for example, on the cell phone records that have been placed in the mapping of the 772, 713, 9807, and going to the 248, 9081, 440 to 452 a.m. If that phone is found at the Memorial Hospital, would that validate your findings?
Yes.
Is cell phone technology new?
No.
How long has it been around?
Decades.
Okay. The materials and things that you were relying upon, how long have those been used?
A long time. More than a decade.
In terms of the difference between the 2.99 and 3 to the 10th, what types of difference in distance are you looking at when you're making those tiny advanced things?
So that's not a huge number, a huge difference between them. So that would be generally a small difference between the distance estimates there.
Are we talking meters or miles?
Meters.
In terms of the distance, you said it's 39 meters plus or minus each direction from the center of that location.
Yes.
The specific location that's plotted is based on the location of the tower.
Yes.
Is the tower a known quantity?
Yes.
Does the tower move?
No. I mean, they can, but as of the records, no.
With regards to publications and trainings and things of that nature that you rely upon, are you trained in this area?
Yes.
What types of resources and materials are you used during your training with the FBI CAST analysis?
Yeah, so instructors from Florida Institute of Technology who teach cellular theory, network engineering, network engineers from all the major service providers, other related fields, certain like manufacturers, the ecosystem, and also we have a lot of peer instruction as well.
In terms of if a child is kidnapped in Miami, are they gonna call an engineer to find them?
No, they'll probably call the police to look at it.
Council asked and brought up a lot of things about the distance and the measurements in the records. Is it possible to go through the CDRs or in the instance of the Sprint, or for example, the engineering report on the 9807 phone number, and highlight instances of exactly where on your records it corresponds with the records that's provided from T-Mobile?
Yeah, we could go through line by line and say, here's the map that I made, here's how the corresponding line and the T-Mobile report is.
And in terms of the records and things that were sent to you, were they forwarded with a T-Mobile email address attached to them?
Yeah, I got them on a thumb drive, and they had a certification from T-Mobile or Sprint.
Okay. In terms of, there's a lot of discussion, I'll make sure it's clear for ladies and gentlemen of the jury. When you were plotting some of these particular phones, specifically the Sprint ones, are you saying that these towers are the ones that would have been used if they were making a phone call?
No.
What are you saying?
These towers saw the phone.
Can you give any more indication on the direction or anything on that specific issue?
On the direction, you can see the side of the tower that saw the phone, but that's it.
Has this type of analysis been used to solve crimes?
Yes.
Has it been used to locate missing persons?
Yes.
Judge, I'm going to object because this line of question is outside of my cross-examination.
Overruled.
In terms of the data that you rely on, has it been validated in your personal experience and training?
Yes.
Nothing further, Your Honor.
Is witness excused?
Yes, Your Honor.
Thank you, sir. You may step down. Excuse me. Counsel, want to call your next witness?
Yes, Kurt Rhodes.
Rose, that microphone in front of you will adjust up or down, but it does not move back and forth, all right? Are you ready to proceed, sir?
Yes.
Counsel, you may.
Thank you. Good afternoon, Mr. Rose. How are you today?
I'm welcome.
Very well. Thank you for asking. Can you please introduce yourselves, ladies and gentlemen of the jury, and tell them where you work?
My name is Kurt Rose. I am a DNA analyst. I work in the BSO Crime Laboratory as a DNA analyst.
And what are the qualifications to be an analyst in the BSO Crime Lab for DNA?
I have a Bachelor's of Science degree in Forensic Science from the University of Central Florida. I completed the Sheriff's Office training program for DNA analysts. I hold certification from the ABC for American Criminalistics and Molecular Biology. And I am required to complete at least 8 hours of continuing education per year.
And so how long have you been employed with the Sheriff's Office?
I began in 2004 as a DNA technician. I went into DNA training in 2005 and began DNA casework in 2007.
Can you explain to the ladies and gentlemen of the jury what's the difference between a DNA technician, like you were in 2005, and then you transitioned to 2004, and transitioned to 2005 to be the DNA trainee?
As a technician, I would do instrument maintenance, quality control checks on the chemicals and reagents, do ordering, record keeping, examination.
So you briefly mentioned a little bit of your educational background. What types of coursework and classes did you take when you were getting your initial degree from in the sciences?
The program that I did through the UCF was the DNA-based program for forensic science. So there was genetics, molecular biology, biochemistry. There was a statistics course, mainly the coursework towards the end of the degree requirements were mainly geared towards genetics and microbiology, biochemistry and molecular biology.
So do you have specialized training using statistics to interpret DNA?
I have completed the statistics in my college coursework, and I have attended courses throughout my career in the Sheriff's Office dealing with statistics and how they relate to DNA case.
You mentioned that you're required to do 8 hours of continuing education. Is that on a yearly basis?
Yes, correct.
And approximately how many hours of continuing education have you completed since 2005 when you started your DNA training?
So again, it's at least 8 hours. Some of the courses which are mostly range from 8 hours to 40 hours. So 1 year maybe 8 hours, another year maybe 48 or even 60. It just depends on the year.
So in terms of the DNA section that you work for, what does it do on a day-to-day basis?
As a DNA analyst, I examine evidence that's submitted by investigators in attempts to develop DNA profiles from question samples and ultimately compare them to known standards to see if the individual that is being investigated or even the alleged victim would be included or excluded from the evidence that's submitted.
In terms of the DNA analysis, do you do that yourself, hands-on?
I do.
And the training that you started to talk about, you said you started training in 2005. Could you talk and explain to the ladies and gentlemen of the jury what that training entails?
It entailed readings, hands-on processing of the samples that we did, time, extraction methods, quantizations. There was written tests, as well as a mock court. Then there was it ended with a competency test to ensure that I was able to process samples appropriately. And then I was allowed to do supervised casework and then finally independent casework.
So let's explain to the ladies and gentlemen of the jury, what is a competency test?
A competency test is given to an analyst after they have completed a training program for whatever subject. It could be as simple as an extraction method or maybe quantitation method. So the laboratory would then provide a test that the analyst would conduct. They would process this test and return results to the agency to see if the results that they've gotten were appropriate for what was given.
And you have to pass these competency tests or examinations before moving on to the next steps.
The competency tests are done to ensure that you are competent in the technology that is going to be employed in casework.
So once you pass that initial testing, is there additional yearly or biannual proficiency testing done?
As a DNA analyst, I am required to do 2 proficiency tests per year. In my laboratory, the agency will purchase proficiency tests from a provider. I process them, generate my results, my answers, and those are then sent back to the provider to ensure that I'm getting the correct answers.
Are those done in-house in terms of the scoring and completion of that proficiency testing twice a year?
I process it in-house, it's reviewed, and then it's sent back to the provider.
Are does the proficiency test require and include statistical interpretations?
They do.
And has the statistical interpretations changed as the way they've been doing in the field of DNA over the last couple of years?
In my laboratory, yes. It went from statistical calculation with known as random match probabilities, single source samples, and CPIs, which were combined probability of inclusion. We've transitioned from those two methods to a likelihood ratio method.
And can you explain, in as simple of terms as possible, what is a likelihood ratio?
A likelihood ratio is a comparison of two hypotheses. Hypothesis 1 compared against hypothesis 2. In terms of casework analysis, the initial hypothesis is that a person is included as a contributor to a sample, and the competing hypothesis is that the evidence or the DNA profile is coming from an unrelated unknown individual. So that is how the likelihood ratio is set up. Person 1 or person of interest is the contributor to the evidence versus it's coming from an unknown unrelated individual.
Okay. So I want to go back, and so can you describe to the ladies and gentlemen of the jury, when you're doing a DNA analysis, what is it that you're looking for?
For the analysis that I'm doing, I am processing for STRs, or short-chain repeats. These are small fragments of DNA that are located in our DNA genome. They repeat a certain number of times. When I first began DNA casework, I was processing 15 STRs plus the amelogenic or sex-determining marker, and now the technology has gone to 24 STRs.
So when you say short chain of repeat or STRs, do they code for something like eye color or hair color?
These are non-coding fragments of DNA.
Why is it important to look at those areas as opposed to eye color?
The locations that we're testing, or that I'm testing for, the locations that I'm processing, they're robust. They're polymorphic, meaning that there are differences. There's not just 1 or 2 variations. There could be 10 to 12 different variations, and they are independent from each other, meaning that the result that I get at location 1 will not affect the result that I would get at location 2, or the DNA profile at location 1 isn't affected by the DNA profile of location 2.
Is that a genetic marker? Is that what you're talking about?
Yes.
And just so it's clear, can you define exactly what a genetic marker is from the DNA analyst perspective?
As it relates to what I do, it is the SCO, the shorthand. That is the specific DNA fragment or DNA marker that I'm processing and testing for.
Can you explain what an allele is?
The allele is the genetic trait or characteristic. In terms of STRs, as I mentioned, they're short fragments of DNA that repeat. So they're measured in numbers. At location, I'm just going to say location 1, an allele or characteristic gene may be a 7, or an 8, or a 9, or an 11. So the DNA profile that I generate is actually just a series of numbers based off of the alleles or traits that I obtain at each DNA location.
You said they're identified by numbers. What does that mean? Could you explain where the numbers, what you said? Is it 274? Is it 11?
As I mentioned, the 7, 8, or 9, that refers to the number of repeats. So with the STRs, it's a repeated fragment of DNA, ATCG, and that ATCG may repeat a certain number of times. It may repeat 7 times, or 8 times, or 9 times. And so that is what those numbers that I'm expressing represent.
And where does that repeat, how does that show up in a person's individual DNA?
It is located on the DNA chromosome.
And what determines what makes up an individual's DNA chromosome?
In the case of humans, our DNA is inherited from our parents. We receive half of our DNA from our mother and half from our father. And with the exception of identical twins, no 2 individuals are going to share the exact same DNA.
In terms of your casework and the DNA process that you do, has that been validated?
Yes.
Is the Broward Sheriff's Office Crime Lab accredited?
Yes.
And by what outside accredited body?
We're accredited by YNW, or the ANSI National Accreditation Board.
What's the purpose of maintaining an accreditation as a lab?
The accreditation is a voluntary process. The accrediting board will do an audit on our laboratory. It will check our SOPs or standard operating procedures to ensure that we are doing proper record keeping. We are following the procedures that we have in place, and that the laboratory is essentially running as it is supposed to be according to the SOPs.
And in terms of the specific areas in which the lab is accredited for, are you only talking on DNA?
It's accredited in 4 different sections: DNA, firearms, chemistry, and fingerprints.
Have you worked in any of those other sections?
I have not.
In terms of the proficiency testing that we talked about earlier, is that also part of the accreditation process?
Yes, everything that is done in the laboratory will be audited through the accrediting body.
And is there also accreditation and validation in terms of statistics that are used?
Again, it's part of the audit.
You mentioned that you used to do 15 areas plus Amylogen, and now you're at 24 areas. Can you explain what made that change occur?
The DNA analysis is a science, and as the years go on, the science advances. So the companies that provide these commercial kits are able to make combinations of these STRs in a bigger multiplex, that's what it's identified as, to analyze more DNA locations all at once in order to provide a better picture compared to years prior when it may have only been 9 locations.
With regards to the locations, does the software take into account the frequency and or the amount of number of times a particular repeat is found in the population?
I'm not sure of the question.
And previously, when you were doing random population, random map, or CPI, is it important to know how frequently a specific allele was shown up in a population of individuals?
Yes, at the end of the analysis, if I am, let me start over. After I look at the evidentiary samples, I'll determine if it's a single source profile or a mixture, and then do a comparison to a known standard. If I am going to report that the known standard is included as a contributor, I am required to give a weight to this. And in order to give a weight to this match or inclusion, I am required to provide a statistical calculation. So years prior, as I mentioned, it was RMP or CPI, we've gone to glycolates now. But all of those different calculations of those statistics are based on allele frequencies. And what that means is those STR markers that I mentioned before occur in the population at different frequencies. So I mentioned allele 8 may occur at a frequency of 25% of the population has it. And allele 7 may occur at 15%. So when I do a statistical calculation, with all of the alleles present in the DNA profile compared to the standard, all of those frequencies are used to calculate the end result, whether it's an LR, a CPI, or an RMP.
So when you change your method, you're still using a lot of the same and building on the same items that you used in the past?
Yes, that's right.
Has the likelihood ratio, LR, been validated for statistical analysis?
Yes, it is.
Can you tell the ladies and gentlemen of the jury about how in the lab you prevent any sort of cross-contamination?
When I process evidence, I am processing one case at a time, and when I refer to that, I screen the evidence. So the initial step is to look at the evidence that I am receiving from our central evidence supply to ensure that the seals were intact. I'll do an inventory of the evidence compared to the submission form and proper receipts. Typically, the items are packaged all together, kind of like a big brown bag. I'll open that bag up and do an inventory. And then again, process one evidentiary sample at a time while leaving the other samples in a drawer of our cabinets.
What do you do in between each sample to your workstation?
And the workstation is cleaned with bleach and alcohol. As I'm doing my screening, I do wear lab coats, gloves. I work in what's called a dead air box, a big plexiglass box about the size of this bench here. And I do all my processing on the bench. I'll clean that up after I'm done with the evidence, change my gloves, and then move on to the next piece of evidence. When the next step will be extraction, which would be after I've taken my sample and my cutting of this evidence, I place it into a tube and try and dilute out or purify any DNA present that's on that sample. At that point, I'm working little test tubes. So I would again be changing gloves, wearing a lab coat, a mask, and I would only be working with one sample at a time, or only open at one sample at a time to avoid sample contamination.
In terms of, you mentioned the test tubes, are those sealed?
Yes.
So you talked about how you get evidence and it's brought to you. Does the lab assign a specific case number at the lab to track all items of evidence and samples?
Yes, when the investigator brings the evidence to the evidence window or the central receiving, there's a property receipt in the submission form that's brought in, accepted by the evidence intake unit, and is given a laboratory number.
When you receive evidence, you mentioned you check the seals. Why do you do that?
I checked the seals. It's an indication if the evidence has been tampered with. There is a chain of custody form, a property receipt, and it lists who had custody of the evidence, and then from basically from which person to which person it gets transferred to.
And where is the evidence stored before you go and retrieve it?
For the most times, it is stored in the evidence vault. There's some cases where the evidence intake unit keeps it up front in their area, in the safe, but the majority of times they have an evidence vault in which I go to retrieve the evidence.
So we talked a lot about DNA and kind of the process leading up to that. What about serology? Is that a part of your job as well?
Serology is one of the first steps that I do when screening the evidence. With each case that's submitted, there's an evidence submission form. It gives me an idea of the type of evidence that I'm going to be processing. Sexual assaults. Years prior, I would screen for semen, looking for sperm cells. Maybe the case has indications of blood, at which point I would do presumptive testing for blood. Items of evidence are submitted where the investigator is just looking for what's essentially called contact DNA, where an individual had come into contact with maybe an item left at the scene. There's no real serology to do on that one, but I would just take cuttings of the samples.
So, Mr. Rhodes, I want to make sure it's clear. Is it your job to go out and collect DNA evidence?
No, I do not do any collection. The evidence is submitted and I retrieve it from the evidence form.
Do you give any advice on where to collect?
I do not.
Have you ever been any training in crime scene or evidence collection?
I have.
In terms of your employment at the sheriff's office, have you ever worked outside of the forensic DNA section?
I have not.
How many times approximately have you done the DNA analysis process we're going to talk about?
I was processing about 100 cases per year. I would say roughly 2 to 3 samples per case, so maybe 200 samples per year for a good 10 years. So thousands of samples in processing.
And in that time, have you had the opportunity to testify in court?
I've testified in Broward County about 40 times and in the federal district 3 times.
Karen, offer to defense for what that?
No need, no objection. Proceed, yes.
Okay, so I want to start with, in this particular case, did you do DNA analysis?
I did.
Could you please describe for the ladies and gentlemen of the jury the step-by-step process you go through? You started talking a little bit about extraction. You could pick up there and continue.
So again, the first step would be a screening of the evidence to collect my samples, which I would then put in 2 small, essentially test tubes, little microcentrifuge tubes. I would add reagents or chemicals to the tube in order to elute out any potential DNA that's present on the sample and to purify any DNA that may be present in that cutter.
Should we approach for just one moment?
Yes.
All right, Taylor Gang, it's 3:30. Our stream has been going for about 6 hours. Given the hour break that we had in the meantime, in between time, so I can pick up my kids. But we're gonna wrap it up for today. Make sure that if you're watching from from X or Twitter, that you come over to YouTube and like and subscribe to my channel. If you are watching from YouTube and you haven't hit the like button or subscribe, make sure you do that as well. I hope you guys have a good and happy Friday, and we will pick back up next week. See you guys on Monday.